Diary. Yesterday we went through the landscape evidence. Today I'm doing planning, starting with Mr. Stroud from the Council. When you're ready, Mr.
Good morning, sir.
Thank you.
Thank you for that. Just to let you know, I think the parties are content for you to have a copy of the SIL compliance statement. I think you may already, one's been winging its way to you through your case officer. Obviously, if it's more convenient for us to get you a hard copy this morning, we can do that in case the emails haven't reached you, but it's on its way to you. And I think the plan is on that to, subject to your views, to make it clear to those that want to attend from either the county or otherwise that we perhaps do that tomorrow morning, sort of make a marker for that so people don't come today thinking they might do it, if that's okay with you.
Yeah, absolutely. That's great. So thank you. The only thing I'd note, when you, I don't know whether you looked at it yet, but when you see the SIL compliance statement from the council, it does touch upon things that are county matters, but quite lightly, I think. And we don't know at the moment, I think any of us, whether the county intends to put anything further in specifically about the matters to do with education and health, well, education in particular, that we have been discussing and agreeing recently. So we just don't know at the moment. So there may, not from us, but there may from the county be something further, I don't know.
We've indicated to the county, and we'll do so again today, that tomorrow morning will be the time to come along. And I think that, I mean, I can do no more, but that's what we'll do that. So it's in their hands, I think, after that. Thank you, sir. Mr. Stroud, you're set up. Sorry, Mr. Begland.
So just before Mr. Cosgrove gets started, one matter of housekeeping from us. You recall yesterday that you were kind enough to allow us to put in documentation relating to the LNRS in relation to mapping. So we've got that. I also have two other documents that I'd invite you to look at. I've circulated them, shown them to my learned friends. The first is the illustrative master plan in relation to the Organ Hall farm development, just to give a slightly better appreciation of what was being proposed there. And then lastly, there's been discussion about the felling licences and what is available online on the Forestry Commission map browser is the map showing where there are conditional felling licences, both relating to after May 2018 and indeed before May 2018. I'm not sure that those instructing me have been able to access publicly what the conditions are for any one of those individual licences. So one has to read the document to see what assistance you can get from it, knowing that there is that gap in the evidence. But nevertheless, we say that it's of some assistance in terms of indicating the nature and extent of the felling licences immediately adjacent to the site. So I'd invite you to accept those three documents.
So just to be clear, the illustrative master plan, reserved matters.
Yes, we're just checking it's the, I'm not complaining, but it's just slightly too small to see it. There has been a reserved matters application, so either this is it or this is slightly out of date, if you like.
Yeah. Yes, my understanding is that this is the illustrative master plan, but that the differences between this and the reserved matters plan are not significant for the purposes that we are discussing.
Okay, fine, thank you. And then the other plans you're submitting essentially in lieu of the web link that was available in the series. So we've got static copies
Indeed.
of those.
Yes,
yes, that's this one here. So the zoom in on the the bit around the site itself.
Okay. Thank you.
On the other one, so, which is this. We're not particularly happy with you receiving this immediately, so we've just seen it. So sorry, Mr. Clapper, I do beg your pardon. Because as Mr. Begland says, it gives a certain impression which we think is highly misleading. So one needs to understand what these conditions and periods and percentages are, because, for instance, those hatched areas, when you read the licence, have only a small percentage of those within the conditions able to be felled under the licence conditions. So it looks, when you look at it, as if there's a licence to fell the entirety of these areas, and that's not right. So until we give you either the whole licence or the rest of it, would you mind just holding up on this?
Are you intending to submit the whole licence with the conditions?
Well, we'll have to now. I've just seen this, so we weren't going to. But obviously, it's been a bit of a fringe issue, but we will now, if Mr. Begland wants to put this in, we'll have to go and have a look at what they say and come back to you.
In the interest of completeness, I think that's quite helpful to have that in the conditions.
Sir, absolutely, yes.
Okay, fine, I'm happy to wait on that. And I also recall you wanted to submit another plan in respect of the relationship of the biodiversity net gain along with the local nature recovery strategy as well. Is that included within these documents? Were we happy for that to be submitted as well?
We produced yesterday, so that we will now give to you. Liv's got it, hasn't she? Thank you. I knew I entrusted it to somebody trustworthy yesterday. Thank you, Mr. Crumb.
Someone, I don't know, are you keeping inquiry numbers on your side?
No, we haven't actually.
No reason why we should.
We'll at the break, so we'll just agree.
So we'll hand up, because I'm in the sort of intermediaries, we hand up the two apart from the... Yeah. Right, for Mr. Begler.
Thank you. Thank you, Mr. Cosgrove. Thank you.
Mr. Stroud, you ready to go? Thank you. Now, you're introduced by reference to your main proof. You're Stephen Andrew Stroud. You're a Chartered Town Planner, MRTPI. You've got an undergraduate honours degree in History and Law and a master's degree from the University of Oxford. You've held further degrees and qualifications as you've set out at section 1.1 of your proof. You've got extensive experience as you've set out further in section 1 of your proof, both in the private and public sector. You're currently an Associate Director at James Bailey Planning, is that right?
Yes, that's correct.
You work for national and regional house builders and promoters, private clients and the public sector. And prior to that, you were the Acting Chief Planning Officer for Baber and Mid Suffolk District Councils.
Yes.
Good, thank you. And you've got quite extensive experience as appearing as an expert witness. You've provided the standard declaration at 1.5 of your proof, and you have a summary of your evidence at 1.6. So I don't know, would it assist you to, at this stage, to have a list of documents, or are you happy just to... You like them, yes. So principally, so obviously Mr. Stroud's proof, Mr. Allen's proof, which is core document 6.7. The other core documents we're likely to look at, if I list them for you, 3.9, the MPPG, 5.8, 5.1. We might briefly look at My Learned Friend's opening, which I suspect is inquiry document 1. It's probably the first thing that was handed in. Possibly 6.1. The NPPF 3.6, sorry, this is not in particular numerical order, 2.6, which is Mr. Cannon's advice, table of benefits at 6.9, and the planning statement of common ground at 6.4. And I probably missed a few, but those are the principal ones we're going to be grappling with. Thank you. Right, so Mr. Stroud, just turning to section 2 of your evidence, the scope of your evidence, you're plainly, as you say, dealing with matters relating to planning policies and planning judgments. More specifically, what is the sort of scope of your evidence for this inquiry? So
I have dealt with main issue 3 in terms of looking at the policy context and then examining, let me get the main issues up, whether any very special circumstances exist. In order to undertake that exercise, what I've also done is carried out my own independent assessment in respect to the Greenbelt purposes A and B.
Yeah. Okay, thank you. Now, first little subtopic, just picking up on some of the evidence we've heard at the inquiry, I want to ask you about the sort of decision, the background to the decision by the council to refuse. And you remember that I think there were some questions and issues raised earlier on in the inquiry about the minutes. I don't think we need to turn them up. By all means do if you want to, but the point was made that the minutes from the planning committee don't actually identify landscape as an issue in terms. What do you say about that?
Well, it doesn't, but I don't think that that's a matter really that this appeal should turn on. Firstly, obviously landscape is referenced in the reason for refusal. The minutes also do record that there are no very special circumstances. Now that of itself imports a balance where you're going to have to consider the various harms that may be present, and of course that includes landscape. It was known to the committee members that there was landscape harm, and this was a matter that they needed to attach substantial weight to. That's in the officer report. And of course it's in the statement of case, which the council has set out as part of the inquiry process.
All right, thank you. Now, in terms of the previous inspector's decision, which the inspector's already heard quite a lot about, called document 5.1, in relation to that, in terms of how one should approach that in your view in the overall planning judgment, can I just ask you first of all to take up the planning statement of common ground, 6.4, core document 6.4, and within that, if we could go to paragraph 211, which is on the 4th page of that document in hard copy.
Yes, just 1 second.
Yeah.
What paragraph?
2.11, so it's under the subsection relevant planning history.
Yeah.
And it sets out the background and the refusal. And 2.11 refers to the dismissal by Inspector Fagan on the 26th of January 2024 and the basis for it. And then it says the decision constitutes a material consideration of this appeal. It is important to note that since this appeal decision has been a material change in national planning policy through the introduction of the grey belt concept. Now, we're going to come on and look at in more detail the grey belt concept with you in a moment, but just at the outset of your evidence, how do you invite the inspector to overall treat and approach the decision as a material consideration as set out in the Statement of Common Ground?
Well, I think it's a highly material consideration. I think, save for the introduction of the grey belt concept, there has been no material change in circumstances really in terms of the broader policy context or the nature of this scheme, such that I think that in respect of the issue relating to grey belt, I think if you were to find that this site is not grey belt, then I think ultimately you have a blueprint for a decision that would ultimately tread the same path as Inspector Fagan.
Thank you. Thank you. Right. Good. And in terms, again, while we've got the Statement of Common Ground open, there's a lot of agreement in section 4 of that document under agreed matters, really from 4.1 onwards, but particularly as one reads through that, as the inspector will, there's lots of agreed matters as to how one, as it were, should structurally approach the MPPF and the various paragraphs in it dealing with Greenbelt and very special circumstances, at least as between the council and the appellant. Where do we get to? What are the key issues? I mean, there are 2 development plan policies mentioned in the reason for refusal, which you referred to. To what extent are they, in a sense, subsumed by the MPPF in terms of their date and relevance?
So I think they are. There's no allegation that they're out of date in the sense of being consistent with the framework. I mean, ultimately, policy CS13 directs you to apply the policies of the MPPF. So that's really the lens through which I think you can take a decision on this appeal, much as Inspector Fagan did. Obviously, that was a decision where, of course, there was no reference to any landscape policy either. Ultimately, landscape harm was recognised, but it was taken into account as part of the grey belt VSC test.
Yeah, and so far as green belt, grey belt issues are concerned, I think you've set out in your proof, and it's also in the Statement of Common Ground, one effectively comes down to purposes A and B and whether there's a strong contribution to answer that initial question. Is that right?
Yes, that's right. I think ultimately that's the question where if that's in the negative, that this site is not grey belt, then I think ultimately this becomes very similar to the previous appeal, where of course consistency in decision taking is a matter of public interest, where there should be confidence that planning decisions should be reliable and predictable.
And again, while we've got the Statement of Common Ground open in section 4, you will see at 4.10 through to 4.12, there's a number of paragraphs addressing the Arup Stage 1 and Stage 2 assessments, which again the inspectors heard evidence about from the landscape witnesses. And again, we will come back to this when we look at the purposes, but the contention has, I think, now been put by the appellant that when you look at the criteria that Arup were looking at in relation to the purposes, they're basically the same as the illustrative features that one should look at when one's coming to a view in relation to grey belt. Mm-hmm. So what's your view on that proposition, please?
Oh, well, I disagree, frankly. I think they're different questions that the authors of the Arup report were considering. Obviously, it predates the PPG. It didn't undertake what clearly I think is signposted in the PPG as being a more textured judgment, looking for illustrative features that will enable you to come to a view.
Good. All right. Thank you. That's just by way of introduction. Can we then turn to the issue of grey belt / green belt, please? And you tell us you conducted your own assessment. I don't want to necessarily repeat matters, but I want, just by way of approach, us to give you your planning judgment, because I think it's agreed between the parties that the assessment as to whether something is a grey belt is a planning judgment rather than a judgment of law or a matter of law.
Yes.
So in terms of approach to, before we get to the particulars of this case, could you give us your view as to how one should approach that by reference to, if it assists, call document 3.9, which we have, which has the MPPG relevant excerpts and so forth?
Yes, so I think in reference to the PPG, it's not setting out any particularly mandatory or rigid framework. It is, well, it's as it says at the top, they are considerations for informing judgments, they are illustrative features. And I think that has obviously been upheld by the Secretary of State himself in the Marlowe decision, which I think was CD 5.9 or 5.6.
Or 5.6.
5.6, yeah. Where ultimately he himself undertakes what I would consider a sort of a broader holistic judgment, considering the various factors that are relevant and having regard to the PPG.
So Ms. Brockhurst confirmed yesterday that she was providing the principal assessment for the appellant on these issues, and I put to her certain matters of approach. I don't think there was much between us, but so far as you're concerned, when the inspector looks at the tables and the NPPG, how do you invite him to approach what are characterised as considerations for informing judgment set out in the various sections? Are they exclusive? Do they prohibit other things, for example, or not?
No, they're not exclusive. It's a non-exhaustive list. They're sort of they're points to consider to enable you to think about the issue. I think, as Ms. Backer's evidence shows, and indeed as I have thought about in undertaking my own assessment, elements of landscape character and settlement character can be very important in undertaking that assessment. I think, with reference to Ms. Brockhurst's evidence, I think she accepted that was quite reasonable. Yes,
she accepted Ms. Backer's approach was reasonable. She didn't agree with it, of course.
No.
The Marlowe decision, which, to be fair, I think Ms. Brockhurst wasn't overly familiar with, no criticism of her. Well, she wasn't overly familiar with it. But your view, Marlowe, you refer that in your evidence. Obviously, the facts of each case aren't necessarily going to assist, but in terms of approach, what do you say that does, that might assist this inspector or might not?
that the illustrative features in the PPG are not a fixed list, and that you can, of course, there may be a feature which would, on reading of the PPG, not be indicative of a strong contribution to the purpose, but nevertheless that wouldn't preclude you from finding that an area or site in question is performing strongly against that purpose. With reference to the Marlowe decision at CD 5.6, I think it's paragraph 44, the Secretary of State refers to the presence of clear physical boundaries to the site, which includes 2 A roads, and ultimately still concludes that that site is making a strong contribution under Purpose A.
We don't need to look at it again, but it's for the inspector's note. There was an aerial view of the red line of the site on PDF 37, which we looked at. You've seen that.
Yes.
And it's a interesting shaped site. It's got lots of bits and parts. I remember plot 4, for example, is
entirely enclosed.
But in terms of the site we're faced with this inquiry and the features that might be said to restrict or enclose the woodland and the developments, just as a comparator, do you see anything that the inspector might take from that Marlowe case that he might think is indicative of how he should approach this case or not?
Well, yes, in this case, I think much has been made of the presence of woodland as being a feature that might restrict or contain development. I think if that were the case, then clearly on the Marlowe approach, which is the Secretary of State, this is his policy, it doesn't preclude you from finding that the site is making a strong contribution. What's more, when you look at the illustrative features within the PPG at CD 3.9, it does make the point that when considering whether a site is making a moderate contribution, you're looking for one or more features that weaken their contribution to this purpose. So I think in this case, even whilst of course I don't deny the presence of the woodland, I think having regard to the role that it plays in understanding the landscape and settlement character, I don't think it actually weakens the contribution of this site in making a strong contribution to Purpose A.
Yeah.
And I think that qualification in the PPG is quite important.
Thank you. Now, can we... one tour document I didn't give on the list, but I just wanted you to look at is CD 4.5, because that's, I think, was looked at in evidence yesterday. That's from the Stage 2 ARUP assessment. And I think, get the correct reference, I think it was page hard copy 15, PDF 19.
Oh, so is this which 4.5?
Core document.
There's
Absolutely right. It's the assessment one.
The assessment one, yeah. Not the annex report.
No, okay. I don't think so. I sort of went 50-50 and got lucky. I got to the page, was to say. But he should have page 15. There's hard copy page 15. It's large table 3.3, large built-up areas used for Purpose 1 assessment, and then you see it says the assessment considered, and then there are 3 matters. One, whether the greenbelt sub-area falls at the edge of one or more distinct...
Yeah.
Do you have that?
Yeah.
So do you have that? Yes, thank you. So I think it was put yesterday, proposition was, well, when you look at the criteria that ARUP were looking at in their greenbelt studies, basically the same as the kind of criteria the inspector will now see in the February 2025 guidance, the same illustrative features. Mm-hmm. So I asked you to say, now we've got it in front of us, what do you want to say about that proposition?
Well, they're not the same. This appears to be a much more rigid and focused approach rather than the more textured judgment that the PPG would indicate that you undertake.
Yes.
And of course, this assessment discounted the site on the basis of it not being a built-up area.
And do you remember, so far, at least as far as Purpose B is concerned, slightly different from that point, Ms. Brockhurst accepted that the kind of matters that the inspector of the Lancaster decision was looking at, perception that went well beyond the matters listed even in Purpose B in the MPPG guidance, were matters that she felt you could properly consider. Are those kind of matters covered in any of the ARUP guidance, either here or elsewhere, so far as you're aware?
No, and with reference to the Lancaster appeal, I make reference to that in my proof at paragraph 513. There's a particular extract from the appeal decision that I cite, and also in relation to the inspector's approach, stating that just merely an assessment of the size of the gap is only part of the picture.
I put to Ms Brockhurst yesterday that when she had the opportunity to read the full inspector's report in relation to the Marlow case, she would see that there was a history of Arup doing a stage 1 and stage 2 assessment there and finding that the sites in their view didn't make a strong contribution, made a very weak or no contribution to the Greenbelt purpose and nevertheless the Secretary of State, as we know, found a strong contribution. What is, as far as the history of this case, Inspector Fagan, obviously not looking at Greybelt, but did, I think, refer to the Arup assessments because they were prayed in aid last time.
Yes.
Did he find them of assistance or not for the task he was addressing? And if you need a reference, CD 5.1, para 29 of his decision.
Yeah.
So what was his view? Did he find any assistance?
Oh, sorry. Sorry, I missed that. I thought you were asking to turn it up. Well, he disagreed with Arup's position. He says that they carried out a wider strategic assessment, not the stricter VSC test. Whilst their conclusion and material, they're not determinative.
In fact, I mean, when you actually look at the inspector has time again to look at the stage 2 assessment in 4.5 in relation to an area which is broadly equivalent to this site, which is RA8, SA75. Did it actually consider, I think it took the view that it was a village, it wasn't a large built-up area.
Yes.
So did it actually go on and consider any criteria, let alone...
Under purpose A, no.
No, okay. All right, thank you. Good, thank you very much. Now, the other point that there is a document that the appellants rely on, which is the CSA assessment, which I looked at briefly with was Backer from July 2024. I don't think we need to turn that up, unless you particularly want to. It's in one of the core documents. Do you know the one I'm referring to? Perhaps we'll just skip the...
Yes.
1.25, CD1, just for the inspector's note, but that, again, I turn to it if you want to, but that was an assessment undertaken in July of 2024, which was produced with the application to provide a view on what, how the site contributed to the purposes, and from memory, insofar as A and B are concerned, it concluded a weak or no contribution, or very weak contribution to those purposes. That's right?
That's what I recall that,
Ms.
yes.
Backer said she didn't, put it politely, didn't think much of it and didn't agree with it. I mean, out of interest, what criteria did they appear to have used to assess purposes? The Arup or any other criteria?
Well, it's pre-PPG, so yes, it doesn't undertake the current approach.
Yeah. Do those findings accord actually with the findings either from Mr. Allen in his evidence as to the contribution to the purposes?
No, clearly Mr. Allen disagreed with the CSA assessment because he finds a moderate contribution.
Yeah. Okay. Thank you. Right. So can we just turn to the specifics of this site with those matters of approach in mind? And so far as Purpose A is concerned, your assessment on whether the site makes a strong contribution or any other contribution, what do you say to the inspector about that? What's your analysis? You've set it out in your proof, but is there anything you want to add in light of what you've heard and what people have said, really? That's the point.
Yes, well, I think as I set out in my proof, I think that the site does perform strongly against Purpose A, just in terms of illustrative features in the PPG. It's free of existing it's free of existing development. It's obviously immediately adjacent to the large built-up area, and it's performing a role where I think it is keeping development and the settlement edge in check. I think that settlement edge is relatively robust. It's clearly verdant. When you look at the topography of the site as well, I think there is clearly a pattern of development where the settlement is ending and the countryside is beginning. I think there was a point made yesterday by Miss Brockhurst that she didn't feel that standing in the site you get the sense that you're in the countryside. I mean, I would disagree with that. I think when you do stand on the site, I think that you certainly don't get the impression that you are within or indeed immediately adjacent to a built-up area.
Yes.
And that's something, obviously, sir, you will have made a judgment on when you were on site. And I think that helps the site understanding the landscape character in the way that it performs a role in checking development and sprawl. And in terms of the pattern of development, I don't consider that this is a scheme that would be congruous. I make the point in my proof that having regard to the existing pattern of development, it is clearly already squared off. You know, this is a site that's having to take a new access from Shenley Hill. It is an adjunct to the existing settlement edge. I don't think that it is. And that's reflective of the fact that the site is playing a role where it is keeping the existing settlement in check.
Yes, so two points arising of approach, particularly focused on arising from Ms. Brockhurst's evidence yesterday. One is this, put to her some propositions about whether her approach whether she considered the approach to take account the specifics of the development before a decision maker when deciding whether land is grey, or whether one should put that aside and deal with it in terms of the site. Mm-hmm. And she came down on what was the site rather than development. Yeah, do you recall that?
Yes.
Fair enough. Now, obviously, there'll be submissions in due course about her evidence, because I also asked if some of her evidence seemed to rely on the site specifics, but that was her position. All right. What's your position on that approach? How should the inspector approach this matter? Should he look at the particular nature of what's proposed, albeit in an outline but in an illustrative master plan, in considering issues of sprawl, or should he do it as more of a land site-based exercise?
So I've approached it looking at the site and the role that the site plays. I think clearly you've got to be mindful of the nature of the development coming forward, of course. But the way that I've approached it is to look at the role that the actual site is playing in fulfilling purposes A or B.
And the other point, I was putting to some points about the role of the site and suggesting that the fundamental difference between us, which we'd established at the outset about whether the site was perhaps countryside or more had an urbanised influence, that sort of debate, and I'm suggesting that was a thread through the evidence, and I put that to her as one of the things that might have led her to form a different judgment on this issue, and she said, well, no, this is not a landscape character issue, this is a different point. You see that? Remember that? Yeah. Now, if you just look at Mr. Allen's proof, where he touches on this issue of purpose A, so if you could take his proof of evidence, please, up and go to his section 6 policy assessment. Page 21 in hard copy, section 6.
Yes.
And sir, are you there, sir? And within that, we drop down to 6.5 and 6.6, where he's addressing particularly purpose A. And just one point, I mean, obviously we'll ask him in due course, but he says at 6.6 that the site is bounded by Shenley Road, hill to the north, woodland to the east, south with Theobald Street and so forth. These existing features will clearly have the effect of enclosing and containing the development site. Furthermore, the existing built-up boundary of Radlett forms the western boundary, which together with the presence of Newbury's primary school have an urbanising influence across the site. But to what extent do you think he's taking into character issues in his take on policy, or not?
It doesn't seem to me that he has, and I think that as Miss Brockhurst agreed was a reasonable approach, I think it is relevant to look at landscape features and character and how that might influence and contribute to the purposes. Yeah.
Well, you say he hasn't, but he said he's looking at the urbanising influence of Newbury's primary schools. So has he taken those matters into account or not? 6.6.
Oh, sorry, at the end of the paragraph. Yes, absolutely. Yes, he has. Yeah, which is slightly contradicts what we heard yesterday. Yes.
Good, thank you. Other matters on purpose A you want to raise, or is that rest of it's in your proof?
Yeah, I think so, yeah.
Good. Purpose B, and again, we heard evidence from Ms Backer and Ms Brockhurst on this, and Ms Brockhurst accepted that Ms Backer's approach, she didn't agree with it, but it was the factors were reasonable judgments and so forth to make, yes?
Yes.
Is that your view as well? Was Ms Backer's a reasonable judgment to take?
Yes,
Do you agree
yes.
with Ms Brockhurst on that?
Yeah.
Now, you've taken your own view, of course,
Yes.
perhaps slightly different from Ms Backer, I don't know. How do you approach Purpose B and your analysis of it?
So again, on the same general principle that obviously I'm starting with the PPG, I'm looking at illustrative features and coming to a view. Again, it's a site free of existing development. In my view, I think, and bearing in mind what I think is a relatively small gap between towns, I think personally 200 to 300 metres or 300 metres in certain areas, I think that actually does contribute a substantial part of that gap. And one of the reasons I say that as well is because you've got to look at the direction that the site, or the location of the site and the direction that development would be moving into. I mean, to take Mr Fagan's reference of the bow wave, that bow wave is directly facing into and moving towards Boreham Wood. So I think on that basis, I think it is a substantial part.
Yeah.
And obviously there would be visual elements of this site from Shenley Hill. You would recognise that the development is moving down and towards Boreham Wood and you know, moving towards and merging the two.
Yes, and so, you know, bearing in mind the words of the purpose to prevent neighbouring towns merging, and my learned friend, one of them, perhaps both of them, I can't remember, made great, you know, emphasised the word merging and asked someone what merging meant. I mean, bearing in mind that wording, you still have the view that it's a strong contribution in relation to that purpose?
Yes, I mean, it's not making the point that the two towns have actually got to touch one another.
No.
I mean, the purpose is that you're trying to prevent that from happening, even whether that's through incremental development. And with reference to the Lancaster decision, earlier I referenced my 513. The inspector says, to my mind, a limited approach such as that would likely result in the constant promotion of small-scale changes.
Yeah. And it said, well, it may be said, it's certainly been said in the opening, that, well, Inspector Fagan, when he turned his mind to the purposes, didn't find a strong contribution to Purpose LB, but I think found a moderate contribution from memory, but he certainly didn't find a strong contribution. What do you say about that? I mean, maybe we've asked some earlier questions about approach, but what do you say about that?
Well, again, Inspector Fagan's decision was pre-PPG. I think there are, given some of the things that the inspector says and the way they approached it, I don't think it's unrealistic to say that he would, if faced with the PPG now, when the grey belt test, find that there was a strong contribution in respect of A or B or both.
Yes. Thank you. Right. Just want to go back on, move away from the specific, the site, and just look at the way the appellants now put their case at this inquiry. Could you take up the appellant's opening, which I think is inquiry document 1,
Yes.
please? And within that, we're going to go to main issue 1, which begins at paragraph 8, Greenbelt. And at 11, it is said there is a national objective to assess and identify grey-belt sites, and that obviously is right from December 2024, and from February we have the illustrative features. I mean, incidentally, in terms of the state of play, in terms of the local plan at the moment, I mean, there isn't a local plan. I think we're waiting for a Regulation 18 to be published.
I think they're
is that
going
right?
through an evidence gathering process, yes.
But in terms of what would be required for any local authority producing a process, a plan in terms of assessments of grey belt and green belt and so forth, what would need to be done as part of the evidence base?
Well, you'd need to do it. You'd have to undertake a fresh assessment with the new planning practice guidance in mind.
Does that exist at the moment?
I don't believe so. No.
So the former evidence base, which we have, no doubt material and can be looked at with all the caveats you've said, but does it actually, in your view, address, so far as this issue is concerned, the modern?
No, I don't think it assists, no.
And was any local authority you're aware of relying on previous assessments from criteria some years ago on Greenbelt to produce new local plans?
No.
No, all right. Okay, now looking at paragraph 11 of my learned friend's opening, referring to the PPG, it said there's pre-existing evidence unambiguously clear that the site does not perform strongly. I just want to look at these bits of, quote, evidence. The first one is the Greenbelt assessments, I think, which we've grappled with. Those are the ARUP assessments. I think that's right. And it said, well, it's common ground that this evidence remains a material planning consideration. What do you say about that?
Well, it is material in the sense that actually it's pre-PPG, so it supports the point that we're making. It's material in that respect.
Yeah. It said which allocated the site. I mean, Inspector, I think it's set out, I can't remember if it's the Rule 6 evidence or somewhere, it's right that the site was allocated and that plan went away.
Yeah.
There was another regulation 18, was there, more recently?
Yes, that's right. I think it's in the core documents, actually.
Right. Was that in 2024, I think?
2024, I think that's CD 3.4, yes.
Yeah. And did that regulation 18, on the basis of the evidence before it allocate the site again?
No, it doesn't, no.
Right.
Just bear with me.
I'm sure it isn't, though.
I think, have you got that, sir?
Which core document?
3.4,
3.4.
I think that's the 2024.
Yeah, 2024, regulate, yeah.
I think
just as a matter of fact, Radlett, there were some allocations made, I think.
Yes, I'm fairly sure I've seen there's a plan, there's sort of a plan of indicative allocations.
Yeah. Okay,
yes, it's PDF 60. Yes.
It can be checked if there's an issue whether the site was in fact allocated the last local plan or not. I think you're saying it wasn't.
No, it doesn't feature, no.
And then we have the MPPF 2024 comes out, new grey belt, that's stopped because new evidence base.
Yes, that's my understanding.
That's where we are, so we're waiting for the next.
Yes.
Yeah. Okay. Second point, Ryden, it said there's the site-specific assessment by Inspector Fagan. He found the development would only have moderate A and B. Again, you've dealt with that already.
Yes, yeah, pre-PPG.
Third, it said there's the evidence of CSA environmental. That's the document we looked at. I mean, is that even agreed with now by Mr. Allen as an assessment?
No, Mr. Allen obviously rejects their judgment.
Ms. Backer doesn't agree with it. You don't agree with it?
No.
Does it address the test for grey belt?
And that's also pre-PPG,
right.
Yeah.
Then it's the own officers' assessment. Planning officers, they formed a view that it didn't perform strongly. They're entitled to do that?
They're entitled to do that, much as obviously a planning committee is entitled to reject that recommendation and judgment. Obviously, having regard to the evidence before them, obviously they were aware of the PPG factors and illustrative features, and of course the various objections making the point that this was a site that was not grey belt.
All right. So I keep saying my mantra is not a numbers game. Although if it were a numbers game, maybe it should be a numbers game. So we'd be in business at this stage. But what evidence has the inspector got before him now, independent expert evidence, in terms of whether the site performs strongly on A and B of this inquiry as you see it?
Well, first, I mean, there is clear evidence that, from two parties that this is not grey belt. I mean, there are 4 witnesses that have covered the point.
And yes, in relation to Ms. Brockhurst's evidence on whether Ms. Backer, well, she hadn't heard you, obviously, she'd read your evidence, was entitled to reach that view on a reasonable basis. What did you understand that to be?
Yes, I think whilst Ms. Brockhurst disagreed, I think she thought that there was nothing unreasonable about Ms. Backer's approach.
Okay, thank you. And in fact, in light of our discussions about approach to character and approach to the site as opposed to the specifics of a development, how reasonable do you think actually the evidence so far is of the appellant in terms of purpose A or purpose B? How do you assess that as a body of evidence before this inquiry?
Well, I think there have been aspects of it that have been unclear to me, whether the PPG has been, for example, with Ms. Brockhurst, following those illustrative features, considering the decision taken by the Secretary of State in Marlow, being clear that it is a textured judgment, and that there may be some features that would indicate a weaker contribution, but nevertheless there can still be a strong contribution overall. I think the evidence certainly of Miss Backer and myself is one that has taken that broader and more textured approach.
Yeah. And then fifth point refers to the independent legal advice from a barrister representing the council, Mr. Cannon, his advice, CD 26. Core document 2.6 might be worth just turning that up, just to get your view on this. again, what do you say about that as an item before the inspector?
Well, I mean, it's a legal opinion, not a planning judgment as to whether the site is grey belt or not. I think it's also, being a legal opinion, it's carefully caveated, recognising that it's being given on the evidence available, and that, of course, if the council is to make a reasonable case, then it needs to have evidence of its own to substantiate its position.
Yeah. Mr. Cannon, as far as you're aware, had the benefit of seeing any of the 4 independent expert assessments now before this inquiry?
No.
The other 2 earlier advisors before, in evidence before this inspector, had either of the auditors that seen the evidence now available?
No, the same local, yeah.
All right, thank you very much. I think those are the only bits relied on. Appellant. Good. Anything else you want to say about purposes LB? Or should we move on to the next topic?
Yep.
Good, thank you. Landscape. Now you've heard the evidence. That's not your function to make findings on effects. You're taking what you've heard on the evidence for you. What, in your balance, in your evidence, in your planning assessment, what weight do you give the landscape matters, landscape and visual matters that you've heard evidence about in this inquiry?
I've afforded substantial weight to that harm, consistent with Inspector Fagan and the officers of the council in making their recommendation.
And I remember I had a little debate with Ms Brockhurst yesterday about what appeared to be her position was, although she found some substantial and moderate adverse effects in various ways, particularly in relation to landscape character, she then concluded that the effects were not significant.
Yeah.
And I put to her various paragraphs. What's your, and then so she, in a sense, I put to her, she passed the baton on to Mr. Allen with that conclusion. What's your view on that as an approach to, and does it accord with any other planning decision maker you've seen? Any other sort of passing the baton on approach from the inspector, from the council officers, from anyone?
To be frank, I was slightly confused, and I think that's probably an unsafe approach. The idea that you would use potential future benefits to discount a harm to then ultimately reach a view that a scheme is not harmful, only to then, as you say, pass the baton on, and for the planning witness in undertaking their balance to then count those same benefits again. I think that significantly risks double counting effectively.
So Mr. Allen in his proof gives the landscape harm limited weight.
Yes.
Has any other planner, by which I mean the council officers, when they came to assess that in their sort of alternative very special circumstances exercise, which they did on the basis, someone might disagree with them on their take on the purposes, or indeed Inspector Fagan, has anyone else given that landscape harm limited weight in the balance?
No, quite properly. They've kept the two separate.
Yeah, all right. Okay. In terms of harm to the greenbelt, both policy harm, as it's called, or definitional harm, and then the actual harm to the openness, I don't think there's much between the witnesses, the landscape witnesses on that, or is there, as you understand it? MPPF 153 in mind, what weight should be given to such harm in your view?
Substantial.
And is that what you've done in your balance?
Yes. Yep.
View. And then the turning then in terms of the harms to undertake a very special circumstances balance on the basis one gets to that stage if the inspector's with the council that it's not grey belt and is green belt. We have a useful document, core document 6.9, perhaps you could turn that up, which is the agreed benefits of the proposed development table. I make it clear agreed between, well actually it sets out all 3 parties' positions. And just, so do you have that document to hand? Thank you. Now just to give it some context, you see it said at the top, the following scale is used, so helpfully you've all agreed a scale of how you assess it. And it said that this reflects the scale adopted by the inspector in the previous years, Mr. Peel. And again, it's right, isn't it? I think I can lead you on this with Inspector C's, Inspector Fagan's decision. He sets out the same scale, and that's why the three parties have chosen to use the same scale in this case.
Yes, I mean, it's sensible, isn't it? Consistency being important.
Okay, so what I want to do, and the other thing just to note as we go through these matters, is the inspector will see in the court documents 5.8, there was a High Court challenge, I think, to Inspector Fagan's decision, combined actually with another challenge in another case taken as one by Mr. Justice Holgate. And Inspector obviously read that in his own time, but there were some challenges to aspects of Inspector Fagan's weight to some of the matters.
Yes.
And you refer to this in your evidence in relation to some of the matters. Did any of the challenges succeed, or?
No, my understanding is that legal challenge failed, and that the inspector's approach to, certainly in respect of one of the discrete grounds, weighing the benefits was entirely legitimate.
That's the Fairfax Acquisitions case. Okay, thank you. Now, what I want to do is focus with you on where the differences lie between you and the appellant. I'll leave Mr. Beglan to deal with the Rule 6 party differences in due course, all right? And also, as we go along, so what I'll do is, having seen Mr. Allen's evidence now,
Yes.
you've set out in your proof under little headings why you say you give the weight you do, and you've also referenced at various stages for the inspector in your proof whether your assessment of weight accords with Inspector Fagan or not. Okay, so I don't want to repeat your evidence, but I want, in light of what Mr. Allen has said now, check whether there's anything you want to say. So looking on the table, the first difference is when you look at market housing together, you give that substantial. Mr. Allen gives that very substantial. The top of the pile, and then just to take them together in relation to affordable housing, you both give very substantial. So where's the difference? Why do you, as it were, give substantial rather than very substantial to the market element?
So several reasons. One, and just simply as a matter of numbers, there are fewer market homes now proposed in this scheme than previous, because of the fact there is an increase in affordable housing. Secondly, I recognise that there is a housing shortfall, and that it is a lower position in supply terms than it was previously. But reading Inspector Fagan's decision, I think he had that in mind. I don't think, when you read his decision fairly, that he thought the position was going to improve any time soon. And just simply, and then as a matter of numbers, trying to look at the extent of the benefit, I think substantial weight is a fair approach, entirely consistent with what Inspector Fagan found. And
just for the inspector's note, the agreed housing land supply positions at 4.3 of the Statement of Common Ground, 0.98 years supply.
Yes,
so it's lower than it was before
Yes.
Inspector Fagan by a margin. Yeah. Okay. Thank you. And affordable housing, you give full weight. Safeguarded land for the expansion of Newbury's primary school. This appears to be one of the bigger differences between the two of you, because you're giving it only limited, and Mr. Allen is giving it significant, so third down the rung. So he's two notches up from you.
Yes.
Why do you think there's that difference, and why should the inspector go with you rather than Mr. Allen?
Well, I've considered, in light of the proof of evidence, I have considered Mr. Allen's evidence. Informing my view, I also had regard to the officer report and, of course, Mr. Fagan's decision. I don't think that anything has fundamentally changed that would warrant an increased provision. I note that there is a preference for this site for the expansion of the school, but of course part of the reason and the need for it is as a result of this development. And I note, in respect of the Section 106, there is a cascade provision. I don't think there is it's not a foregone conclusion that the land will be required, and therefore I think it's appropriate to continue to give limited weight. I think what I would say, recognising the difference between myself and Mr. Allen, is, as I set out in my proof and with reference to Mr. Fagan's decision, he had, in exercising his balance, noted that if there were some leeway, even if he had given significant weight to other benefits, it still wouldn't affect the outcome of his balance overall.
Yeah. Okay, thank you. The next item of difference between you in relation to BNG.
Yes.
You give it limited, the appellant gives it moderate. What do you say about that in terms of the difference and the reasons for the difference?
So I give limited weight, consistent with Inspector Fagan. It is a benefit, of course, but I think contextualised, I think 20% BNG, it's a limited uplift, it's a limited provision, and therefore I give limited weight on that basis. I mean, I've seen a huge number of schemes where much greater net gains are proposed. So ultimately, I think you've got to contextualise and you've got to calibrate your compass one way or the other, and I think this is a limited gain.
That was one of the judgments that was sought to be challenged. Inspector Fagan's judgment in the High Court. That's my understanding, yes. The High Court did not think that was a good point of challenge.
It didn't succeed.
Right, okay. The next issue between you, I think, economic and social benefits, please. Where do we lie there?
Yes, having read Inspector Fagan's decision, again, I think it's prudent to take a consistent approach. I agree and think his approach is reasonable. So for the reasons set out at 543 of my proof, I give that limited weight too.
Thank you. I think the final difference between you on the table is connectivity benefits,
yes.
Limited versus very limited. Is that right?
That's correct, yes.
Again, so far as that's particularly helpful, what's the difference?
I'm sticking with Inspector Fagan. I think it is very limited weight. I recognise it's a benefit because, feasibly there might be some wider utility, but ultimately it's a necessary component of this development.
So, actually, as it happens, when you've formed your own assessment, have you gone higher or lower than Inspector Fagan on your various judgments?
I haven't gone higher than Inspector Fagan. I'm pretty much. I think he'd undertaken a reasonable balance, and I've adopted his position, albeit having thought about it myself. The only difference is where I've afforded limited weight in respect of the safeguarded land for the health centre, which is actually a position agreed and consistent with Mr. Allen.
Yeah. One, if we just take up Inspector Fagan's decision with you just on this point, I think you referred to in passing, which is his overall approach to weighing benefits at his paragraph 103.
Yes. On
the last page of his textual decision, page 17 internal. He says there, having regard to these benefits, they do not clearly outweigh the overall significant harm to the greenbelt and the substantial adverse landscape effects on character and appearance. I've explained above. He says my conclusions on the benefits and so forth. While these are, of course, a matter of judgment, I would add that even if greater weight was to be attributed to some of these benefits, for instance, if I had given significant weight to the new health facility and to the economic benefits. So just pausing there, so, and he goes on and says, even if he'd done that, the totality of these other considerations would still not clearly outweigh the overall harm. That was his view. He refers to, or is thinking out loud, as it were, as if he'd given significant weight to the health facility. Just looking at the table, does Mr. Allen go as high as significant? I think he goes limited, doesn't he, on that one?
No.
And in relation to the economic benefits, again, the inspector said even if he'd gone to significant, looking at the economic benefits, Mr. Allen, I think, goes moderate, which is a notch below
a notch
significant.
Lower, yes. Yeah.
Right. Now, one thing I suppose I'm going to ask Mr. Allen, so I should ask you, as we've heard the evidence about this decision in its various guises and agreed to be a material planning consideration between the parties, it there follows that the inspector, I'm sure, will want to know in the round, when he makes his decision, what weight he gives the decision, if any, or which parts of it he gives weight to or not, and how that weighs in the balance. So, overall then, for the reasons you've said in more detail in proof, does this weigh in favour or against the current appeal, the inspector's decision?
Against, I think, as I say, the only real change is the introduction of the grey belt policy. And I think, so if you were to find that this site is not grey belt, then I think there's a neatly trodden path already before you in exercising, the relevant balances.
Good, thank you. Right, we're nearly done. Final couple of matters, please. Yes, so we're told by my learned friend that there's going to be a costs application made against the council. We haven't seen it yet, but we have had in the statement of case, core document 6.1, a basis set out, which is 3.21 if you want to look at it, but it says the basis will be the lack of evidence to substantiate the reason for refusal. What do you say about that as a basis for making an application for costs, if indeed one is going to be made? In light of the evidence,
I think it's a poor basis and actually an unreasonable basis to seek costs. It seems to be that's a reactive approach simply based on what appears to be an unhappy outcome in respect of decision and is premature. Obviously there is an inquiry process for a reason. Council has the opportunity to substantiate its reason for refusal and provide evidence, which it has done. It seems to be entirely premature and unreasonable, frankly, in my view, to make that case so early on that there would be an application for costs. And I'm aware of examples where appellants who have made unreasonable cost application are actually liable to a costs award against them on that basis.
Okay, thank you. Now, just going to, and you set out that proposition in your proof as well, but the reason I ask you now is just in light of having heard the evidence and indeed the concessions made by Ms Brockhurst on purposes A and B as well.
Well, it only reinforces my view. I think the council has clearly substantiated its case. Moreover, as Miss Brockhurst agreed, the approach taken by Miss Backer and by implication herself has been entirely reasonable.
Good, thank you. Now, if we could just, and I was going to end by asking you to read your summary, but seeing as there's no one here, I'm sure people may be watching online, but I think I will avoid the need to do that. And just check with you if there's anything else you want to say in chief, but apart from that, if there's not, then those are my questions in chief. Thank you very much.
Thank you.
Excuse me, Mr. Warren, you have cross-examination a couple of hours. Do you want a short break beforehand, or are we happy to...
I hope it won't be a couple of hours with Mr Stroud's assistance, but I'm in your hands, sir, as to whether we have a little break.
I'm good to crack on.
Okay.
Good to crack on.
Happy to.
Thanks. So in terms of documents for this, obviously Mr Stroud's proofs, which is core document 611, the framework 3.6, the PPG 3.9 is that, 5.4, 5.6 and 5.9, core documents 2.3 and 2.5, and 3.4. 3.4 is that 2024 Regulation 18 consultation document. Thank you very much. If you're ready, Mr Stroud, good morning to you. Could we start, please, with your proof? I just want to cover this question of weight to what we agree are the benefits, very briefly, mainly on the housing point. So if you go, please, to your page, your PDF page 20, paragraph 5.39. 5.39.
Yes.
New affordable housing, very substantial weight. Yeah.
Yes.
And you, in reaching your view, you consider the amount alongside the need. In other words, the large need for unmet need for affordable housing. Is that right?
Yes.
Okay. And just to check, in terms of how you calibrate, how you envisage harms and so on, that very substantial weight you give to the affordable housing, nearly 100 units, 98 units, is a greater weighting, isn't it, than you give to, for instance, the landscape harm, your 534?
Yes, I've given very substantial weight, yeah.
Yes, so very substantial weight to affordable, more than you give to the landscape harm on your case, correct? 5.34.
Yes, I've adopted the same gradation, yes.
Yes, you've adopted the same gradation. Just answer my question, if you would, because otherwise it's going to take the 2 hours that I said
Yes,
it wouldn't.
yeah.
So you've given more weight to affordable housing than you have to landscape harm, correct?
Yes.
Okay, and the same is true, I think, of the green belt, isn't it?
Yes,
Yeah.
yes, as Inspector Fagan, yes.
Thank you very much. Now, in terms of the market housing, you've only given that, I think, substantial weight rather than very substantial weight, as you were explaining, is that right?
Yes.
And you said to the inspector earlier on that that was, in part at least, because there are fewer market units here than there were in front of Mr. Fagan, because obviously the 50% affordable. Is that right?
Yes.
Okay. So you've diminished, as I understand your reasoning, the amount of weight that you would otherwise give to the market housing because it's less, only 50% compared to 60% before. Is that right?
Well, it's not a numerical exercise, but it's a factor in coming to.
Well, I diminish. I mean,
yeah.
Give less. I wasn't being
Yeah.
numerical about it. Okay. So you've given less weight because you say, well, there's less than last time. However, as you recognised in your proof, I think, and in your evidence in chief a few moments ago, the position now is agreed to be, isn't it, that the council has under 1 year's housing land supply,
Yes.
correct? And we know, don't we, from the decision letter that that's considerably less than the position in front of Mr. Fagan, 2.25 years housing land supply, pretty bad anyway, but it was a lot more, wasn't it, at that point?
It's less.
Well,
You say considerably less.
it's over a year. It's nearly a year and a half less housing land supply.
Yes,
Isn't
that's
it?
correct.
And in terms of the numerical shortfall, how much is the absolute shortfall greater than it was? Do you know?
I don't know.
You don't know?
offhand. No.
Have you reached your view about weight without knowing how many housing numbers are actually needed now?
Well, as I say, it's the fact that there are fewer houses is one factor in coming to a view overall.
It's not the point I'm asking you about. I'm asking you about the current shortfall compared to how it was. So numerically at the moment, as you know, the upshot of only having 0.98 years housing land supply is that there is a shortfall of 4,868 homes, correct?
Yes. Well, it's a considerable number, yeah.
Yeah, so factually that's right, and as you say, it's a considerable number. And last time, obviously, one can do the maths, but we had 2.25 years rather than 1 year's housing supply, so you can do the maths. On the same basis, it was only just over 2,000 shortfall, wasn't it then?
Yes, yes.
So in absolute terms, you're thinking about families on the waiting list, children trying to move out of their parents' homes, etc. There are over 2,000 more shortfall than in front of Mr. Fagan.
I have considered that.
Yeah,
yes.
I mean, that is a substantial further diminution in the supply, isn't it?
Yes, it is a diminution,
Right.
yes.
Well, no, it's Mr. Stroud, 2,000 additional unit shortfall is a substantial number, isn't it?
Well, yes, it is. Yeah.
Right, okay, thank you. And it's lest we forget, the shortfall that we happily bandy around these 0.9 years, etc. The 5 years supply is a minimum, isn't it, requirement of national policy?
Yes, it's not a ceiling. No.
Yeah, that's what the framework says, doesn't it? It's a
Yeah.
minimum number that needs to be maintained on a rolling basis. And the officers, we know, don't we, gave this point in their recommendation to the members on this application now appealed very substantial weight, didn't they?
They did.
Right. Okay. And this point has been, hasn't it, how much weight to give to this particular very severe housing shortfall now, considered by a colleague of the inspectors in relatively recent times, hasn't it, in December 2025?
Yes.
Yes. Do you know the one I mean, Mr. Prentice's decision, which is core document? Just have a quick look at that. Core document 5.4. I don't know whether you can get that if you've got that up. We haven't looked at this one yet, sir, so very briefly, if you wouldn't mind.
Yes, this is the scheme for the retirement homes.
That's right. Land at and to the west of Longview and 49 London Road, Shenley. So, Mr. Prentice, inquiry in October, decision 5th of December 2025. And if you go down, you've seen this before, I take it?
Yes.
Yeah. If you go down to paragraph 100 and, first of all, 141.
Yes.
You'll see that the first of the public benefits that the inspector identifies was market housing, to which he attached not substantial weight, but very substantial weight. Is that right?
Yes.
And we know that it's the same shortfall because if you go look at paragraph 104, which is on PDF page 18, so
Yes.
the inspector's been talking about need, and he says that need is particularly pressing in Hertsmere. The council and the appellants agree that the current supply of deliverable housing sites is just 0.98 years. So it's the same, unsurprisingly, because the decision was in December, and we're only now in early February. It's the same shortfall to which that inspector gave very substantial weight, didn't he?
Yes, but this is a retirement living scheme.
Right, but this point is about retirement living as part of the market, because it's market.
It is still market
living,
housing
it?
that falls under retirement living.
Yeah, but
which
it
there was a
counts as
critical
part of the
need.
housing numbers, doesn't it? That's
Sorry.
why this is a relevant consideration.
Yes.
Yeah, so there's no difference between the relevance of the shortfall to which the inspector gives very substantial weight in that case and the relevance of the housing here, is there? He's not giving very substantial weight to retirement living. He's giving it to meeting part of the huge shortfall, isn't he?
Yes, he splits those two benefits, I think.
Yeah, yes, exactly. The specialist housing is another benefit as well, isn't it?
Yes, but I mean,
Yeah.
I don't know the specific facts of this case and delivery. I mean, I've made the point in my proof about not being sure of the extent to which all of those market homes will be delivered in this case.
Right, well, we'll come to that in a minute, but let's just stay with this point. So just to help the inspector, when you look at 103, paragraph 103, just to be clear, yeah, you can see the last couple of sentences about freeing up housing in the general market, and consequently the provision of specialist housing for older people can also make an important contribution to the general need for housing. And then he goes on to say that need is particularly pressing, 0.98 years. That's the factual context for his judgment that very substantial weight should be given to meeting part of the shortfall of 9.98 years, isn't it?
Yes.
Yes, okay, fine. You know, if it's relevant that it's 0.98 years and a recent consideration of this has given it very substantial weight, firstly, you agree that this is obviously a material consideration for the inspector?
This decision is, yes.
Yes.
But recognising that it is a retirement living scheme where there are other factors involved, such as housing churn, freeing up existing houses. Yeah.
Yeah, but again, I'm so sorry, Mr. Stroud. I don't want to belabour this point, but if you just go back to his conclusions, will you, on weight?
Yeah.
141. The public benefits of the proposal would be delivery of market housing. Yeah, that's the retirement housing as market housing. Yes, it's part of the numbers. It counts towards the numbers, doesn't it?
It does,
Right.
but equally at paragraph 106 of that decision, the inspector is saying that having regard to all the above factors, including the release of existing homes to wider housing market by those relocating to the scheme, I mean, that's one of the inherent benefits of a retirement living scheme.
Right, but he's given it, hasn't he, its own additional weighting, the third bullet point under 141, the delivery of purpose-built accommodation for retirement living. Yes?
Yes.
Right, okay. So we agree material consideration.
Yes.
Yes, all right. And fine, all right, well, the inspector's seen that. Your point about consistency in relation to Mr. Fagan's decision applies to this decision as well, doesn't it?
Yes, it's a decision of another inspector, albeit in Mr. Fagan's case, it is a decision relating to effectively this scheme.
Yeah, but against, as your own case, I think, majors on, if I can put it that way, of a complete change in national policy in relation to Greenbelt.
Yes,
Yeah.
save for that point.
That's why Mr. Fagan's decision is in a different policy context. The point I'm asking you about here, a December 25 decision by Mr. Prentice giving very substantial weight to meeting market housing need in the context of a 0.98 housing land supply is directly referable, isn't it, to today's circumstances in this case?
Looking at it on a purely, say for the fact that this was a scheme relevant to retirement living, yes.
Thank you.
But, you know, I've given my reasons as to why I think it's substantial weight in this case. But even if it were to be the case that you, sir, decide that this is a matter that warrants very substantial weighting, as Inspector Fagan found, there is a, for want of a better term, leeway.
Well, okay, I think he was... I don't want to cross swords with you on that, because obviously he was dealing with a VSC assessment. So we know here, don't we, that if the inspector finds that this is a grey belt site, the council and the appellant agree that permission should be granted, yes?
Oh, well, indeed, but we're talking about the benefits, so
all right.
You know, that is relevant.
Thank you. So just dealing with, we've touched on this already, but in terms of how the inspector should approach Mr. Fagan's decision, obviously the biggest difference between the two is the policy context in relation to grey belt, correct?
Yes.
But you didn't mention this when you covered that in your evidence in chief. As we've already said, one of the other material differences is the degree of housing shortfall, isn't it, between the two, which we have agreed a few moments ago is a substantial
relevant to the benefits,
Yes.
yes.
Thank you. Relevant to the benefits, relevant to the overall planning judgment.
Well, yes, if we get that, you just said, you know, if it's a grey belt site, then you don't really get
Well, we
that.
don't have to worry about it,
Yes,
I know, but
exactly.
even if it weren't, it's a difference, isn't it? A substantial additional increment in housing need that didn't apply when Mr. Fagan was deciding.
Yes, there is an
Yeah.
increased housing shortfall,
Thank
yes.
you.
I don't dispute that, but I think that when you read Inspector Fagan's decision, I think he had anticipated that there would be an increased shortfall in the future.
Right. Well, I think we need to be slightly careful about that, because his judgment obviously wasn't based on a shortfall of 4,800 units, because he didn't know that was going to be the case, did he?
No, but he recognised that it wasn't going to improve.
Right. He wasn't going to improve. That's rather different from doubling, getting worse by a factor of 100% or more, isn't it? He didn't say that, did he?
No, he didn't say it in those
right.
express terms. No.
Okay, thank you. All right. I just want to touch very briefly on where we are in terms of whether things are going to get better or not. Obviously, you're not relying, as I understand it, on an emerging plan arriving at any time in the near future.
No.
Well, we know that there was a draft allocation of the site in the 2021 Regulation 18, and that was then withdrawn. I'll come back to this later in the day with Ms. Scott, but you've seen the documents, I take it, which relate to why the 2021 plan was withdrawn after consultation. Large-scale local objections to the amount of greenbelt release proposed?
Well, I mean, that's typical of many plans. Yes.
Well, you can say that. I mean, is it? I mean, it would be a sad reflection, I'm afraid, on planning in England if that were true. But I'm just talking about this case. So it's true, isn't it, that the reason why the previous draft plan was withdrawn was because of the scale of objection to greenbelt release in Hertsmere?
You'll have to take me to that.
All right.
Reference, I'm afraid.
Okay, well, we can do if we like, but I mean, it's, as I say, it's a point that is particularly raised by Miss Scott, so I'll do it there. But yeah.
Well, my point is, I mean, there are objections to every plan. You know, I would like to see where that's written down, the express reason from the council that says, we've decided to pause this because of the...
Okay, well, I'll tell you what I'll do. I'll show you the version or the document they then came up with in response to having withdrawn that first plan, which deals with the same point. So if you go to core document 3.4, so that's what they describe as an additional public consultation in April 2024.
Yes.
and you'll see that there's a forward from the portfolio holder for planning. Do you have that on PDF page 3? With a new administration, do you see that? We're now well on the way to producing our new local plan. And then the second paragraph, after nearly 18,000 representations, it was clear that residents rejected the last draft in 2022. Do you see that?
Yeah.
It wasn't a planning judgment exercised by the officers or the members. Residents' objections rejected it, and then our new approach reflects various things. Do you see? Yeah? So it was a scale of public objection, wasn't it, that led to the withdrawal of the plan?
I don't read that as being
okay.
the reason. I mean, it's obviously, that's a matter of fact that there are 18,000 representations.
Yes.
And it was clear that residents rejected it, but
Our new approach, it continues, by contrast, reflects our ambitions, etc., etc. Yeah? Anyway, well, I take it up with Ms. Scott. If you don't know, Mr. Stroud,
I don't make that.
You don't know?
No.
You don't accept the point that I'm putting, that it was the scale of objection to Greenbelt release because you don't know, is that right?
Well, yeah. I mean,
Okay.
it's not before us other than this.
And that's fine, all right. Okay, if you're not aware of it, the many placards and the many objections and what was said at the withdrawal. Okay, but this plan, well, it's not really a plan. This document, this additional consultation, does not, does it, attempt? In fact, it says, I think. Do you see the fourth paragraph down? We are committed to protecting more of the borough's greenbelt by allocating far fewer sites than were included in the previous draft local plan following your feedback in 2021. We're also setting a lower housing target. So the position, albeit that this isn't like a full Regulation 18, if you like, was that this plan that Councillor Oakley is introducing here, because they're not putting Greenbelt release in to the same degree, wasn't aimed at meeting the full need, was it?
Sorry, say that again?
Wasn't aimed at meeting the full need of Hertsmere. The previous one was, with the Greenbelt releases, but this one wasn't, was it?
I don't know.
Well,
it says it's setting a lower housing target. I don't know.
And the previous one
There would
was
be a justification.
attempting to meet the need. Well, if you don't know, you don't know. But then there we are. That's what it does. And it's obvious, isn't it? I mean, there were a number of draft allocations in the Greenbelt, including this site, in 2021. There was a groundswell of local objection to the plan and Greenbelt release. They come back with a plan with fewer Greenbelt sites, and of course, as a consequence, they can't meet their housing need in the draft plan. Do you see?
Well, this predates the new framework and,
That's right.
and the advent of Greybelt.
Yeah, absolutely. But that's I'm just giving you the full context for the site not being included in the 2024 consultation. Do you see?
Yes, but then maybe it didn't feature because of the considerations in relation to the site.
Oh, really? Have you got any evidence of that?
No, but this is something
we say maybe.
on both sides.
We say maybe. I mean, there is no site-specific rejection that we have seen in any document from Hertsmere in relation to this.
All I have is the record, which is the site's not in there.
Okay, there we are. And I don't want to do any more of that. So that's where we apparently got to. But I think you said, at the moment, as far as you're aware, and obviously you're appearing on behalf of the council, so I assume you've taken instructions on this, there's no Greenbelt, Greybelt study that's been produced?
I think they're going through an evidence-gathering phase with a view to publishing a new consultation draft.
Right. So the answer to my question was we haven't got one at the moment, but in line, presumably, with government requirements, they're going to have to do one.
Undoubtedly, there will be one, yeah.
All right.
Which may well find that this site is not Greybelt.
Yeah, well, we'll see. We'll see.
Well, indeed.
Yeah, undoubtedly. Undoubtedly. We'll see. But we don't know, do we? We don't know when that's going to be, Mr. Stroud. We've got no time.
I don't know.
No. And you're not placing, as I understand your evidence, any weight in opposition to the grant of permission on an emerging local plan, are you?
No.
No. All right. So I just want to cover, and again, I'm going to do this by reference to the things that you add, as it were, rather than Miss Backer's evidence again, in terms of the Greenbelt. So can I just ask you, please, to go to your proof, page 13 of 27 in the PDF, where you have your paragraph 5.8.
Sorry, bear with me. I've got
5.8, yeah.
multiple windows. Sorry, which paragraph?
5.8, PDF 13, page 11, hard copy.
Yes.
The appellant accepts that none of the exceptions of paragraph 154 apply in this case. In respect of 155, the counsel and the appellant have agreed that limbs B, C and D are satisfied. That's why I'm not going to ask you, obviously, about those matters. That's an agreed position, isn't it, between our two parties?
Yes.
Okay, need, sustainable location, compliance with the golden rules. Obviously, those equate to. Okay, and in terms of approach to the question of whether the site is grey belt, I'm not going to go back over the evidence and such as it was in front of the members for the moment. I'll come back to that in the context of costs that I'm going to ask you about at the end of the cross-examination. But in terms of the judgment that the inspector has to make, the PPG guidance has a status, doesn't it? Which is, I'll put it this way, important, potentially as important as the wording of the MPPF itself.
Yes.
Yes. And so it's not just a material consideration, it's an important, would you agree, material consideration?
Yes.
And in line with other policies, the interpretation of what it says in the end is a matter of law, isn't it?
Yes.
Yeah. And if one finds in it things like look to see whether there's a physical feature in reasonable proximity which would constrain development, one thing one can be absolutely sure about is that is something that the government considers must be considered in every particular case, correct?
Yes, as part of many other considerations.
Yeah.
Yes.
If there had been any other really important considerations, because it's a list, isn't it? It's not just one in each case of purpose A and purpose B. One would have expected the government to put it in. These are the ones they have chosen. Let me finish. These are the ones they've chosen, aren't they, to put in, and therefore one can assume that they are the ones the government thought were particularly important to flag up in policy.
No, I don't quite make that,
Okay.
that leap, no.
Right, so government puts out guidance and policy, but actually leaves out things that it may think is really important. Is that your position?
Well, no, what it's doing is it's providing prompts, being very clear that they are illustrative features and they are considerations to inform a judgment. There may be others.
I'm not suggesting
say
that in a
more
particular case there might not be a particular factor that the decision maker has to take into account. The point is the weight and importance to be given to the examples that the government has chosen to guide these judgments should be recognised, shouldn't they, as the ones that the government has decided should be put in.
Well, they're prompts for you to consider,
Yeah.
but clearly, I mean, the Secretary of State himself has, when we reference the Marlowe decision, even then you can have features, but then them still not be determinative overall of whether a site.
I understand that, but we'll come to Marlowe is obviously, as you say, an unusual-looking site and configuration quite different from this one. So I want to be proportionate in the way that I deal with same or different questions in relation to the Marlowe judgment. It's a matter of judgment in each case, as we know,
Yes.
whether purpose A is strongly met or not by the site. The point I'm making to you, though, is whilst it may be true that there might be some additional factor which is relevant in a particular case, do you accept that the ones that the government has chosen to stress by putting them into the PPG, which you say is a big change, Arabs out of the window, etc., should be recognised as the ones the government wants people particularly to pay attention to?
No.
You don't? Okay,
No,
fine.
otherwise the government said, these are the factors that you should pay particular consideration to.
Well, it does. It says should give consideration to the following, doesn't it?
Yes, but not...
Right, okay.
No, but not greater You're saying that they have a greater prominence and importance than any other factor.
Well, of
It
course
doesn't
they
say
do,
that.
because they're in the PPG. They're in the PPG, Mr.
No,
Stroud.
they're a list of illustrative features.
Okay, all right. So can we agree this? If the government had thought that there was some other particular factor, so not constraint features,
Right.
for instance, not whether it's developed at the moment, if they thought they were particularly important, one could have, is it fair to say, assumed that guidance on factors like that they thought were particularly important would be in the guidance they specifically brought out to guide the judgment?
No, I disagree,
I don't think
which
so.
is why the language in the PPG
Right.
is so carefully caveated to say these are just illustrative features. You know, they are things that you would think about, but it doesn't preclude any other consideration or characteristic as being just as important.
All right. I don't think you suggest, though, I mean, we can make submissions about whether that's a reasonable or not approach, Mr. Stroud, to how important these points are, make submissions about that. But the point that you make about there could be other things, I'm going to do it this way. We'll go to the Marlowe decision in a second, but your point there is considerations beyond what's in the PPG might be relevant.
Yes, such as the character of the landscape and its relationship to the settlement edge, which Miss Brockhurst agreed was entirely reasonable.
Right, so my point was, you gave an example in answer, I think, rather than the beginning of your answer was, yes, you're relying on Marlowe because it's an example of considerations beyond those specifically identified in the PPG. Yeah.
Well, what it's showing, what Marlowe shows, is that you may have some factors that are listed as a limiting factor in the PPG, but that doesn't necessitate a different outcome.
Right, okay, I thought that was what you were saying. Now, what that means, of course, is that the Inspector and the Secretary of State in Marlowe were applying the illustrative criteria to what extent are their features that restrict or constrain development, but they were reaching a different judgment. They were disagreeing, weren't they, in the end on that judgment?
In that particular case,
in that particular case. But that's what it shows.
Yeah.
It's not introducing any new factor in the Marlowe decision, is it? It's about whether that particular criterion about constraints is met or not met.
Well, I think there's reference in the Marlowe decision to being a settled landscape.
Yes. All right. Well, should we have a quick look at that? I don't want to, again, sir, I want to be proportionate in the way I deal with this, but can we go to that? It's core document 5.12, as you know.
5.6?
I beg your pardon, 5.6. It's paragraph 5.12 obligation, sorry. 5.6. So your paragraph 5.12 refers to this decision letter. And if you go, please, to decision letter, the Secretary of State's decision letter, paragraph 44.
Yes.
The Secretary of State has considered the Inspector's analysis. Do you see that? He considers there are clear physical boundaries to contain development to the north. Yeah?
Yes.
But doesn't consider the sites clearly defined to the east and the south. So that's an example of the application, isn't it, of one of these illustrative, as you would have it, features that the Secretary of State put in the PPG. Yeah?
Yes.
He agrees that this is fundamentally a settled landscape with built form interspersed with rural areas, predominantly consisting of open fields and lakes. However, he does not agree that the site would essentially square off the existing development. So we can look at the Inspector's report, but those two sentences go together, don't they? He agrees with the Inspector that this is open fields and lakes, but he doesn't agree that what follows from that is that the scheme would be a squaring off of development. Are you with me?
Yes, although he's making judgments about landscape.
No, it's in the context of whether it would square off development and therefore be an incongruous pattern of development. That's what he's saying.
Well, no, that's a new. No, I think that's a new sentence. He moves on to then say.
However, sorry, I don't want to get into textual analysis too much, but just read it as a matter of English. He agrees a settled landscape, predominantly open fields and lakes, the east and south. However, he says, he doesn't agree that the site would essentially square off the existing development and considers the development would result in an incongruous pattern of development. So those two sentences are about the second or third, is it, of his particular points in the PPG, isn't it? That's what those sentences are about.
No, I don't think so. I think he's drawing in various factors. He's considering the state of the landscape and reaching agreement, and then he goes on to say, but this is incongruous.
Exactly.
Yeah.
So it may well be that the built form is interspersed with rural uses, but I don't think it's rounding off. I think it's an incongruous development. So it's part of the judgment on one of his key guidance points in the PPG, isn't it? It's not a point about landscape character, is it?
Well, I haven't quite read it that way.
Well, I can see that you haven't read it that way, but you're wrong, I'm afraid, Mr. Stroud. I'm putting to you, you're misreading what the decision letter actually is dealing with. It's quite plain. He's dealing, first of all, with constraints features, and east to the south, and then he's dealing with incongruous pattern of development, isn't he?
No, I haven't read it that way.
No, I can see
he is.
that. But can you see the point that I'm putting to you about how one should actually read the paragraph?
I see the way that you've read it. No, I think he's looked at the state of the landscape in the way that he's formed his views, which, as we've agreed, is a reasonable approach.
There we are. Okay, so well, you'll make what you will of that, and we can see what the inspector found, obviously, with which the Secretary of State disagreed. Just go to that, will you? Would you mind just going down to the inspector's report? It's in the same document. In the normal way, it's many a page further down in the PDF. I'm looking for inspector's report, paragraph 15.6, which is on PDF page, to the bottom of PDF page 202, I think. So that's under the heading, Would the Development Utilise Grey Belt Land? Are you with me? So this is one of the paragraphs that the Secretary of State says, I've carefully considered the inspector's views. But it's interesting that in this paragraph, 15.6, the inspector's dealing with the council's own assessments of the parcels, Greenbelt land, that was in issue in the Marlow case. And he says, despite the concept of grey belt being relatively new, I disagree with the council that strongly would have different meanings in their Greenbelt studies and the definition, in other words, the definition in the framework. Strongly is not a complex word, nor one which has many different meanings. To adopt the council's approach, which is the same one as here, that this is a completely different methodological approach to complying with the purposes, would unnecessarily complicate an essentially simple concept. Now, you can see what he said. That paragraph's not disagreed with by the Secretary of State, is it, in the decision letter?
Sorry, what's the
point? The question is that this point, I disagree with you, counsel, that strongly when you're doing a PPG exercise is quite different from the previous regime under which the council's own assessments, just like here, had been done. Because strongly is just a simple word. It's just an evaluative word.
That's not the inference I draw. No, he's simply saying strongly is not a complicated word. He's not saying there is a very limited number of criteria within the PPG that you should follow.
Sorry, I thought we could deal with this more quickly. Look at 15.6. So in relation to purpose A, even on the council's own assessments, so in the Marlow case, as here, given the time when Marlow was dealt with, the council's assessments were pre-PPG. They were a previous Greenbelt, like here, like the Arup ones here. Yes. And the council was arguing that strongly, because again it was found not to be strong, the land in that case, you can't read across, the council was saying, strongly, because it means something else now because of the PPG. And the inspector is rejecting that, isn't he? I disagree with the council that strongly would have different meanings in their Greenbelt studies and the definition, MPPF. Strongly is not a complex word, etc. So he's rejecting precisely the point that you're making here about the Arab studies, isn't he?
It doesn't say that. I think that's doing quite a lot of heavy lifting. I think it's just simply saying that you can't simply move from one to the other.
Well, strongly, do you disagree yourself that strongly is not a complex word or one that
strongly is not a complex word, but in order to reach that judgment, you've got to consider factors. Yeah. Factors within the PPG that are only illustrative and non-exhaustive. Right. Which I think Ms. Brockhurst agreed as well. So just let me be clear about your case. Are you saying that the PPG is not so hard-edged that it's very different from what the Arup work took into account then? No, the approach is clearly different. Right. But our point of difference is you are saying that it's a very limited set of considerations you're taking into account, and I'm saying, no, it's much broader than that. Well, again, I'm not sure that is precisely what I'm saying. I'm saying that as I put to you earlier, and you disagreed, and I'm going to make submissions about it,
the government has chosen to give specific pointers on particular issues, which, as I've put to you in the Marlowe case, he actually works through in decision letter paragraph 44. And those should be given due weight because they're the ones the government has chosen to stress.
I don't think that they are any more important than any other factor that you might see as being relevant to contributing to the purpose, A or B.
It's an interesting, all I'll say, and I won't say that actually, I'll just make submissions about an interesting point of how to interpret government guidance and policy in that case, that it's not actually that important because other stuff that they don't mention could be equally important.
Well, I think when the government chooses to use the word such as, and these are illustrative features, these are considerations to inform, it's not fixed, it's not mandatory.
I know that it's not. There's a difference between. Let me just put this to you. Sorry to interrupt. There's a difference between a list not being closed and the list not being very important. Do you see?
I didn't say the list wasn't important.
Right.
What I've said is it doesn't import any greater sense of importance than other factors that might be really quite relevant.
All right. Now, the ones that... So, just before we come to the ones very briefly, that just to be clear about the council's case, now that we've had your evidence as well as Ms Backer's, that you say are here important, in addition to the ones that are actually in the PPG. Let me just deal quickly with the Lancaster Road decision, which is, I think, caught up in 5.9, isn't it? You just go to that, please. So this was a decision, wasn't it, of March 2025, yeah?
Yes.
Post the emergence of the February 2025 PPG guidance. And I think it's right to say, isn't it, that the inspector in this case takes into account the guidance? Is that right?
Yes.
Yeah. And he... It's a he, isn't it? Forgive me. Yes, paragraph 10. Thank you, Dr. Bose. Paragraph 10 is the reference to the PPG having come into being, etc. So even though, just to be absolutely clear about it, the inquiry was in January 2025, the decision was in March, and the inspector had regard to the PPG that had come out by that time. This was a decision, wasn't it, where the inspector found, applying the PPG, the site to be grey belt?
Yes.
Yeah. All right. And the point that I think you refer to in your proof, if you go to paragraph 20 of the decision letter, this is under purpose B, isn't it? The assessment of whether the site strongly contributes to purpose B is accepted as a matter of planning judgment. Nonetheless, consideration must account for several factors, and not just in relation to distance or size of the site. Yeah. Now, of course, you've heard Ms Brockhurst's evidence and so on. The appellant isn't saying that one should only look at the size of the site or the distance, is it? Here.
No, but what we have stressed is there is a point of perception.
There's a point of perception, exactly, and Ms Brockhurst's given her evidence, disagreeing, obviously, in trenchant terms with the point that's raised by the council and others on perception of merger here. So, again, this isn't a decision which shows that the approach the appellant is taking is wrong because it focuses, the appellant here is focusing just on size of site or linear distance.
No, and that's not the reason I referred to it.
Right, okay. You're referring to it, I think, aren't you? Because it has things in it like perception when you're dealing with purpose B. But again, that's not an issue between us because we've dealt with that in our evidence and accept that. Perception is relevant here too. And the perception is whether there would be a merger between the settlements, the towns.
Yes.
Yeah. Okay. This decision also indicates, doesn't it, if you go back to purpose A, if you look at paragraph 18, 1.8 of on the same page, I think, of the inspector's decision, in the light of the evidence to see that the site's located on the built edge of the settlement there, Hess Bank, it doesn't make a strong contribution to Greenbelt purpose B, preventing settlements from merging into one another. In this case, the two settlements, it's a self-contained site adjacent to existing development to the north and east and is easily distinguishable visually and physically from the wider countryside. So the inspector there is taking into account, isn't he, I think in relation to purpose B, because that was the only one that I think the parties were fighting about in that case, arguing about, that whether the site was self-contained and easily visually distinguishable from a wider countryside is something that should be taken into account in purpose B. Do you agree with that?
So that was the reasoning undertaken in that case.
Do you agree with that as an approach, that it would be relevant to ask oneself whether the site in question was self-contained and visually distinct from the wider countryside?
Yes. Yeah.
Which is the case, obviously, in the case of this site, isn't it?
Well,
Self-contained site?
no.
You don't
I
think
there would be visual openness, certainly at on Shenley Hill.
Yeah. Your witness said localised and
Well,
limited.
if you have a look at the
Do you disagree with what your witness said in terms of the spread of visual impact? It's a localised visual impact.
It's localised,
Right,
but you can
thank
see
you.
across the site, you will recognise
All right.
that the development is moving directly towards Boreham Wood. That's a perceptual factor.
All right. Mr. Stroud, the point I put to you is, are you saying, because you apparently give some judgments about this as well, is your view coloured by a judgment that this site isn't self-contained?
What do you mean?
The question is, have you taken into account in forming your judgment, your view, that this site here is not a self-contained site? Is that something you think?
Well, I've considered this site based on its particular constraints, with the framing of the woodland to the east and the south, the existing state of the northern boundary.
Yes.
I've looked and considered that, yes.
Right, so
The topography as well.
okay,
yes.
so that's a roundabout way, is it, of saying, yes, I've considered that it is a self-contained site?
Well, I don't use the phrase self-contained. I've considered the nature of the site and its boundaries.
And the degree, well, let me put it this
and its
way,
topography.
the degree to which it's contained.
The degree to which it's contained, yes.
Yes. Okay. And just to be clear about it, though, you referred, you're not taking a point about woodland felling, etc., I know.
No.
You're not suggesting, are you, that the woodland, 25 hectares of woodland and the wooded sides with the two well-established roads and so on, and the housing on the edge of Radlett don't make the site self-contained? I mean, you don't say that, do you?
No, I don't. I mean, in
Right.
respect of the woodland, what I do think is it plays a particularly important role in understanding the character of the site and its transition very clearly away from the settlement edge.
Sure, and its visual separation from the rest of the countryside. Plays a
Well,
role
it's
there
part
too.
of the countryside.
Yeah, exactly. Quite. All right, there we are. So self-containment. And then also, do you see in 19, the inspector here, I'm really pursuing your line here. You should be grateful, Mr. Stroud. Are there other things that in particular cases might be looked into? In this case, do you see, when considered in the context of the North Lancaster Greenbelt, the site is very small. As such, its contribution to purpose B is relatively limited. I mean, obviously, this site is very small in relation to the Hartsmere Greenbelt, isn't it?
In relation to the entire Greenbelt, but
Yeah.
I disagree the site is small. It's 8 hectares within a relatively small
Right.
gap.
But this is a relative judgment he's making, isn't it?
So
It's a relative judgment he's making, isn't it? Not an absolute.
that's what he says
Yeah,
at
yeah.
the start of 19. Yeah.
And if one were to do that exercise here, it would be true here too, wouldn't it? The site would be...
Within the context of the whole Greenbelt, yes.
Yeah. All right, thank you very much. Okay. I just want to very quickly touch on a couple of points you make on purpose A. I promise I'll try and do this as quickly as possible. The point that you make, and to some extent I think Ms. Backer made it, though you've articulated it in a slightly different way. I'll give you a reference. In your proof, paragraph 5.16.
Yes.
In my view, having regard to the evidence of Ms. Backer, the appeal site performs strongly against purpose A because it is the immediate undeveloped countryside break on the southeastern edge of Radlett. Do you see that?
Yes.
The relevant question is not whether the site is visually contained in longer views, but whether spatially and functionally it is the land that is currently doing the work of keeping development in check at this point. Yeah? Do you see
Yes.
that?
Yes.
Now, the site is a designated greenbelt site, isn't it, at the moment?
Yes.
Yes. That's the fundamental reason it was refused permission for 195 houses by Mr. Fagan, isn't it?
Yes.
Yeah. So it's the fact of its designation as greenbelt that is keeping development in check, isn't it?
Well, no, I mean, that simplifies the point, but what we're doing is assessing that the contribution that the site would make in fulfilling that purpose.
Yeah, I know, but you're not suggesting for a moment, are you, that with a 4,800 house shortfall, if this wasn't a greenbelt site, that the tilted balance in 11D wouldn't indicate that permission should be granted for the scheme, are you?
No, I think we're
No.
agreed that if this is greenbelt, then it wouldn't be inappropriate.
Yeah, exactly. So this is a point about what work, as you put it, the site is actually doing at the moment to keep development in check. It's not because it's landscape, because we've just agreed permission would be granted absent the greenbelt status. It's the fact that it's designated as greenbelt that's keeping development in check, isn't it?
Well, in one sense, yes, but
Yes.
what I'm looking at is I'm assessing this site to consider how it performs against that purpose. And this site, I think, plays a strong role when you consider its interface with the existing, clearly robust settlement edge, topography moving away, rural character. I think
know,
it
but those
performs
points are-
strongly in checking unrestricted sprawl,
I'm so sorry.
notwithstanding that it is designated as
But the landscape points, so edge of the landscape, verdant, moving away from the boundary of the settled area, etc., those are landscape objections, okay? We know that they wouldn't be enough to give, to restrict development here, as we've agreed. The thing that is keeping development in check in relation to this site is the fact that it's a designated greenbelt site, isn't it?
Well, I think that's circular, because otherwise why would you assess greenbelt sites in the
It is
first
circular.
place?
That's
So
precisely the point.
That's why
No,
you've got to look at the
that's precisely
contribution
the-
the site's making.
That's precisely the point that I'm making. You, Mr. Stroud, are praying in aid the fact that the development, not because the site, not because of its countryside, as we know, but because of its greenbelt status, is keeping development in check. But that, of course, is circular, because the PPG asks us to review this in the light of the PPG.
That's not the approach I've taken.
But do you agree then that to say that a greenbelt, just because a site is greenbelt, it can't be greybelt? That would be wrong, wouldn't it?
Yes.
Yeah, obviously. But if in fact it's the greenbelt which is designation which is keeping development in check here, because otherwise permission would be granted.
I mean,
it is the designation, isn't it, that's doing the job of keeping development in check?
That's self-evident, but that's not the approach I'm taking in that paragraph.
Well,
What I'm
that's what
doing
you
is I'm
say.
assessing the contribution that the site is making as part of the grey
Yeah.
belt. Not because it is grey belt, but what is its contribution to the grey belt purpose?
I think the trouble is that the points that you make there, and again, you're referring to Ms. Backer's evidence, and she fell, in my view, into the same error. Whether the site is visually contained, etc., whether it's undeveloped or whether it's a countryside break, etc., those are matters which are out with the spatial policy of Greenbelt. Yeah, they're landscape points, aren't they? The character of the site.
Which we're agreed is
Yeah.
a reasonable illustrative feature in accordance with the PPG.
Right. But we've also agreed that the countryside aspects of the site obviously wouldn't be enough to prevent development being granted here. So if that's right, it must follow, mustn't it, that these landscape points are not keeping development in check. It's the green belt status of the site which is doing that, correct?
No, I think that's a separate
No?
question. What we're considering is, as Greenbelt, what role is this site playing?
Right, okay, well, if you agree that's the correct approach, that's fine, and we can make submissions about what you've actually done, you and Ms. Backer have done. But can we agree that one should not take into account purely landscape points in assessing PPG?
They are part of the illustrative features that you would consider. They're factors.
Right, but they're not. The point you're making here is it is the land that is currently keeping development in check. Now, it's not the landscape which is keeping it in check, as we know. It's the greenbelt designation, isn't it?
No, I think we're at cross purposes.
I don't think so.
The fact that it's Greenbelt is obviously that's self-evident. What I'm considering is what contribution is this site making to Purpose A?
Yeah.
The purpose of which is to prevent sprawl.
Okay.
Looking at the illustrative features, of which I think landscape character can be, well, it's agreed to be a factor, and that's exactly the assessment I've reached.
What do you mean by doing the work of keeping development in check, then?
So, looking at the characteristics of the site, being free of existing development, being immediately adjacent to the built-up area, looking at the robustness of the existing edge with the settlement, considering whether it would be incongruous or not. I mean, I've followed those examples.
Well,
landscape character being irrelevant.
If you're not saying anything more than what's in the PPG, that's fine. But it is the site that's doing the work of keeping development in check at this point. Now, up to the inspector, I guess, in the end, to evaluate this. But what it appears to me that you're saying there, Mr. Stroud, is that because of those points, it's undeveloped and so on, there isn't development there at the moment.
That's not the point.
Okay. So what do you mean by keeping development in check? That means preventing housing being built, doesn't it?
No. What I mean by keeping in check is, well, effectively fulfilling the role of Purpose A.
It just means it's undeveloped at the moment, doesn't it? It's not keeping anything in check, because were it not Greenbelt, there'd be 195 houses sitting there now. We know that.
Yeah, that's not the point.
So it's not anything to do with the landscape that's keeping development in check. It's to do with the fact that it's a Greenbelt site, isn't it?
Well, yes, but that's a different question. What I'm looking at is the extent to which this site contributes to Purpose A.
Yes, I know that you are, but I'm putting to you that as part of your reasoning there, you've got something circular. Anyway, I'm in danger of putting it 4 times. I've already put it 3 times. I'll stop there. Thank you very much. That's all I wanted to come back to you on Purpose A. On Purpose B, I think we've largely covered this, but could I just check with you, do you accept, Mr. Stroud, that the judgment, and we could look at the PPG if necessary, the judgment on Purpose B, which is preventing the merger of neighbouring towns, that's the purpose, isn't it?
That's the purpose, yes.
The judgment has to focus on whether the scheme would either literally or perceptually give rise to merger between Radlett and Boreham Wood.
So I said it again.
Would you accept that the question is, would the development of the site literally or perceptually give rise to the merger of Radlett and Boreham Wood?
Yes, albeit it's the other way around, isn't it? It's the contribution that the site's making.
Thank you.
Yeah.
Thanks very much. Okay, last series of questions. If you're happy to go on, sir, it's 11:30, nearly 11:30, I know, but again, with Mr. Stroud's assistance, we'll be done in 10-15 minutes. So this is a section of question about costs, which I think is fair to put to you, rather than just make the submissions in the written document. You'll know this, Mr. Stroud, but one of the bases upon which the government suggests, there are others no doubt, but this is one of the ones that they actually suggest, why costs might be awarded against the local planning authority is if they prevent development which should obviously be granted. Yeah? Clearly be granted.
That is one of the
illustrations.
Factors, yes.
There are all sorts of other ways authorities can behave unreasonably, I know that, but this is one of the ones that the government particularly picks up on, that they prevent the grant of permission that should clearly be granted. Now, you say in your evidence, for your references at your 5.29, you said it again in your evidence in chief a few minutes ago, that an application for costs was premature. Now, obviously, the costs application relates to why we're here, the refusal, doesn't it? So the starting point, and I'm not suggesting it's the ending point, but the starting point is whether it was reasonable or not for permission to be refused and therefore for Fairfax to have to appeal, isn't it?
Yes, yeah.
Yeah. And so arguments like, well, some evidence has been produced now ex post facto, which, as it were, attempts to support the members' decision, has to be viewed very carefully, doesn't it, in that light, as ex post facto justification, if there wasn't any other evidence in front of the member.
Well, you have to consider the evidence very carefully, yes.
Yeah, you have to consider, so my point is, just to be precise, the fact that what Miss Backer and you and Miss Scott and so on are saying is ex post facto, maybe not so much in relation to the parish, to be fair, because they objected on a variety of bases themselves, obviously in the consultation. But as far as the council's concerned, officers recommended approval, didn't they? We had Arup and so on, which you say doesn't really apply anymore. But they didn't have any evidence at all, did they? Any evidence in front of them applying the PPG tests to which the inspector can look at the members, as it were, addressing when they refused permission.
They had the PPG before them. They had all of the application evidence. They had the various objections, including from the parish council. This is a planning committee who will be familiar with the area. They will have looked at the evidence and reached a view. The inquiry rules and procedures are there for a reason, that offer a council an opportunity to then substantiate its case, which is exactly what's happened here.
Right.
In my employment previously, obviously I've seen many decisions where planning committees have, quite fairly and reasonably, as is the democratic process, decided to reject officer recommendation, and they're free to do so. And indeed, in many cases, subsequent appeals are then dismissed, ultimately upholding the decision taken by those planning committees.
I'm with you. I'm not talking about the generality so much here. I'm talking about what the evidence was here. Now, you said that the members had, various bits of evidence and some front. The first factual point is the inspector and we, indeed, can't see any evidence, either in the minute of the meeting or anything, recording of the meeting, of the members discussing detailed points, or indeed any evidence about whether the site was a grey belt site.
Well, I think you have in the minutes clarity that the site is not grey belt, and there are no very special circumstances. That is what's recorded.
That's not my question.
And then you have a reason for refusal, which explains why planning permission has been withheld.
All it says is we don't consider it to be grey belt. So there's no evidence at all that the members actually grappled with any of the PPG work, is there?
Well, there is, because that's self-evident from the recorded minute and the reason for refusal.
Well,
I think there is nothing novel or unique in the way that this decision has been taken. It reflects the kinds of the decisions that are taken on a weekly basis across the country.
Yeah, I'm not sure that's your best point, if I may say so, Mr. Stroud, but I'm not talking about the generality of how local authorities take decisions, a number of which are obviously found to be unreasonable by inspectors on appeals, as you know. So I'm not talking about the generality or saying, oh, well, it's all a matter of normal practice. I'm talking about what happened in this case. So where in the minute, Mr. Stroud, is there any evidence or indication that the members grappled with the PPG tests, or indeed any evidence?
Well, it is a minute. It simply records the decision and the reason for it. I mean, it has been recorded that they considered that the site was not grey belt, and there were no very special circumstances that would illustrate that it's appropriate development in the green belt.
So the answer to my question is there's no indication that they grappled on any document that we can see with the PPG, correct?
There's what we have is the minute and the reason for refusal.
Yes, what's the answer to my question? There's no evidence in that they grappled, this is my question, with the considerations, or indeed any other considerations, in the PPG, is there?
Well, they clearly had evidence before them. I mean, that's there from the application documentation. They're able to reach a judgment. They've had a look at the background documentation. They're aware of all of the objections that have been...
Show me the inspector where this is in the minute, Mr. Stroud. Where's the evidence in the minute that they grappled with the PPG?
Well, it's not recorded in the minute,
no,
but it's obvious that they have grappled with it.
Is it? Where else is it recorded?
Well, there is a committee bundle that they will have been given. They have a familiarity with the area. These are experienced decision takers.
Had they been to the site?
I'm sure that many of them would be very familiar with the site.
Do you know whether any of them had been onto the site?
Not as part of a formal site visit.
No.
But
there was no formal site visit here, I think, was there?
No, but that again is quite typical. We're dealing with members who are familiar with the area. They'll know the site very well.
This isn't a JR, so the point about members should be assumed as a matter of law to be familiar with the area in general doesn't really work here, Mr. Stroud. Did the members go on to the site, do you know, or not, to evaluate whether it was self-contained and cut off?
Well, not onto the site, because of course it's locked up. But I mean, again, that's typical of the majority of planning applications that are determined by
you keep talking about
committees.
Typical things. Members often go, don't they, as you well know, Mr. Stroud, if they're concerned about things, to see a site and arrange a site visit and go to it.
I don't. Well, from my own experience of other authorities, it's not something that happens on a regular basis, because you rely upon the familiarity that members will have with the area itself. All
right, not in your experience anyway. Okay, and then in terms of we know what the officers recommended and the evidence that they considered in the report. In terms of the minutes, if you go to core document 2.5, which is the minutes of the meeting when permission was resolved to be refused. We've got, haven't we, here an account of what occurred, a summary account. of what occurred. Yeah?
Yes.
And we can see, I'm not going to take you through all of it because you and the inspector have no doubt read this. How do you see I don't think I need to ask you about, we can see who spoke and so on. Mr. Allen spoke and representatives from objectors and the councillor spoke. And then there was a procedural point. And then there's a paragraph beginning, a member asked. Do you see that? A member asked whether there had been any meaningful changes since the application was previously considered. That was earlier in the year, I think, wasn't it? Yeah? And there was a point about the school and so on and medical facility safeguarding. And then there was reference, wasn't there, to Mr. Cannon's opinion. Do you see?
Yes.
Legal, or indeed the other ones, legal advice from King's Counsel, plural perhaps, had also been included. The application was coming back to committee after being refused previously because the developer had challenged the committee decision because there was a procedural issue. Hertsmere then had the opportunity to seek legal counsel, who advised that officers should have been given the opportunity to advise members how refusal would affect Hertsmere, etc. And then we see, don't we, in the next long paragraph, an account of what was discussed.
As you say, a summary account.
Yeah, okay. No reference, I think, there to the points that I was previously asking you about. But what was flagged up to them was, towards the end of that paragraph, the external legal advice from the KC explained why the grey belt designation of the site was justified. Do you see that? And then, in fact, the officers saying that even if it wasn't grey belt, VSC still indicated that permission should be granted. That was the officers' view, wasn't it?
Yes, that's
yes.
what I recall.
So not just grey belt grant permission, but even VSC grant permission. And then there was a question about green space, and then there were some further questions and so on, and then there were some points about highways. Do you see that?
Yes.
And then do you see the paragraph that begins, some members maintained that the application wasn't substantively different? And then it says, the grey belt designation of the site was seen as a subjective judgment by members based on their interpretation of the advice from legal counsel. Not quite sure what that sentence means, but I guess it means they thought that it was up to them. Yeah?
Well,
regardless of what was said by Mr.
planning
Kemp.
judgment is the preserve of the decision taker.
Yeah, I suppose that's what that means. Subjective judgment by members. Thus, if determined by members to be greenbelt, there were no VSC, they said, to justify building in their view. So they rejected that. Other members recognised the grey belt designation based on officers' expertise and the advice of external counsel, noting the benefits to the scheme. Yeah? And then we have the resolutions. But before the final vote, there was some advice given by the head of legal, wasn't there? Or the assistant director of legal. Do you see that paragraph?
Sorry, where is this?
The assistant, just before the vote, the assistant director of legal and democratic services advised members. Do you see that?
Oh, are we on to the second vote now?
The second vote, yeah, not
Yes.
the first one, which was, should we grant permission? No. The second one, before they, as was apparent was going to be the case, they refused permission, 7-6. The legal officer advised them, didn't they, that there was a strong likelihood the application would go to appeal, given the officer assessment and the advice from King's Counsel. This was because legal advice had considered the site to be grey belt. In this event, the inspector would look for substantial grounds for refusal in their absence. Members were advised that Hertsmere would be afforded significant costs for disregarding legal advice borne by the taxpayer. So effectively there was an appeal and costs award warning, wasn't there, given by the legal officer at the point just before they voted?
Effectively warning them that they would need to substantiate their case and their reasons for refusal.
Yes, that's right. That's precisely why I've been asking what evidence there was of them grappling with these things that we've been carefully looking at over the past 2 or 3 days.
Well, I think that evidence is there. They were grappling with it. They'd had advice on one side, they had a vote, that vote failed.
Right.
They then looked and considered and explained why the vote failed. It
That's
failed
interesting.
because they...
I think one thing is absolutely clear.
I'm quite happy to wind this line of questioning if we can make some progress.
Yeah, by all means.
Most
So,
helpful,
yeah.
Thank you.
Just one point. There isn't any indication here, is there, of how they decided or what they decided about the PPG points. They didn't say, no, it's not self-contained, no, it's not, there isn't a feature in reasonable proximity or anything of that kind.
This is a summary account.
Yeah, so the answer is no, there's no indication of that detailed consideration, is there?
It doesn't mean that it didn't take place.
Right, but there's no indication of it.
Well, it's not recorded.
Okay. All right, thank you. And we've obviously, the other part of the cost application, sir, is going to be failure to substantiate, obviously, through evidence based on the judgments that you've heard and heard cross-examined by Ms. Backer in particular. All right, thank you. Obviously, planning judgments can be reasonable or unreasonable. Just because it's a judgment, it doesn't follow that it must always be reasonable, does it?
Of course.
No. So one can say, yes, I think this will lead to the merger of these two settlements. And it can be a completely unreasonable judgment, can't it?
Well, that's why you would have to explain why that you took that view.
Exactly. It's not just because somebody says it, it's whether or not it's reasonable for them to have said it, isn't it?
Well, have they explained why?
Yeah.
I think it would be unreasonable if you just simply stated something without adducing any evidence.
I think it's a stage further than that. Not just said why, but those reasons that they've, the reasons, their reasoning for those assertions or those judgments have themselves to be reasonable, don't they?
Yeah, I think that would be a very high bar.
What do they need to be reasonable?
Well, to say that somebody having made a statement and then evidenced it has been unreasonable in doing so, I think is a pretty high bar.
You say that it's unlikely that it would be found to be unreasonable. You mean just because they've said why they said it?
Well,
even if it's hopelessly unreasonable, you mean?
So, for example, you've just criticised the evidence of the council's landscape witness who has undertaken an assessment incorporating factors and characteristics that your landscape witness stated to be reasonable. So,
we can have a debate about that. But this is, I don't want to bandy submissions, Mr. Stroud, about Ms. Backer's evidence. That's not the purpose of it. Exactly. But the point is, there's quite a play been made by the local authority about it being a matter of judgment. It's all a matter of judgment. But the point is, that's always the case. All planning is judgment. If just because it was judgment was an answer to a cost application, there wouldn't be a cost regime, would there?
That's why you'd expect evidence.
Right, exactly. It has to be backed up with substantive evidence. And that evidence itself has to be cogent, doesn't it? And actually support the case. That's what the cost guidance says.
Yes.
All right. Thank you very much. All right, sir. Thank you. I'm sorry that took so long. I'm done. Thank you.
now. Mr Cosgrove, you have some questions, I presume, re-examining.
4 topics, thank you, sir. Mr Stroud, just picking up on the last debate you had about costs and members' decision and the minutes and so forth, and you were explaining, I think, to my learned friend that members did consider various matters in relation to Greybelt, and it said, well, it's not in the minutes and so forth. Do we just go to core document 2.5, which are the minutes first of all, and you take into some parts of that. If you, for example, look at PDF 2, and you'll see towards the bottom of that page there's reference to the legal advice from King's Counsel, which, as I recall, we've looked at it, set out the relevant tests for grey belt versus green belt. Yeah?
Yes.
And you'll see there's reference there to the inclusion of it to justify grey belt designation, and then further down on the next page there's references to grey belt at various stages, and whether it was a justified conclusion to find the site was grey belt or not. And there's reference on the next page, you'll see under the headings, under the paragraph, some members maintained that it wasn't green belt and was grey belt. All that discussion. I mean, question to you is this: what's your view on the minutes as whether they disclose or not that there was any discussion about the issue of grey belt and green belt?
I mean, it indicates that there was. Yeah.
Yeah. Now, in the report, obviously the members have a report provided to them, and there are, I mean, if one just does a word search of grey belt, you see it all over the place. But what I want to ask you, did that report discuss and describe the policy basis for whether something might be grey belt or green belt or not?
Oh, yes, it did.
Did officers go on and consider in that report the very special circumstances test on the basis that members might find the site was green belt?
They did, actually. It's towards the end of the report, yes.
And again, in the interest of time, I mean, is it fair to say when one looks, for example, if we look at, for example, a PDF page 44, you'll see officers reporting to members at 7.3.4. They say, therefore, consideration now also needs to be given to Power 155 of the NPPF, which relates to grey belt land, and then the following paragraphs talking about grey belt and how one comes to a view.
Yes.
Now, you explained to my learned friend that members disagreed with the officer's advice. I think your position was that's something that it's part of the planning process, sort of week 1 at planning school, right?
Yes.
Did they have enough, in your view, before them to come to their own view as to what grey belt meant and what green belt meant and the distinction between them, or not?
Yes, of course. In order to come to a view, which they then took, it just happened that the view was different.
Good. So is there anything in your view in the points put to you about there not being a basis at the decision-making stage for there be no evidence to justify the refusal before them, or no basis upon which to do so in some way?
No, there's no.
And even if that were the case, is that the test for costs? The planning appeal? No. And in relation to the evidence the inspector has now to justify the reasoned position of members, is there substantive evidence in your view?
Yes, before this inspector, yes. Yeah.
Good. All right. Now, a couple other points just to cover. Going back to the beginning of your cross-examination, you were asked, if you can take up the inspector's decision at core document 5.1, you were asked some questions about housing shortfall and the current level as opposed to the level at the time Inspector Fagan was considering the matter. Do you recall those questions?
Yes.
And your answers in chief, you said, after a debate with my learned friend, you said, well, even if you were to up it to the top level, it wouldn't make any difference in your judgment. That
yes.
Was your, right.
Yes.
And then you referred to, you said, and you answered my learned friend, you said you felt Inspector had addressed what he thought might happen about housing in the district. Can I just ask you to look at paragraphs 55 of the Inspector's decision through to really 60? And the Inspector will have read this. Those are the parts the Inspector's talking about supply, emphasising at 57 the chronic failure, 55 there's no sign of a new draft-looking plan, I've little confidence that the council is moving forward with efforts and so forth, and you'll see at 57 every single new housing is important, even one dwelling must be encouraged and considered.
Yes.
And then at 58 you'll see he refers to other decisions where some inspectors had given more weight than him, very substantial. So, are those the paragraphs you had in mind when you were answering my learned friend about
yes.
Inspector Fagan's reasoning?
Yes.
Yeah. Okay. And thank you. Next point, you were asked about the PPG guidance. And as we know, in certain circumstances, courts told us it can have as much equivalent importance to the NPPF, and you agree with that?
Yes.
And you were asked a series of questions sort of about approach, I think, and about the criteria and the lists, and it was put to you, well, you know, there's a reason why particular points are set out there, and it was said that those factors there, the weight should be recognised, or weight should be recognised in relation to them because they're what the government has said you should consider.
Yes.
Now, there are, of course, as all the experienced planners in this room will know, there are certain times when weight is for a decision maker, and there are certain times in planning policy where government tells you what weight to give to something. For present purposes, in this case, 153, we're told what in relation to weight?
Yes, that's the latter,
Yeah.
yes.
Is this inspector told what weight by the government to give to the various factors in the purposes guidance here? Does anywhere it says you must give substantial weight to indent 1 or...
No.
In your view, how should one approach what weight you give to the factors identified by the government, or indeed any other factors that you might want to take into account in a particular case? Is it just because they exist, or is it contextual?
It's absolutely contextual. I mean, it's not uniform. You'd have to consider the circumstances of the case, and these are prompts to aid you in coming to a judgment, of which there may be other factors.
Good, thank you. Now, you were asked some questions just briefly about CD 3.4, and that, you recall, was the stage going back when there was another local plan and justification for an emerging local plan. Do you recall that? And if you go to within that document, if you have it, please, you ask some questions. I think it's put to you, well, a suggested basis as to why certain sites were abandoned. And you said you don't know, and you looked at this document. If you look at section 4 on PDF 9, is that where we see there's a heading, the proposed spatial strategy?
Yep.
And again, in the interest of time, we won't read it all out now, but in those paragraphs that follow, is that where there is the set out position at that stage as to why certain sites, in light of assessments made about Greenbelt, certain sites were not being pursued and certain sites were being pursued as a matter of judgment?
Yeah.
And in a local plan process, you have an identified housing need, policy off, policy on, all that stuff. It is, at least in principle, is a local authority entitled to reduce an identified need if there are just suitably justifying circumstances?
Well, yes, I participated very recently in a local plan examination where that was the case.
Yeah, all right. So, again, the inspector can read that in his own time to see the snapshot of what the position was,
Yes.
so far as that document reveals. Okay, thank you. Now, yes, you were asked some questions about the Marlow decision, and you were taken to various parts in the Secretary of State's decision and also in the inspector's report. You were taken in particular to paragraph 44. Now, when one looks at paragraph 44, if you have that up, it's PDF 8 within core document 5.6. You looked at particularly the sort of second half of it. You had a debate which I'm not going to intrude on between you and Mr. Warren about word by word dissection of what was meant, whether it's development or the development, but we'll deal with that later. But when you look at the first line, the Secretary of State's considering the paragraphs he sets out there from the inspector's report and says he considers there are clear physical boundaries to contain development to the north and west. What, in your view, is that referring to as a factor, so far as you can tell in this context, in terms of the considerations one might be looking at for purpose A and purpose B, so forth?
That they would be factors that would restrict or contain. So that's one of the illustrative features.
And you were asked some questions about, we won't go back into the inspector's report, you remember you were taken to some points about the inspector's underlying reasoning, ARUP, reference to ARUP and all that kind of stuff, and it was said to you, well, there's nowhere in the Secretary of State's decision where that reasoning is disagreed with. Do you remember that line of questionings? But that reasoning in the inspector's decision which you were taken to, which informed her conclusions on purpose A, did the Secretary of State agree with her conclusions on purpose A?
No.
Thank you. Now, final question, I think, or final couple of questions. Yes, you were asked some questions about going back into the purposes, general approach, I think, and do you remember you had a little debate about, I think you were both telling each other you were being circular at one stage. I got slightly lost, but the debate, I think, was, it was being put to you that really the issue is the land is just greenbelt. It's not really a landscape character issue, it's just greenbelt, and you're being circular by... And you said, well, that's not really answering the question. I just wanted, and you said you have to look at each particular case and characteristics. Can I just understand what you were saying there, just so I've got a clear note of it? It was said to you that you were just saying it's just greenbelt, and that's circular.
No, I wasn't, and that's not what I set out in my proof or in chief. What I've looked at is, I've looked at the question as to how is the site contributing to purpose A, and I've looked at illustrative features as listed in the PPG and other considerations including the role of the landscape in understanding how the site contributes to that purpose.
Now, it was put to you quite forcefully on a number of occasions. You shouldn't be doing that. It's not relevant landscape character issues. Can you just take again Mr. Allen's proof and what he's done? I just want your view on this before we hear from Mr. Allen. But again, Mr. Allen's proof, when he's doing this exercise, his 6.6 of his proof on page 21, he's in the policy assessment of purpose A at that stage. 6.6 and 6.7, he's bottom of 6.6, you see he's talking about features, he's talking about the existing built-up boundary of Radlett forms the western boundary, which together with the presence of the school have an urbanising influence across the site. Overall, there are multiple factors which fall into what the PPG envisages are features that weaken the land's contribution. So how do you understand him to be dealing with part of his analysis of purpose A? Is he using character issues or is he not using?
Well, he seems to be taking a similar approach to me in that respect, albeit we've reached different conclusions.
But found it obviously a different view as to character than you take.
Yes, yeah.
Which found his conclusion.
Yes.
All right. So do you think you were being circular, or do you think Mr. Allen's being circular?
I think we're approaching it in a common way, at least in that regard.
Thank you. Thank you. So those are my questions. Thank you very much.
No, I don't have any questions. Thank you. Okay. That brings us up to 12 o'clock. Thank you. So if you give me one moment. It's an opportune moment to have a break now before hearing evidence from Ms. Scott this afternoon. Shall we have a break until 1 o'clock? Everyone's happy with that? Yeah. Okay, good. Thank you. I'll adjourn there until 1 o'clock.
Thank you. Just to recap very, very briefly for those who may be online now who weren't able to watch when we recommenced a little while ago. Mrs. Scott has been introduced to the inquiry. Her proof of evidence is available online, and she read back to us the key points arising from her conclusions in section 7 of that proof of evidence. We were moving to discuss purpose A of the Greenbelt, which is set out, her analysis of that position is set out on pages 17 of the proof of evidence. And in relation to paragraphs 6.13 and 6.14, Mrs. Scott, you've been reminding us about your view about the absence of physical features that could restrict or contain developments, looking at the context and nature of the minor roads themselves and the Radlett plantation and what the future might hold in relation to that plantation. And you made the point, this is just about where we got to, that whilst it's clear to your view that there has been large areas of deforestation in the recent past, there is no obvious evidence of saplings being visible on the land. Now, in relation to that, and therefore what the medium to long-term position might be in relation to the commercial plantation, do you have anything to add to that position by reference to the sale materials that have been attached to the evidence served on behalf of the Rule 6 party? It's in Appendix 1 to your proof of evidence. Well, Mrs. Scott, let's put that to one side just for the moment, because there may be further information in relation to that. But if we focus on Appendix 1 to your proof of evidence, the Woodhall estate plan and marketing details there, and we can see in the normal way various plots have been identified on the Savills plan. And so in terms of what that might indicate in relation to the medium or long-term future of the commercial plantation, is there anything that you want to add to your existing evidence on that point?
I would like to point out that a large part of this woodland plantation are shown as areas for sale, and that they are the sales particulars did suggest that these areas which are for sale, which include other areas other than the woodland plantation, that they would provide development opportunities for residential development in regard to the significant need for new housing developments. It does include the woodland plantation.
Thank you. And then in relation to purpose A, it's 6.15 of your proof of evidence, you've remarked on the effect that this proposed development would have on the pattern of development should it be permitted, and you've described that as being incongruous, applying the words that are used within the PPG for the reasons you set out. It will result in built development extending significantly further into the Greenbelt, away from the triangular section of open land to the south of Theobald Street. Now, the inspector was shown a plan indicating that position yesterday when Miss Brown was giving evidence. So, again, that's part and parcel of the Rule 6 party's evidence. Is there anything you wanted to add in relation to that point?
Sorry. About the area of land, yes. Yes, I would like to point out that in the 2024 plan, the Hertsmere Council were not proposing to allocate this site, but they were proposing allocations of other sites, which, when you look at the allocations that they were showing, were very much rounding off the areas of settlements in the area rather than extending further outwards. So they did concentrate very much on areas which could be rounded off. And they did actually include the triangular site adjacent to Theobald Street, the open land, the triangular L-shaped land. So that, you know, this might be developed anyway. It was allocated in the 2024 plan, but obviously the consideration of grey belt now has to be considered, you know, in terms of allocations anyway. Got something more to say about that. Yes, a lot of these allocations have actually now come, the allocations shown in the 2024 plan. Yes, I wanted, I don't know if this is the right time to say, but I know one of the questions which were Mr. Strood was asked was saying that now the allocations are showing much less development than had previously been proposed. And therefore they wouldn't be providing as much as a result of this. But the reason for this was that the area, the population growth in the area was reassessed prior to the 2024 plan. And this was a report prepared in July 2023 by Iceni, and it's the implications of the 2021 census on Hertsmere's housing needs. And this did show that the population growth of Hertsmere wasn't as high as it had been previously, and therefore the need for housing had been reduced. So it does actually include, and well, that's why they were showing less housing basically. But it does, I can provide this as evidence if this would be helpful.
We may not need to go into the detail of that material, but that's one of the reports that, to your knowledge, was informing the 2024 Regulation 18 version of the plan that we know is not now being carried forward.
Yes.
But it was part of that evidence base, updating the position. And as you've indicated on your assessment of how Radlett was treated, and in particular this edge of Radlett was treated, there was an alternative site that was proposed that was much more akin to a rounding off of the settlement than, in your judgment, the appeal site would be. Yeah. Thank you. Then if we turn to the discussion in relation to purpose B, that's in your proof of evidence 616 going through to 622 on the following page. And as part of that, you have, applying your judgment, and you tell us, reached the conclusion that the appeal site would represent a substantial part of the gap between Radlett and Boreham Wood, and you've explained why that is. You set out at paragraph 6.17 two paragraphs from Inspector Fagan's decision, and you refer there in paragraph 21 to his assessment that the existing gaps at 1.7 kilometres, which is the gap that we're interested in, is a relatively small gap between settlements. And I take it from the fact that you've incorporated those paragraphs that you agree with that assessment in relation to the nature of the gap. And we know, because you tell us in 6.18, that since that appeal decision, since his decision, planning permission has been granted 16th of November 24 for up to 110 dwellings at Organ Hall Farm. And we now have the illustrative master plan that was given to the inspector this morning in relation to that. So if you just cast an eye over the illustrative master plan, are there any further observations you wanted to make in relation to that? Because I think the point that was raised against the distance that the Rule 6 parties calculated between the red lines of Organ Hall Farm and where the appeal site would stretch to is, well, the actual built development of Organ Hall Farm will only extend 60 metres further north from Borehamwood. Do you have any observations about whether or not that is a full assessment of the way that will happen on the ground and the way that it will be perceived?
Well, the actual the site area is considerably larger than was shown in terms of the distances shown on the, for example, the statement of common ground. And I believe that that you need to consider where the site begins, not where the built development on the illustrative plan begins. And I believe that when you get to this edge of the site, just getting it the right way round, it's the the northeastern edge, where the area is shown for public open space on the site, on the illustrative drawing, that the character of the area will significantly change. It will no longer be pasture land, it will be maintained public open space. There is an access into the public open space. The actual details of the public open space may change. We don't know whether the footpaths will be lit, but it will be a maintained area, and it will be definitely perceived, in my opinion, as part of the development, whether or not the development is only at the other end of the site. You'll still get the perception of the start of the development at that point.
Thank you. And so in relation to that, you've noted at 6.19 we have the L-shaped parcel that we've just seen, and the site area is approximately 8.79 hectares in relation to Organ Hall Farm. Now, 6.20, you've given in figure 7 the 900 metre gap, red line to red line, as now it exists, and overall those features of what would happen on the ground have led you to the conclusion that the site does strongly contribute to both Greenbelt purposes A and B.
Yeah.
Thank you. So in relation to the other points from your evidence, we've got a point about the provision of accommodation and the weighting that you've given to that. Now, you gave the provision of market housing significant weight based on the accepted difficulties in the housing land supply that the council has faced, and we've heard information about the housing delivery test as well. But in terms of the evidence that's before this inquiry, I think you wanted to make reference to some of the material that, and so apologies because this isn't a document you'd necessarily have immediately to hand, I should have forewarned you about it, but we have copies if it helps, just for speed. It was attached to Alison Rubinson's representations,
Yes.
I
I think it was
to
Appendix 2.
Appendix 2, thank you, and it's a table that she has put together in relation to what has happened recently in the locality in terms of housing developments and things that are, to use the colloquial term, in the pipeline. So
Will you hold it up while I see it, so I can remind myself I've seen it before, because I have gone through. Is it a table, this one?
yes,
Yeah, okay.
Would you like a copy?
I can make a note of it and I can find it in my file for later. I've got a note for my record.
if anyone
I've
else
seen it,
would-
I've recognised what it is, thank you.
Sorry? Would people like copies?
it was attached to the representations that were made. We understood that it had been.
Shall I hand round the copies? Would be helpful.
Yes, why don't we do that? because this plainly is material the inspector has seen and is going to be asked to take into account. So.
There were lots of representation.
No, these are the representations. Now, Mrs. Scott, as I say, this is material that Mr. Rubinson put before the inspector, and he's being invited to consider. I'm going to take it at a very high level for present purposes, especially in light of the fact that it's only recently been circulated around the room. But from what you have seen on that table, we know that it's in no sense a formal assessment of the housing land supply position, and it's not intended to question the formal documents that the council has produced in that respect to say that they are methodologically wrong or anything of that nature. But what it is intended to do, I think, is to give the inspector some more information and perhaps a slightly different insight as to the level of development pressure there has been recently and what that might translate into the relatively near future in terms of housing development. Now, if we look at it in broad terms and in that way, what observations would you make about that document?
Well, it does show that there are a significant number of applications which have actually been either approved, as I've shown in yellow, this is residential development obviously, or in orange, which is in the pipeline. So there's more in the pipeline than there is being approved, but there have been 876 dwellings approved in the last 2 years, and 11,029 are in the pipeline. When I say in the pipeline, they've been applications submitted to the local authority. So these are sort of active applications.
I think as well as applications submitted, it may well include the strategic side that the authority has been pursuing, and some other further development opportunities.
Yes, the 5,000 dwellings in the new town, Bowman's Cross. In total, this comes to 11,905 new dwellings, which is quite a significant part of the housing target of 18,500.
On that, in terms of the local planning process going forward, plainly things are at an early stage in that respect, as we heard, in one sense, but in another sense, we also know that this local authority, like so many other local planning authorities, is now moving swiftly to meet the December deadline at the end of this year, because if they don't, there are consequences in terms of the kind of plan that they're going to need to bring forward. So we see that that's what the authority's aspiration is. Therefore, when we look at reasons why one might think there could be an improvement in relation to housing land supply in the relatively near future, the local plan has its own LDS, but also in relation to a local authority that has significant areas of greenbelt land, if this authority does what it needs to do, which is to prepare an assessment in relation to greenbelt and greybelt land for plan-making purposes, and let's say there is an assessment that some of the land is greybelt land and is proposed to be treated accordingly in the local plan coming forward, is it necessary for developers? Because developers often say, well, in greenbelt authorities, we effectively need to wait until the local plan is adopted, because until that point in time, we've got to show our very special circumstances. In relation to the grey belt designation, would that necessarily be the same position?
Well, there needs to be an assessment by the authority or by somebody acting for the authority on green belt and grey belt and what land could be regarded as grey belt. And once this assessment has come through, I don't think you necessarily have to wait until the plan has been adopted. I think this is likely to result in more applications coming through on land which has been allocated as grey belt.
Thank you. Now, next, I wanted to turn to the weightings that you have given to other matters within your assessment, and you've set them out in detail in your evidence, and you've given reasons for why you have ascribed the weightings that you have. So I don't want to take long, as it were, in relation to those questions, but on affordable housing, you accept, again, that that should be given, I think, a significant level of weight due to the presently low levels of provision of affordable housing. But in terms of the Rule 6 party's position, do you have any other observations to make about the extent to which affordable housing as defined by the government is really likely to assist in this locality?
Well, the problem in this locality is that house prices are exceptionally high. I think that on average they're about 1.5 million, which, and for 3-bedroom houses they're about 1 million. So they are exceptionally high. And although the affordable housing which is being offered will be in accordance with government guidance and in accordance with the affordable housing strategy provided, SPD provided by the council, in reality it might not be that affordable to a large number of people who are in significant need, particularly key workers, people wanting starter homes. Though there'll be at least 20% reduction in market housing. This doesn't necessarily make it terribly affordable for those who just cannot meet that sort of price. So there'll be still a significant amount of housing need, and it is very difficult to resolve that unless it is development which is truly affordable. In fact, I'm actually dealing with, I live in a rural environment, and we have done a neighbourhood plan for our area, and we are actually providing affordable housing which is truly affordable in our area, and we are in quite an expensive area as well. So it's about 50% of the market housing.
Now,
I'm not saying that this should be, because it does follow government guidance and the guidance of the SPD. But that is my view anyway, and the view of the parish council.
And in terms of the land for school expansion, you've set out why you consider that that isn't a benefit to be given any real weight in the circumstances that currently arise here, and you summarise those again orally. In relation to the delivery of the new medical centre, it now appears to be, as a potential update or refinement of the appellant's position, that there will be a cascade agreement in effect, so that if the medical centre isn't taken up within a period of time, that land can be used for further affordable housing provision. Do you have any observations in light of what Ms Brown said about the overdevelopment of the site and the way the density is being applied that might apply to the land that would otherwise go to the medical centre, or is it too far removed in terms of detail to offer a view about that at the moment?
It's probably too far away, but I mean, I think you have to consider, for example, whether more think it's being probably offered for more affordable housing. I think it was about 28 dwellings. It was calculated. I believe that was a figure shown. So obviously that will be helpful. You know, I can't say we don't want more affordable housing, because it was very clear when you listened to the committee report, the planning committee, how important it is for them to have more affordable housing. But there is the problem that there would be still increasing the density of development on the site as well.
Now, let's assume, for present purposes, that the level of affordable housing remains at 50%. That is the minimum requirement in order to achieve compliance with that element of the golden rules. There are still other elements of the golden rules that would need to be satisfied by this development. Two of them are potentially in question here. The first is in relation to the nature of the infrastructure and open spaces that are provided on the site, and we heard Ms Brown's evidence on that yesterday in relation to whether or not there would be in a meaningful sense a situation that was landscape led, where there was an integration of those open spaces so that they provided good quality provision. Do you have anything that you wanted to add to her evidence, or if not, what does her evidence and conclusion mean for your planning analysis?
I mean, Ms Brown has a considerable amount of experience in dealing with sites of the type, you know, where we're looking at sites on the edge of settlements, for example, where you have to consider the golden rules and how it meets with the golden rules. And in her opinion, and in my opinion, it needs to be more than just providing a small area of public open space, which would be necessary for any development, even if it was in the centre of the town. For a large residential development, you would need to provide an area of public open space. And the area of public open space being shown is only sufficient to allow for the development. To meet the golden rules, in my view, and in Mrs Brown's view, it is necessary to create much more of a landscape setting and a landscape structure to the site, a landscape-led development, and a large areas of open space, which this scheme does not provide for. And I think that it could be, well, we wouldn't be able to achieve as much development on the site, that would be certain, but it would address the important reasons which have been introduced as part of whether development is, whether it's appropriate development, is whether it meets those important green space standards as set out in the golden rules. And in my opinion, it does not meet the golden space standards, which would be required.
Thank you. I'll jump in there, Mr Buglin, if I may. So that's your opinion there based on the evidence before you now. So this is an outline application. Could that be, to your mind, rectified in the reserved matters?
Obviously, you could provide more open space, but it would involve the need to, if you wanted to achieve 195 dwellings, it would mean that the density of the built development would have to increase in scale. The other thing which, I don't know whether it's probably appropriate at this point in time, is to mention about the pedestrian routes through the scheme. This does not accord with the policies of the Radler plan for the provision of public linkages, pedestrian linkages with the footpaths of footpath 55 and footpath 54, and the illustrative layout does not show as good a footpath layout as could have been provided by linking into footpath 55 and also having the footpath going further west to link and round the Theobald Wood, the other end of Theobald Wood, to link with footpath 54. And that is shown in the Radlett plan.
So that's core document 3.7, and it may be page 63 that you wanted to draw attention to.
That's correct. It's page 63 of the Radlett plan, which provides a suggested pedestrian route, which you don't necessarily need development to provide this route, but this is one of the policies of the plan, is this improvement of the pedestrian routes in this area. And you'll see that it links directly to Shenley Road, Williams Way, she's not, that is Williams Way, yes. And then it comes around the edge of the woodland and then goes sort of north of Theobald Wood and comes out directly opposite footpath 54.
This
rather
is
than
figure
the scheme as
19B.
shown, which comes out much further east, and therefore you've still got to walk along the road to then connect with footpath 54.
Thank you. I wanted to go back to the inspector's question about the capacity to address this issue satisfactorily through the reserved matters. And you obviously seen Ms Brown's proof of evidence. You heard the evidence that she was giving yesterday about the level of development on this site and how, in her judgment, it would preclude there being compliance with the golden rules in that respect. Have you seen anything, or do you take a different view about whether or not the level of development here is such that it precludes the ability at the reserved matters stage to really address this issue in a satisfactory way?
Well, I agree with what Ms Brown said in her evidence yesterday, that the amount of development being proposed would preclude the provision of an acceptable level of green space.
On that, in terms of this scheme being promoted since the new MPPF has come into force, and we spent some time yesterday looking at paragraphs 155 through to 159, so I'm not going to repeat that exercise now. We also looked at what the views about place services have been, which were in material respects similar to those that Ms Brown had offered. Have you seen anything in terms of the revision or refinement of the scheme that was directed either at securing compliance with those requirements of the golden rules, now cognizant of them, or anything that was designed to secure compliance with what place services had offered in their advice?
Well, the scheme which is being put forward is virtually identical to the one which was considered 3 years ago, same amount of development. And they have the applicants were shown the views, were advised about the views of place services, that decided that they didn't want to make any alterations to the scheme to resolve the problems which place services were saying would need to be resolved for them to be able to support the application. So though place services didn't object to the principle of development, they did not agree to support the development because of the problems with the lack of landscaping and the fact that the issues which had been raised by the inspector had not been resolved.
Now, part of the development plan that we have in relation to assessing the way that development might or a satisfactory form of development that might come forward locally is in the neighbourhood plan, and you drew attention to one policy there. Another policy that is mentioned in the evidence on behalf of the Rule 6 parties is at page 39 of the Radlett neighbourhood plan, and that's the section that deals with townscape and landscape character.
Yes, indeed.
And again, the inspector will have had the opportunity to consider this and the accompanying documents, the character assessment and the design code. But in terms of the more general requirements to reflect and respond positively to the local townscape and landscape character, following on from Ms Brown's evidence, in your assessment, does this proposal comply with that element of the development plan?
No, it does not. The policy intent is to meet new housing demand in a manner that is sensitive to the character of the area, and policy HD3 of the Radlett Neighbourhood Plan states that development proposals are required to reflect and respond positively to local townscape and landscape character. Development within the settlement of Radlett should have regard to the Radlett character assessment and the Radlett design code. And all developments must respect local character and residential amenity. And they also have a policy in their addendum about the bungalow areas as well, which is a much lower density as well.
Yes, and the inspector will have had the chance to
Yes.
see the bungalows on
And they are of
Dagenham
local
Close.
townscape importance, the bungalows.
Thank you. And so in terms of, sorry, I may have missed part of your answer there, in terms of compliance with that policy, how do you say that the development measures up?
No, it doesn't comply to that policy, no. Which is the problem of increasing the density in terms of height and scale. It would even make it even worse, because you would have to increase the height of the developments to accommodate the number of dwellings being proposed and the other matters being proposed.
Thank you. And then another document that we were able to introduce to the inquiry this morning is the LNRS map, which shows the focus area in consideration that has recently been adopted. Now, although this has recently been adopted, obviously been in the works for a little while, and if we pull that map up, if you've got a copy of it there, tell me if I'm wrong about any of this.
So, just find it. It's the map I want. Hold on. Certainly got it somewhere.
Mr. Scott, if you can't immediately find it, I have another copy here. And so in terms of what we can see here, we see that the focus area where there is colour, and amongst that we can see half of the development site just about moving into this focus area on the LNRS mapping, and we can see from the key at the side that action 3 in relation to a brown area that affects, amongst other places, a significant proportion of the appeal site, that the action is to create more good quality neutral grassland. Right. Now, in terms of what the proposal will do or achieve, is that something that's going to be beneficially affected or adversely affected on the site?
The development will be adverse to this local nature reserve. Getting tongue twisted now. But it won't achieve this nature that you're going to help me here, preservation strategy. Because it doesn't allow for this at all. No account has been taken of providing for the local nature reserve. So it cannot be. The development as proposed does not provide for this, and it should be provided on site wherever possible. And this development could provide, though this particular development couldn't provide, it hasn't been designed to provide for this.
And so that's your understanding of the way the guidance works, that if it can be provided on site, that's what should be done. And
Yes,
so one
indeed.
needs to look at this, whether the circumstances is or are that it cannot be provided on site.
Yes.
By, for example, if there'd been a refinement of this scheme.
Yes.
And
It cannot
have you seen any attempt to refine the scheme or otherwise meet what was coming down the track in relation to these kinds of requirements?
I would have expected the appellant to have considered this because it was something that was emerging for quite a long time. It is now adopted policy, and it clearly has no account has been taken of it, and this does show the need for improvement of grassland as well as woodland. The brown is improvement of grassland and the green is improvement of woodland. Even if you were to put it in the gorse area, which I think the gorse is the main area for the biodiversity net gain, that doesn't have grassland. And it should, if it can't be provided on the site, should be being provided within the area shown grey, in that that is the London connectivity area. It should be provided in that area, but ideally on the site itself.
Lastly, in relation to compliance with the golden rules, there's a test in relation to sustainability. Now, on one view, of course, this would be an extension to Radlett, the development site, and Radlett occupies a relatively high place within the settlement hierarchy overall. The Rule 6 party takes a point in relation to the sustainability of this site by reference to its particular locational characteristics. So, in that respect, what do you say are the characteristics here that lead one to the conclusion that, notwithstanding where it is as a potential extension to Radlett, it remains not sustainable in terms of applying the golden rules?
Well, in my opinion, the site is not sustainable for reasons that it is not within easy walking distance of the town centre or the Radlett station. And I think there was a rebuttal by Philip Allen in respect to this, where I think he accepted that it wasn't within easy walking distance, but it's not only not within the normal 800 metres walking distance, but this particular walk is particularly difficult because it's a very steep incline, and along Shenley Hill it is not a particularly safe or easy way to access the site. So in my opinion, most people wanting to access the site would be going by car. I know there are bus stops, but the frequency of buses is not very great. And I think the tendency would therefore for people to use their cars rather than to walk or to cycle or to use public transport.
Mrs. Scott, thank you. I think that's all I wanted to ask you by way of examination in chief. Is there anything else that you wanted to say before I hand you over to the appellant?
No, I don't think so. Thank you.
Thank you.
Okay, Mr. Warren, do you want a short break before cross-examination, or
I don't need one, sir. No, I don't know whether
Happy.
Mrs. Scott needs a break. No, she's fine, I think. We'll
Thank
carry
you.
on if you're happy to. Yeah, thank you. Afternoon, Mrs. Scott. You were obviously a witness at the last inquiry, weren't you? The decision letter, 26th of January 2024. And you'd recognise as a planner that since then we've had a new government, and the MPPF of December 2024 introduced grey belt, which as a matter of green belt policy was quite a new turn, wasn't it? It was a brand new concept. Yeah, yeah. Okay. And we know, don't we, that the definition of grey belt, we can look at it if necessary, but the definition of grey belt turns on whether the land in question does or does not strongly contribute to purposes A, B and D.
Yes.
That's right. I don't think you're taking a point about D, are you, on
No.
behalf of the parish? No. In terms of strongly, the new policy then that the government brought in December 2024 was very different, wasn't it, to what was there before? Because, if you like, subject to the other points about infrastructure and golden rules we'll come to, in terms of the principle of it, land in the green belt wasn't subject to the same protection anymore unless it was the best green belt land, the strongly performing green belt land. That's right, isn't it?
Yes.
Yeah. All right. And the in terms of the, can I just take you very briefly, so I won't do this at great length, but would you mind just having the MPPF of 2024 open, please? CD 3.6, obviously in our current document set.
So which section?
So if you go to the Greenbelt section and go to paragraph 155, so that's PDF page 44 or 45, I think.
Yes.
Yeah. And so this is the grey belt policy, if you like. So it won't be inappropriate in the green belt where all of the following apply.
Yeah.
And the first is obviously grey belt,
Yeah.
which we'll come back to in a second. But again, just be clear, on behalf of the parish, you're not advancing a case that the development of the site would fundamentally undermine the purposes of the remaining green belt in the Hertsmere area, are you?
No, I'm not advancing that. However.
No, I thought, just matter of fact, you hadn't said that before, so I'm grateful for you confirming that. In terms of the second of the criteria there, B, I think you accept, don't you, there's a demonstrable unmet need for residential accommodation?
Yes.
Okay, and I'll come back to sustainable location C in a moment, and D is obviously the golden rules. Now, the golden rules requirements are referred to, aren't they, in D? Do you see? Where applicable, the development proposed meets the golden rules requirements set out in paragraphs 156 to 157.
Yeah.
Yeah? So the government tells us, doesn't it, when it refers to golden rules, where the requirements to comply with them, to benefit from golden rules are found. And they're in the next two paragraphs,
Yeah.
you see. So the government doesn't say, does it, that paragraph 159 is a requirement to meet the golden rules, do you see?
if paragraph 1.59 explains what the improvements of green spaces are required as part of the Golden Rules.
Yes, except
So it is relevant
yeah.
to
Okay.
156.
So to just go back to my question, D is, it's not inappropriate if it's A, B, C, D, where the development meets the Golden Rules requirements
Yeah.
set out in paragraphs 156 to 157. And then we have them, don't we? 156 has A, B and D, Golden Rules, affordable housing, infrastructure, green spaces. And 157 tells you more about the percentage of affordable housing in the particular case, yeah? And then after that, you have 158, which says if you comply with them, then you get significant weight in favour of the grant. So it's a consequence, isn't it, 158, of complying with the Golden Rules? Are you with me?
Yes, that's in relation to the weight to be given.
That's right,
to be complying
once you've
with the
complied with the Golden
Rules.
Rules. But the document actually tells us, doesn't it? The government actually tell us in 155D what the requirements to meet the Golden Rules are. They refer, don't they, expressly to what we find in the following two paragraphs, 156 and 157. Do you see?
Well, it goes on in 159 to explain what is required to meet the Golden Rules in relation to green space
Yes.
as well.
But if the Golden Rules requirements, in order to qualify, included 158, well, they don't obviously, 159, then the government in 155D would have said, where applicable, the development proposed meets the Golden Rules requirements set out in paragraphs 156, 157 and 159, wouldn't
That
they?
just sets out
Yeah.
what the requirements are, and the requirement at 156C is the provision of new or approved improvements to existing green spaces that are accessible to the public. New residents should be able to access good quality green spaces within a short walk of home, whether through on-site provision or through access to off-site spaces.
That's right.
So that's what it says.
Just pause there, though. Just pause there, Ms. Scott. 159, just to help, isn't about, is it, new existing green spaces accessible to the public or short walk of the home. It's about other things. It's about landscape setting and about local nature recovery objectives. Do you see? It's not about the things that are referred to in 155C. Are you with me?
But this is all part of the improvement of the green spaces.
Well-
It explains further what is considered required in order to accord with the Golden Rules.
Yes, I'm afraid we just disagree about the interpretation of
have
that
to
paragraph, Ms.
disagree.
Scott, and I've put the point to you. Did you just come back? I asked you twice. I'm going to ask you once more. 155D says, doesn't it, where the development meets the Golden Rules requirements, and it's set out in paragraphs 156 and 157. It doesn't refer to 159 there, does it?
Not at that stage, no.
Well, it doesn't refer to it there. And can you see that 159, just go back to 159, just read it normally. The improvements to green spaces required as part of the Golden Rules. Yeah?
Yes.
So the green spaces are required, aren't they, as part of the Golden Rules? We know
Yes.
about that, yeah? So the improvements to green spaces required as part of the Golden Rules should contribute and should do a couple of other things. So
Yes.
if you've got an open space and it's the one that gets you within the Golden Rules, it should do these things
Yes.
as well. Not to qualify, because it's not a requirement of the Golden Rules, but these are freestanding government objectives as well on top, aren't they? That's what 159
Well, they're
means.
explaining what is expected in relation to green spaces.
Yes, but not any. I've put the point, so I won't go around it again. We'll extend it unnecessarily. But again, I think one has to read this all as a whole. I think there's another reference, in the paragraph, footnote 30, thank you. Footnote 30 in the MPPF, just go, it's in the plan making section, I think, isn't it? PDF page 18, is it? Printed page 18. Paragraphs. I'm sorry. So in the same MPPF, so I beg your pardon, I didn't make that clear. Yeah, within the framework itself, if you go up to PDF page 18, You should have paragraph 69, paragraph 70 towards the bottom of that page.
Sorry?
Paragraph 69, paragraph 70 towards the bottom of that page. Just getting you on the right page. So in the printed copy, it's page 18.
Sorry, the NPPF.
Yes,
Sorry.
I'm staying with the NPPF.
Yes, I've got that. Which paragraphs?
So in this
Golden Rules 67, yeah.
in this section, that's right. So if you go up to the top, I was just giving you the page, getting you to the right page. If you go to the top of the page, there is a paragraph which deals with a provision of affordable housing, paragraph 65. Do you see?
Yes.
Any affordable housing requirement should be reduced by a proportionate amount. Footnote 30, do you see? Mm-hmm. And then it says, footnote 30, equivalent to the existing gross floor space of the existing buildings. This doesn't apply to vacant buildings which have been abandoned or to major development on land within or released from the green belt for which the Golden Rules requirements set out in paragraphs 156 to 157 of this framework should apply. So
Yeah.
it's the same as 155,
Same, yeah.
C itself, reading it consistently across the whole document. This also tells the reader, doesn't it, where one finds the requirements of the Golden Rules within the document.
Yes, the
Yeah.
requirement of the Golden Rules is provides adequate green spaces.
All right,
And
there we
then
go.
there's clarification of that in paragraph,
Yeah.
is it 159, and also in the PPG.
Yeah, so your approach, as I understand, I've put the point to you as to why we say you're wrong about the interpretation of the NPPF, but your approach has been that 159's requirements are also part of qualifying for the Golden Rules. That's what you think it means. Okay, well, I've put to you why we say you're wrong about that, and you've given your answers. All right, and then just dealing with the local nature recovery. Sorry, let's go back. So I'll just skip over it. Let's go back and do it properly. Go back, please, would you, to 159, paragraph 159.
Yes.
Improvements to green spaces required as part of the Golden Rule should contribute positively to the landscape setting of the development. Yes? Mm-hmm. So what's the development there? That's the development that's being proposed and released under the Golden Rules, isn't it?
Sorry, would you repeat?
Yes. The improvements to green spaces should contribute positively to the landscape setting of the development. That's the landscape setting of the proposed development,
Yes.
isn't it? Been consented, right? Okay, thank you. And then support nature recovery, meet local standards for green space provision where these exist in the development plan. It talks about locally specific standards. So support nature recovery. And then the last sentence, where land has been identified as having particular potential for habitat creation, ... within local nature recovery strategies, proposals should contribute towards these outcomes. Now, just on the face of it, the policy there that the framework includes doesn't refer, does it, on its face, to the development site in that sentence. It says where land has been identified as having particular potential, proposals should contribute towards the outcomes. Yeah?
Doesn't say so in this sentence.
No,
as
that's
such.
I'm just asking you about the sentence. Well, that was the answer to my question. Go on. So my question was, it doesn't say in this sentence, does it,
No,
that it's just the development site? That was my question, which I think you answered. Do you want to say anything else about some other point I didn't ask you?
Says it should be on site if possible.
Well, yes, it doesn't say on site where possible in this sentence, does it? No. And obviously this sentence is about, isn't it, proposals contributing to nature recovery strategies on land which has been identified for those purposes.
Yes.
Yeah. And that's why, obviously, we've given the inspector this drawing, the A3 one, sir, which shows the off-site areas which are bound in as part of this proposal, looking at neutral grassland improvement and improvement to woodlands in areas which are indeed identified in the LNRS for improvements. You see that?
Yes.
Yeah. Okay, so land identified as having potential, here it is, some kind of browny orange, some reddier orange, different types of habitat. Proposals should contribute towards those outcomes. We've got the proposals which are part of this scheme through the 106, haven't we? Yeah.
Offsite.
So a compliance with meeting, contributing towards outcomes on land which has been identified for those purposes within the LNRS, correct?
Yeah, but it doesn't meet the requirements of the local nature recovery plan, which state that it should be on site if possible.
Right, if possible. Okay, if possible. So I don't think your case is that there is a planning policy which requires the local nature recovery strategy indication to be complied with in order to be acceptable.
Yeah.
Okay, thank you. This was adopted, I think, in quite recent times.
It's very recent.
Very
yes,
recent.
but it's been emerging for some time.
So
I was aware
okay.
of that plan prior to it being adopted.
Yes, I know, but in terms of how much weight should be given to it, and your point about why doesn't the scheme take it on board, obviously the scheme was refused months ago by the local planning authority,
yes.
and obviously the scheme has come forward before, hasn't it? The NRS was adopted.
Yes, but it was emerging before.
Okay, well there we are.
It wasn't adopted.
It wasn't, no. Just looking at your helpful focused image that looks at the site and the immediate surrounds of the site, do you understand why there's just what appears to be a relatively arbitrary line just drawn across the site from one side to the other?
Not clear exactly, but the line, which is mainly the area coloured grey, is within an area called the London Connectivity Area.
Yes.
And the area to the east of that, which is the other half of the site, is within a different area called the Glades or some Blades or Glades.
Right. Okay.
So and if it can't be provided on the site, then it should really be provided within the same areas. I understand the policy requirements of the nature recovery
yes,
strategy.
I'm not sure that the local nature recovery strategy says anything like that, Mrs. Scott, to be fair. I don't know what you're referring to there. Which bit are you saying? If you can't do all of what's indicated on this drawing, it has to be done somewhere else in the relevant area. I'm not sure. I'm not sure that's I don't think I've seen that reference.
Oh dear.
I mean, I can take you to the PPG if you like, but I'm not sure that the LNRS. Yeah. I mean, should we look at the PPG, core document 3.9?
Yes, I need to get
Yeah.
that.
Tells us a bit more about how to approach this question, I think.
Sorry.
No, don't worry. Are you looking for the PPG?
Yes.
Okay. I mean, it is in the core documents on the screen if that
Okay,
helps.
I'll find it on the screen. Hold on. What?
It's core document 3.9. 3.9.
Yes, that wasn't the one I was thinking of. I don't think there's anything in this that's going to be particularly helpful. There is a new...
Have you found the
yes,
the PPG?
I have found
okay.
that.
Go in it, would you, to the bit that
Yeah.
deals with the local nature recovery strategy paragraph, which is I think the paragraph 2 from the end, 6412. It's got a heading. It's on PDF page 10 of 12, and it says, how can major housing development on land which is released from the green belt through plan making or on sites in the green belt contribute to accessible green space? Do you see that? So it's talking about...
Yes, yes.
And it says the following contributions to accessible green space should be considered.
Yes.
you see. So you know how that's put, yeah?
Yeah.
New residents, wider public should have access to good quality green spaces, which is safe, etc., sets it out. Accessible green spaces are areas of vegetation, a bit more detail about that. It talks about access to them. And then again it says proposal should consider how the creation or enhancement of existing green spaces can contribute to the priorities for nature recovery set out within the ALNRS, you see. So it doesn't say proposal should or must, let alone must meet, the quantum, for instance, or the areas within a site in order to comply with policy or guidance, does it? It's much looser than that.
No, it says should consider.
Yeah, should consider, exactly. Okay. Well, the inspector can read it. So it should consider how. Because one of the things that we need to bear in mind in terms of this LNRS document is it's identifying areas that could be improved, isn't it, as we went into earlier in the inquiry. It isn't saying we've done an ecological survey, there's a need, if you like, for X hectares of this particular thing and Y hectares of that other kind of thing, and here's where we think they should be provided. It's much more looser and more prospective than that. Here are some areas which we identify could be improved, and the guidance says, please consider how you might do that. Yeah, okay, all right, there we are. Okay, thank you very much. Let's move on. I'm not going to ask you very much at all. You'll be pleased to hear about Purpose A, but since we're in the PPG, would you mind just going up to the famous table, which is on page 4, PDF page 4. Purpose A, to check the unrestricted sprawl of large built-up areas.
Yes.
Yeah, heading. And again, I'm not going to go over it, but one of the things that the government identifies is that assessment areas contribute strongly, are likely to be free of existing development and lack physical features in reasonable proximity that could restrict and contain development. And can you agree, Mrs. Scott, that the reason why that's there, that physical features that could restrict and contain development, is because the purpose is about checking the unrestricted sprawl? That's why it's important, isn't it, to see whether there are features that could check sprawl. Do you agree?
Yes.
Thank you. Okay. In terms of the facts here, I think the only point I want to ask you about is in relation to the two roads, so Theobald Street and Shenley Road, Shenley Hill, Radley Hill. The roads themselves obviously are, they're not new roads, are they? Particularly in the case of Theobald Street, they've been there a long while. I think the evidence from your group is that they're heavily used.
Yes.
Yeah. And there's no evidence.
But they're country roads. Really.
Sorry?
They are country roads.
Country roads, but they're heavily used. That's the point that's been made. They don't just back, do they, as it were, they don't just lie next to the site in clear arable fields. There are trees, aren't there, and the golf course on the Shenley hillside.
Yes.
Yeah. And on the Theobald Street side of the site, we've got that bit of, not the plantation, the other woodland that's got more ecological value, Theobald Wood.
Yes.
Yeah, okay, thank you. And there's no evidence, is there, that obviously the roads are going to go anywhere, the golf course is going to go anywhere? There's no evidence of that, is there? There's no evidence that Theobald Wood is going to be mown down at any point in the near future?
No, I think it's unlikely.
I think it's unlikely. Okay, fair enough. All right, thank you. Now, in terms of your point about the woodland, the commercial woodland plantation, that can we agree, a matter of judgment, but can we agree reasonably that that's a substantial area of land? I think it's 25.9 hectares or something like that.
It is a sizable woodland.
Sizable area of land, inspectors can see it. And in your evidence, you refer to the forestry activities that have been going on there. And you say that there have been large areas of deforestation. You give us a couple of photographs of some cleared areas.
Yes, I have many more if you need them.
Yeah. I'm not sure that you've indicated there. Obviously, the inspector can see, and one can see on aerial photographs from recent times how many, what density of planting remains there. I mean, it is still, isn't it? I think it's. Have you been there recently?
Sorry?
Have you been there recently?
No,
Okay.
I haven't this year,
This year, okay.
but I have seen many photographs.
Sure, okay. But you can see from those photographs, I take it, and if necessary, so this can be checked from aerial photographs or on the site. I think this is a correct way to put it. The vast majority of the area of the plantation is still standing, isn't it?
Yes, but
Yeah.
it is being depleted.
Okay, you say it's being depleted. It's been thinned, I think is the word that's been used, under licence, hasn't
Yes.
it? The licence has been, the existing licence has been discharged, hasn't it? Do you know that? It's been finished, hasn't it? There's no
I
further
believe
licence.
so. I haven't seen details. Of
Okay. And all I'll say, without descending to detail, is, are you aware of the fact that the licence thinning didn't cover most of the first 50 metres next to the appeal site? There's been no thinning in the commercial
I think that
plantation.
there was a
next to it.
previous licence that
Right.
dealt with that.
All right, okay. It's a commercial woodland, a forestry business, isn't it?
Yes.
Yes. And there's no indication, is there, that the commercial forestry use of that area is going to stop?
Well, if the land was sold,
Yeah.
it might stop.
Right, so you're relying on
A
that.
new owner, well,
Okay.
it would be for the owner of that coniferous forest, it would be more valuable to sell it for residential development.
Okay. I mean, you rely then.
It's
Sorry.
not-
So I said there's
I
no
don't think
evidence.
You
Let
can
me.
rely on it being the most the sort of area, the sort of type of development which achieves the most in terms of value for an owner. But so there is a possibility
Okay.
that a lot more might be felled in the future.
Okay. As you, I'm asking you about the evidence. So you rely in your answer. You said, well, it may be if it's sold, and you've given us in your first appeal, your appendix, I think, sales particulars. You're aware, are you, that the site is no longer for sale? The estate is no longer for sale. Are you aware of that?
Well, it was for sale until the end of November.
Yeah, well, but that's as maybe. But are you aware that it's not, in fact, on the market?
It might have been taken off the market
Right.
recently, but it might come back
Okay.
on the market soon.
So there's no evidence, is there, at the moment, that the site is for sale and will change and somebody will start clear felling the plantation? There's no evidence that it's going to be sold, is there?
There's evidence that it was going to be sold until very recently.
Well, that wasn't
It
my
might have been taken off the market recently, but it may come back on the
All right.
market.
But as you said, in relation to Theobald's Wood, what's likely or not, even if it were on the market, even if it were sold, cutting all this down for residential development is going to require, isn't it, planning permission and assessment,
yes.
etc., etc. And I take it that your view as a planning consultant is it's unlikely to get planning permission for residential development, the area of
At
the
this
plantation.
moment, yeah.
Yes. Right, thank you. All right. Yes, public open purpose B, I think 2 points. The first point is, are you still with the PPG? Is that still available to you on your screen? We
I
just
have a
looked, didn't we, at the
very
beginning of
irritating
purpose A, do
computer
you
that
remember?
keeps switching itself off.
Yes, I know mine does that, annoyingly.
Yes, I am.
If you go to purpose B, further down the table, assessment is strongly likely to be free of existing developments include all of the following features, and the first is forming a substantial part of a gap between towns. Now, can we agree, first of all, matter of interpretation, you're the planning witness for your clients, substantial means big, doesn't it? Mm-hmm. Yeah? A big part of the gap.
Yeah, so
Yeah,
it's
that's a
significant.
relative judgment, isn't it?
It's relative,
Right.
but I would say substantial generally means a significant part, yeah.
Yes, it doesn't say.
It doesn't necessarily say, I think it's relative.
Yeah, exactly.
It's a
Yeah, it doesn't say a
relative
substantial
yeah.
site. It says a substantial part of a gap. So a big part of a gap. Yeah. So the judgment on that one is this site a big part of the relevant gap? Yeah. That's the judgment. The question.
It's a judgment. It's, in my view, it's whether it's a significant part. I think it is significant.
Okay, I'm
It's
not asking
more-
you about, sorry.
It's not more than half.
Yeah, I mean, obviously, you'll know from your experience.
But it is all moving in the direction
Sure.
towards Boreham Wood.
I do
and they
understand.
are two major towns. And
I do understand. I'm
you
just
do not
asking you about
want
the
them
wording.
to coalesce.
I'm
It
just,
would be very important. It's very important to settlement pattern that these two towns do not coalesce.
yes, I didn't, that's fine, that's not even a qualification to my question. But the question I think we agreed on, as a matter of interpretation, the question here is, would it be a substantially, i.e. big part, relatively, of a gap between the relevant towns? So that's the judgment. The second question I've got for you about this is a specific point on the facts of this case. The Organ Hall Farm master plan, indicative master plan that you put in from the outline stage of the Organ Hall Farm consent hasn't it, the public open space in the it's rather over half, 55-60% of the site is
Yes,
public
yeah.
open space. Public open space is not inappropriate, in inverted commas, development, isn't it, in the green belt?
No, but it's being taken out of the green belt.
I know it has, because it's got consent, but in terms of what it's like and its effect on
It is open
coalescence,
land, generally. It's generally open.
yeah, but sorry, it's a specific question. Public open space, open recreation uses, or whatever it may be, are not inappropriate
No.
development, are they? No. Okay, thank you very much. All right. So just coming back quickly to golden rules, you talk about infrastructure, the infrastructure requirement, and there's a couple of points about that. You say no secondary school provision or contribution. Yes, as one of your points on infrastructure, no secondary school contribution. Yes?
Well, it wasn't part of the application. It might be contributions being provided.
No, okay.
I don't
I'm
know.
just, let me give something, make it easier. Let me give you a reference to your proof. If you go to your proof, please,
Yeah.
and have a look at paragraph 6.40, 6.40.
Yeah. Yeah.
So golden rules, major development involving provision of housing, and they require those things, A, B, C, and then you go on to talk about infrastructure at 6.45 and following. You with me? And at 6.46 to 7, you talk
Yes,
about
yeah.
educational facilities.
Yes,
And I just
yeah.
started with the second one, 6.47. No secondary schools, you say, the proposal doesn't provide infrastructure in terms of a secondary school or expansion itself, or transport connections to those schools. Now, I take it, that's all subject to, isn't it, you being aware that the Education Authority doesn't require from this in their position, they don't require such a contribution or...
No, I'm aware of that.
So it's not really an objection, is it? That
Sorry?
it's not really an objection, is it, here in terms of golden rules, that we're not providing something
No,
that we're not asked
no.
to?
Just it's a statement.
Okay. And then in terms of the primary facilities, do you see your 6.46? You say there's no current need for expansion of the Newbury's primary school, provision of additional playing fields necessitate extra costly maintenance. And again, I don't know whether you've caught up with this, the agreed position between the County Council and the appellant on that in terms of primary school land, and then a cascade, which I think you mentioned potentially of the site.
Yes.
Okay.
Yes, I'm not saying it hasn't been supported, but that's because it's a facility which is being provided on the site, obviously. It's a facility that can be provided because it's adjacent to the school.
Yes.
So it has that advantage.
Yes.
But it wouldn't necessarily be the place where you would expand primary school provision if it wasn't part of this development.
Right, you're right, it may not be, and that's why the offer which has been accepted by the County Council is to preserve the land, and if they don't take it up
Yes.
in due course, then there's a cascade to affordable housing. So again, would you accept that that's not really a point that goes to compliance with the golden rules on the facts here?
No.
Okay, thank you. All right. Sustainable development is the other point you take. And again, it's really a county council point as well as a local planning authority point. you're aware that neither of those bodies, not the Transport Authority, if you like, or the LPA here, says that the site is unsustainable.
I'm aware of that.
Okay.
Yes, I have a different view.
Officers obviously didn't say that either to the members. And I don't think Mr Fagan said that, did he either? That it was an objection to the grant of permission on the last occasion. You were here that it's unsustainable. He deals with accessibility and transport, doesn't he, in his decision?
No, he didn't.
He gave it limited positive weight.
Yes.
Yeah.
Yeah.
Okay. All right. Thank you. Your proof refers to wind turbines on the site, but I think that was just a mistake, wasn't it?
I've seen what. I can't remember whether it was Mr. Allen or
yes,
Brockhurst
Mr. Allen
mentioned. I think
in
it
his
was
rebuttal.
Mr. Brockhurst mentioned the wind turbines. Yes, I have read that part. It doesn't say they're not going to be provided. It doesn't expand on that point.
I see. Okay. Well, it's a matter that can be controlled.
I
Obviously.
think it's probably, to be honest, I think it's probably would be unlikely.
Yes.
I think it would be quite objectionable.
Yes. And anything that was a big wind turbine, etc., you think about what the description of development is here, even if it was proposed, even if it fell within the description of development, which I think is unlikely.
It might get sufficient wind.
Yeah, okay. Anyway, there we are. The inspector's got that point. It's not part of the scheme, and it details, obviously, reserved matter stage. You deal with residential. I'm just mopping up our last few points here. You deal with residential amenity at your 6.76. Sorry. 6.76.
Yes.
So this is under the heading Other Concerns of the Parish Council, and you've got, it's called Impact on Character of the Landscape, I think the heading, and then you've got Harmful Watling Chase Community Forest Point, and then you've got Openness of the site can be clearly seen from Shenley Road and the entrance to the public footway. And then you talk about residential amenity. Do you see that?
Yes.
Now, in terms of residential amenity impacts, stemming from proximity of new dwellings or proximity of a playground to residences and that kind of thing, those are matters, aren't they, that would be dealt with at the reserved matters stage, making sure that buildings aren't too close and there's a suitable set off and no privacy issues, that kind of thing.
Yes, it is,
Yeah.
but it is a dense development, and in my view, this will have a harmful impact on the properties. I mean, these properties do have a wonderful aspect at the moment,
They do.
and whilst
Right.
there's no right to a view as such, it will be harmful to these the people who live along this side of who live adjacent to this site.
Yeah.
It will affect their outlook, and there will be noise and disturbance and pollution,
Yes.
potential loss of privacy to the gardens, and there will be lighting as well. So it will be harmful to them.
Yeah, I mean, I think in terms of their view and so on as receptors, the LVIA covers them as you've probably seen in
Yeah.
terms of residential receptors next to the site. But my point was, in terms of controlling so as to make the final detailed scheme acceptable in planning terms, if permission were granted on this appeal, the authority would have control, wouldn't it, over approving, to make sure that there was not an unacceptable loss
Yes,
of privacy
it
or
would to
anything like that.
ensure that there's no undue harm.
Yes, all right, thank you. And obviously you don't present any detailed evidence, do you, about daylight, sunlight or privacy distances
No.
or anything of that kind, no? All right, thank you. And then in terms of the final balance, and I suppose this is a benefits point as well as something which goes to very special circumstances, if that is required. First of all, we know, don't we, if it is not grey belt and one's looking at a very special circumstances, we all agree, don't we, all of the planning witnesses agree that paragraph 11D of the MPPF would apply.
Yeah.
Yeah, okay. And you know, obviously, how very substantial the shortfall is, less than a year. 4,800 shortfall, you say, I think, significant, don't you, in terms of weight? That's quite a lot less, isn't it, than the weight that's been given by inspectors like Mr. Prentice, for instance.
I think the inspectors said substantial.
Very substantial, I think.
Mr. Fagan
Mr.
said
Prentice.
substantial, yes.
Yes.
I'd say I would leave it as significant. I have my reasons for considering why it is significant rather than substantial. I mean, in terms of the affordable housing, it is only 50% affordable housing. That is the minimum that is required in this case. Yeah. So it's not going above that amount, which it could have done.
Yes, I mean, on affordable, you made a point about it's very expensive to live in the area and so on, but I think towards the end of your answer you said the point that I was going to ask you about anyway, which is that the affordable housing, not just the 50% amount of affordable housing, proportion of affordable housing, but the fact that it is affordable housing would comply, wouldn't it, with the policies? Yeah. Yes, okay, yes. So it's policy compliant.
I'm not saying it doesn't comply.
No, and you said that towards the end.
The weight I give it.
Yes. And I think the difficulty with it's very expensive here and so on is essentially it's an argument about whether government policy is right, isn't it, rather than complying or otherwise with government policy. We're not really in the business, I think, at a planning inquiry of debating whether government policy is right or not. Okay. And just in terms, so affordable housing, 50%, but there's been almost no affordable housing built. I mean, I think 9 units in 13 years in this parish.
Yeah, no,
I mean, it's a very expensive place, as you yourself say. Yeah. It's a very important thing, isn't it? Nearly 10 times as many as in the last 12 years on one site. I mean, it's a big contribution.
There is a need for affordable housing.
Yeah.
Yes.
Okay. All right. Okay. Well, I've put the point. In terms of the market housing in general, can I just ask you very briefly about the document that you gave us today, which came from, was it Miss Rubinson's? Mrs. Rubinson's
yes.
representations. And do you have that, sir? Thank you. Thank you. Yes, thank you very much. The agreed figure, I think, for housing land supply is 0.98 of a year. And that's on the basis of the standard method, as you know, because the plan is old and the standard method is the basis for the housing requirement. Standard method is 1,110 units a year, isn't it? 1110. The 5-year housing land supply calculation, which gives us 0.98 of a year, I think of these approved units, I think 773 of the 876, they're all on the first page, the ones that say approved, were approved before the current year of housing land supply, before the 31st of March 2025. So if one just takes that, the year 2024 to 25, 773 units were consented, but that's only 75% of a year's worth, isn't it? So actually, to the extent that they're not included, these numbers in the supply, they just indicate that the position's getting worse, don't they? Because in that year too, the requirement wasn't met. So it's deteriorating. What this shows is it's deteriorating even beyond the 0.98. You with me? Okay. Fine. That was the point I had for you on that. Thank you. And again, I asked you about very substantial weight to the housing numbers. You gave some evidence about what's happening on the plan making front and what happened in 2021 and 24. I think you tell us, don't you, that the 21 draft that had the site in was withdrawn because of the objections from local residents. It's actually you who say that in your evidence.
Yes, there were a substantial number of objections
There were.
on planning grounds.
On planning grounds, on protecting the greenbelt was one of the main points, wasn't it, that was raised? Too much greenbelt release.
it was there was objections on a lot of grounds, including the policies which weren't being met of the Radlett plan. The
Yeah.
objections varied.
Yes.
There was a lot of objections in relation to traffic and access and the problems of sustainability. There was a
Yeah.
lot of objections on that. But yes, it wasn't a popular site, that's for sure. But it was in the 2024 plan, that site was reconsidered.
Okay,
And it
may I
was
stop you there? I'm not going to stop you from making that point in a minute, but I'm just trying to keep it in order for the inspector. I'm still in
There
2021.
were objections to other sites as well.
Yeah,
It wasn't
understood.
just this.
So I just want you to come back and answer my question, if you wouldn't mind. My question was, one of the main things that people objected to, that, as we can see from the document I showed the earlier witness, led to the 2021 draft plan being withdrawn, was objections by locals on release of greenbelt sites. That's right, isn't it?
There were a lot of
Yeah.
objections. This did
Thank you very
probably
much.
influence it, yes.
Okay, and they weren't obviously all about this site, were they? People were up in arms about the general amount of greenbelt release that was being proposed at that time, correct?
Possibly.
And then you said, rolling forward from that, your attention was drawn to a document which referred to some work on housing numbers that had been done and, migration and so on. The plan that may eventually, if we're lucky, come forward here, subject to local government reorganisation, of course, is to be based, isn't it, the MPPF tells us, on the standard method.
Yeah.
The standard method needs to be met, not what ICENI say might have happened to migration numbers. The government's policy is meet the standard method, isn't it?
This is partly based on population growth and where it's growing, where it's not growing.
Yeah. But the ICENI work is pre the MPPF, the Labour
Yes.
MPPF of December 2024. It's back in the day when the December 23 Conservative-led MPPF said it's just the standard method, just a starting point. You can look at local, that's the context, isn't it, of the ICENI work. But things have changed again, haven't they? The government now is saying, bring forward your MPPF and deliver in full the standard method. That's what the MPPF says, isn't it?
It is trying to achieve that.
Yeah.
Yes.
All right, okay. Thank you very much. So that's all I've got for Mrs. Scott. Thank you very much, Mrs. Scott.
Excuse me. Re-examination, do you have any questions?
Yeah, very short.
Want a short break beforehand or afterwards? We'll keep
No,
going.
I'll literally be 2 minutes.
Thank you.
The temptation nearly overtook me to ask about paragraph 159 again, but I think that might be the 5th time, so I shall abstain. But what I will ask you about is the PPG guidance that you were asked about shortly thereafter. You were taken to the Greenbelt guidance in 3.9, but just before the discussion in relation to that part of the guidance, you started to refer to another element of the PPG as well, but then the discussion carried on by reference to the PPG on Greenbelts. Well, this was all in the context of considering the local nature recovery strategies. Now, can you recall what PPG you had in mind in that respect?
There's been another PPG on landscape, I think,
Was that where you drew your evidence and view that the first approach in relation to attempting to meet requirements that now arise as a result of the local nature recovery strategy should be dealt with on site unless that
Yes.
cannot be done?
yeah.
So that's it. I'm not sure that part of the PPG has obviously been very recently updated. I'm not sure it's in front of you. If you'd like it, we can plainly put it into the library.
Identify that as a single extract, that'd be quite helpful, thank you.
Can I just come back to one point? So not with the witness, but just to make sure, it's entirely my fault to correct an error that I made, so I didn't want to
Okay.
mislead you in any way. It was about the cascade for affordable housing. I think I said, didn't I, in the questions, that related to the education land. It relates to the medical land. not the education land. So that's the bit of land which could end up with up to 18 affordable units on it if the medical centre doesn't get built there. The school land is simply given to the school, and they can use it as they wish. Thank you, sir. I'm sorry about that. That's my fault.
And that had been appointed regarding sort of the costs, I recall from your court. Yeah, okay, I'm fine from there, thank you. Right then, if you're indeed finished, Mr. Beglin, I only had one particular point I wanted to raise, which was this document, which had been, as I recall, had been submitted entirely reasonable if you didn't pick it up first time round. There were an awful lot of interested party submissions, but I just wanted to be sure, because I highlighted to be, had you actually got everything or not? Difficult, I'd not go full Dick Cheney of known unknowns and known unknowns.
We're very
you don't
happy.
know what you haven't got.
I think we're checked, sir, but we've obviously got this particular
You're
thing
happy
that's
with
being
that,
relied on. So I'm perfectly happy for it to be for you to take it into account. And obviously I asked
And
some
I presume
questions,
if you
but-
did have further comments on it, you've had the opportunity to ask questions now, and you can pick it up with your own witness.
Yes,
whatever
yes,
it
thank you.
was.
No, we're very happy with that.
Okay, fine. We'll carry on from that then. 3 o'clock. Do we want to? We have got time to carry on then today with Mr. Allen. Is that worthwhile starting rather than leaving him? Okay, great. We'll have a short break then until 3:10, and then we can carry on with Mr. Allen. Is that okay? Thank you.
very much, sir. Our next and final witness is Mr. Allen. Good afternoon, Mr. Allen.
Good afternoon.
And from Mr. Allen, sir, you should have a proof and rebuttal. And I'd like to introduce you, Mr. Allen, to the inquiry through your main proof of evidence. If you just take that up. Printed page 5, PDF page 6, introduction. You're there, and you are there. You explain 2.1. You are Philip Allen, and hold a BA Honours and Diploma in Town Planning from Oxford Brookes University, and you're a member of the RTPI and have been since 2006.
That's correct.
You're currently Director within Boyer's London South East Office. Boyer, obviously well known, National Planning Consultancy, 5 offices, forms part of the LRG, one of the largest property services groups in the UK. Employ around 70 professional staff covering specialisms of town planning, master planning and architecture. You have 20 years professional experience, you say, in planning within Boyer since 2007 and previously at Nathaniel Litchfield and Partners, now Litchfields. And then you explain the rest of your experience across a range of different sites, and including this site since 2017. Is that all accurate and up to date, up to 2.7?
Yes, that's correct.
Marvellous. And then you say at 2.7 the evidence you give is true and prepared in accordance with the guidance of your professional institution, and your opinions are your true and professional opinions. Is that correct?
Yes, that's correct.
Good. And with you, Mr. Allen, I just wanted to pick out some of the key points as they settled in the inquiry, starting with green belt purposes, and particularly focusing on the scope of the dispute between us and our friends on the other side, which is the contribution of the site to purposes A and B. And I'd like to start, Mr. Allen, by just getting you to explain how you've approached this question.
No,
Contribution of a site to purposes A and B.
Sure, and I'll be referring to the PPG guidance at CD 3.9.
Yeah.
And I agree that this is a useful place to start, given it's been name-checked a couple of times already.
Yeah.
So, looking at paragraph 6.4...
in your proof, is that?
In my proof. Yes, the starting point in terms of purpose A, purpose B, I'll just qualify that in terms of the main evidence on Greenbelt was provided by a landscape witness yesterday.
Yeah.
And so I'm simply looking at, from a planning policy perspective. So, starting point for me is PPG guidance. Yeah, I accept it's not a closed list, but there needs to be, in the first instance, a proper interrogation of what the PPG guidance states. And I start that with 6.5 in terms of starting at, at the top end in terms of purpose A, strong contribution, and the illustrative features. So there's 4 there in terms of whether the site is free from existing development and lack of physical features. Now, in this case, as I set out at power 6.5, it only needs 1 or more features to weaken the contribution of the site. And in this case, we've got Shenley Hill Road, we've got the woodland to the south, the plantation, and Theobald Wood, working around to the east. That's a local wildlife site, and obviously the built edge of Radley itself. So it's enclosed in all directions, containing development at the site. So in my view, they're physical features. So the site doesn't lack physical features. In fact, it has physical features around the entirety of the site. Moving on, it then moves on to, we obviously are adjacent to a large built-up area, and I referred to the evidence given yesterday in terms of incongruous pattern development. I have nothing further to add on that. So, from my perspective, that means the site doesn't make a strong contribution. It tips down to the moderate considerations, and one of those being subject to any other urbanising influences, and that's where I cover at 6 point.
You mentioned
So-
6.6.
6.6, that's correct.
Urbanise the influences across
So,
the
so
site.
that's the reference there in 6.6 is to the contributing factor in the moderate category, and that's from a spatial impact perspective.
Yeah. Okay, can I just pause you there and just give you the opportunity to respond to this point? It may be suggested to you that what's said at para 6.6 is an acceptance of taking into account questions about landscape character when you're performing an analysis of whether a site contributes strongly or otherwise to greenbelt purposes. First of all, Mr. Allen, have you taken into account questions of landscape character in your assessment of sites' contribution to greenbelt purposes?
No, this is simply from a spatial perspective in terms of a greenbelt policy.
And Mr. Allen, as a planner, what's your view, your advice to the inspector, about whether questions of landscape character are relevant considerations when you are looking at a site's contribution to greenbelt purposes, certainly A and B?
Yeah, no, I don't consider it relevant. So that's a matter for the landscape considerations, which is separate.
Yeah. Okay. Sorry, I interrupted you. So you were taking us through your approach. You've looked at purpose A, come to your conclusions. Is there anything else you wanted to take the inspector through on contributions of site purposes?
Well, in terms of, since we're talking about purpose A, we may as well move on to purpose B. And again, looking at the PPG guidance as the starting point, you look at strong in terms of, there's two elements here. Does it form a substantial part of the gap between towns? And in this context, we're talking about Radlett and Bournemouth, not Radlett and Shenley. And well, I'll come to the very reasonable conclusion that actually there's a small reduction in gap, and that's quantified in the Statement of Common Ground, the 1.36 kilometres gap, which is the same gap assessed by planning officers in the September committee who came to the same conclusion. It is my view that any reasonable interpretation of that is that a reduction, which I've quoted about 190 metres, I think discussion this week's been 200, it makes no odds in that context. It cannot be a substantial part of the gap, and that's what planning officers reached in September based on the same evidence. And I know Mr. Stroud made reference to the visual impacts from Shenley Hill. I would just make the obvious point that when you're travelling between Radlett and Bournemouth, you're going along Theobald Street, not Shenley Hill, which is the direction to Shenley. So I don't consider that to be a relevant point, and that moves on to then the visual separation. And again, evidence was on this was heard yesterday, so I have nothing further to add because it quite frankly doesn't change with Theobald Wood, and there's obviously a pedestrian and cycle connection from there, but that kinks. So in practical terms, the perception when travelling down Theobald Street, which is obviously the main route down to Bournemouth from Radlett, there'd be no noticeable change in my mind.
Now, of course, Mr. Allen, you've had the opportunity to hear the full case now put by the Council and the Rule 6 Party about the contribution that the site makes to greenbelt purposes A and B. You've heard last open field soft edge. You've heard the point about, from the Rule 6 Party, well, you might have to reduce the weight you put on the woodland because it might not be there in the future. You've heard the point about perception that Radlett and Boreham Wood might be perceived as moving closer together, but not actually, in fact, merge. Heard all of that. Now, Mr. Allen, I just want to give you the opportunity to say, having heard all of that, individually or collectively, do you think there is now the basis for a reasonable judgment to say that the site performs strongly against purposes A or B?
No, I mean, given any judgment that needs to be based on fully justified by evidence, on what I have heard, there's nothing to me that would warrant that conclusion.
Thank you. So sticking with the topic of Greenbelt and switching now to look at golden rules, you set out your evidence on this at 6.52, and of course it's common ground with the council, core document 6.4, para 419, that the golden rules are met. I just want you to, for the purposes really of addressing the points said about from the rule 6, just to take up the framework. Look at that together. And if we could, by reference to para 155 and 156 and onwards, explain your reasoning as to why you say the golden rules are met in this case.
So yes, so obviously the link is 155D, which moves on to 156. So
Yeah.
in terms of 156A, I mean, I think it's common agreement between all main parties that the affordable housing criterion is met. In terms of the infrastructure, 156B, I mean, I would note that this is the same wording, same meaning as the guidance in Power 58A, which is the compliance with SIL regulations. And, you know, the development will provide contributions in accordance with SIL. So by that motion, B is also satisfied. In terms of open space C, you know, there will be a new area of open space, about half a hectare, and a lot, as also as part of the illustrative material, the illustrative landscape master plan. And, you know, in addition to that area of open space, there's a linear trim trail footpath route that is capable of being delivered as part of the detail. So it's not just simply that area of open space near the site entrance. There's other incidental areas of open space. So in that sense, those green spaces will be open, accessible to the public. So that first part of 156C is met.
Yeah.
You know, the detail will come as part of the reserve matters application, but those spaces will be designed to a good quality, high quality, and will clearly be within a short walk of the new residents. So in that sense, 156C is met in its entirety.
Yeah.
Clearly, looking at 155D, there's explicit reference to paragraphs 156, 157, and the conclusion, therefore, if you meet 156, 157, which we do, significant weight is given in favour of the development, and that concludes at the end of 158.
Yeah.
We'll obviously then move on to 159.
Yeah, how does that, Mr. Allen, come into play then, 159?
So it's effectively add-ons. You know, you met the golden rules. Can you do some more? You know, in addition, it would be good to achieve these aims. And obviously, we've discussed about local nature recovery strategies, and there's some information that's been tabled on that, which I'll just move to now. In the context of that last sentence, and I think it's common ground with what Ms. Scott has just said in terms of there's no obligation requirement to provide it on site. It's as part of the proposals. So this plan that we tabled shows the off-site locations provided as part of development, and I refer to the biodiversity impact assessment, which is CD 114. I just refer to it because that quantifies the improvements at the 3 off-site locations. And this is quite a colourful plan.
Yeah, do you want to just orientate where we are? We can see the blue annotation Gorswood, and we can see the arable parcel just about.
Yeah, the arable parcel is a bit harder to decipher, but it's to the due southeast of the Gorse woodland.
Yeah.
So I guess, as a general point, in terms of local nature recovery strategies, and I think it's illustrated by the colourful nature of this, is what it is seeking to do is identify those areas which can contribute to achieving the greatest biodiversity gain, the most bang for your buck, effectively. And so it can't be that all this green different colourings, which all perhaps would have been helpful to have a key for all the areas, but effectively it's different elements of the local nature recovery strategy. It can't be that it's seeking improvements to all of them, and I would make the point that actually a large part of the site is one of the few areas where there's no actual, beyond the urban area, no actual aim or objective. And I'll just make the point in terms of the gorse woodland, the sort of salmon pink, that's identified as an area of particular importance for biodiversity, which points to me that actually, you know, in terms of a hierarchy, that's pretty high up to the top. But in terms of specific points, there's on-site provision in terms of grassland and broadleaf woodland. So what the biodiversity impact assessment says in terms of the gorse woodland, that part of those, and it's the big over the blue sites, it's one of the aims is one of the enhancements would be that the broadleaf woodland is improved from moderate to good. So that's one element of the on-site sort of on-site conditions that is effectively as a net gain, and that's quantified in CD 114 at exec summary. And the second one is grassland, and that's where arable parcel 2. It's.
Do you want to just identify that? Probably so you can see it. It's not terribly easily. Just the annotation is the same colour as the background. If it's clear to you, then you've got it. Yeah. Sorry, Mr. Allen, carry on.
So that as part has moved from modified grassland in poor condition to other neutral grassland in good condition.
Yeah.
Now, so that which wouldn't necessarily have been achieved without the proposals coming forward.
Yeah. So just bringing that all full circle and looking at 159, obviously heard what you said about not relevant to complying with the golden rules, but just thinking about that last sentence, where land has been identified as having particular potential for habitat creation or nature recovery within the LNRS, proposal should contribute towards these outcomes. Looking at the off-site provision, is that land which has been identified for habitat creation or nature recovery within the LNRS?
Yes.
And what's your view about whether the proposals, taken as a whole, including the biodiversity net gain provision, would contribute towards the outcomes identified in the LNRS?
Well, it would certainly contribute to those, which is part of the reason why we achieve a minimum of 20% BNG.
And therefore, what's your view about the compliance or otherwise of the scheme with paragraph 159 of the MPPF?
Well, it complies.
Thank you. So that's golden rules.
If I just jump in there
Sorry,
for
sir.
a moment
Yeah,
then.
of course.
So even if I were to disagree with you, Mr. Allen, and agree with Mrs. Scott in respect of 159, and rather than nice to have add-ons, these are actual requirement of the golden rules, you essentially been telling me that you comply with them anyway.
Correct.
On that basis of your assessment. Thank you.
Thank you. And then moving to a different topic, please. Just to get straight where we are on the housing need situation, you set out, as is common ground, the current housing need figure. That's standard method 1010 DPA. And we know the response provided by the current development management rules, that's in the Statement of Common Ground 6.31, 0.98 years. But question for you, Mr. Allen, is how is the current position, so 0.98 years, how's that compared to recent years?
So I just draw to power 4.7 of my proof. So effectively, as I say, it's nearly a 5,000 home shortfall, and so I'd effectively track it from where we were 2 years ago in terms of the previous inquiry, which the inspector accepted was always the common ground, that was 2.25, which is a drop from the council's most recent housing land supply position, which is now dated, and so that in that time it's dropped. Subsequent appeal decisions have come and gone, and it's continued to drop quite significantly to the current position. So it's gone from over 2,000 homes at the shortfall at the time of the previous appeal to nearly 5,000 now. So I think in any book that is a significant deterioration of the position, and that's just exemplified in the housing delivery test results as well. Which, so looking forward, looking back, whatever way you look at it, it's fallen off a cliff.
Yeah. Okay, so that's how things are going on the development management front. Let's have a look at plan making. How far off does the authority say it is in adopting a new local plan?
Yeah, well, it depends if you take the current LDS at face value. So based on that, we should be having a consultation on a Reg 18 now and a Reg 19 consultation in April before submission before the end of the year. Now, given the last Reg 18 consultation was, well, coming on for 2 years ago, to make such progress in such short a time is perhaps optimistic, putting it politely.
And I'm just pausing there, just so we get the picture. Was that consultation that was undertaken in 2024, was that against the current MPPF?
No, no. I was just trying to find the table in my proof where I cover the numbers. Hang on. Yeah, so at the top of page 17, prior to power 5.29, I just sort of track.
Yeah, just give us a moment, Mr. Allen. So we're on printed 17, PDF page 18, and it's your.
I should have actually numbered.
Yeah,
I should have numbered the tables. Would have been helpful. But so you can see in the draft local plan in 21 when it was, which included our site, based on the current standard method figure, which is just over 1,000 homes per annum. It met 75% of the need, or the identified requirement, and you can see the 2024 draft is obviously just over half. So looking forward, when a new plan does appear, there needs to be more sites, including ours, to get anywhere close to the stated requirement.
So just remind us what the LDS says about adoption of a new local plan. So what does the LDS say about that? When does the council, in its formal document, anticipate this is all going to be adopted?
I'm just going there now, but effectively, from memory, it's effectively next 27, so before the end of next year. So to make progress from the last consultation was just effectively a list of potential sites. So the 2021 draft was a complete plan. So there's a considerable progress to be made.
Yeah. And has there been any new greenbelt studies or studies identifying land that would be grey belt or anything like that you've seen in the evidence base?
No, I haven't seen it. I mean, it goes to the fact that the evidence base as is.
So given all of that, I mean, how likely, in your view, is it that the council will have a new local plan in place, as it says in its formal documentation, by 2027?
Well, next to no chance. Yeah. So, the conclusion I draw from that is there's no local plan solution to the housing shortfall.
Yeah. And just whilst we're touching on local plans and how development management might intersect with them, is there any prematurity objection that's been raised to this application?
No, and it would be wrong to assume one.
And just sort of spooling forward and thinking then about what the strategy of a new local plan might look like, is there any suggestion in the council's published documentation that it would be able to meet its need within its existing urban area?
No, there's no suggestion it can, and quite frankly, it couldn't. Clearly brownfield supply will form a component of that, but by itself,
Yeah.
it will not.
And again, is there anything that the council has published or is publicly accessible or before the inquiry which suggests that the council will be able to expand its main settlements without using the greenbelt to meet its need?
No. I mean, I'd just point to all the higher order settlements, and by that I mean Bournemouth, Potters Bar, Bushy, Radlett. They're all surrounded by greenbelt. So you can see that in Figure 1 of CD 3.3, which is the 2021 draft plan, which is just on the key plan. So yes, no, not enough brownfield. It's inevitable that the most sustainable settlements will need to grow. There will need to be greenbelt release, which was accepted by Inspector Fagan in decision.
And just you touched on it just a minute ago, but how does Radlett fare in terms of its sustainability hierarchy and the current, or indeed in any emerging documentation, compared to other settlements in the district?
Well, it's only behind Bournemouth, Bushy, Potters Bar, which is why both the 21 and the 24 draft plans had allocations to that. So in terms of the principle, different amounts, granted, but obviously accepted that the principal growth at Radlett into the greenbelt was an appropriate approach.
Yeah. And given all of that, I mean, in your judgment, how likely is it then that Radlett is not going to have any greenbelt allocations in any future plan by this authority to meet its need?
How likely? Not likely.
Yeah.
It quite inevitably will need to.
So let's zoom down then from the sort of strategic level and have a look at this site. I mean, what's your view about the appropriateness of this site to accommodate housing development?
Well, it's common ground between us and the borough that it's a sustainable site. Inspector Fagan identified the clear accessibility of the site, and he does that at Power 56. Clearly, the 2021 plan proposed allocation of the site. So, yes, I think on a number of metrics, there's a high chance, in fact, I would say certainty, that the site would be proposed for allocation.
Okay, thank you. And let's now turn and then, with all that in mind, look about the weight to attach to the benefit of providing housing in this location and think about market housing, first instance. So could you take up what Mr. Stroud's proof of evidence, please? And within that, if you could turn to his page, printed page 18, PDF page 20.
Yep.
And on that page, you should have a heading, the provision of new market housing, square bracket substantial, para 5.38. Do you have that? And if we just look together at, because this is a point where you and he are apart, you say very substantial, he says substantial, and he gives his reasons. He says, in reaching that view, I've considered the quantum of housing proposed rather than simply a full weight to the principle of market housing of itself. I recognise that the council's housing land supply is lower than it was considered by the previous inspector. However, I do not consider the supply position has worsened to such a degree that it warrants upgrading the benefit into the very highest grade of weight agreed by the parties. I also observe that the application is an outline and there appears to be little information regarding the timescales for delivery. I just want to ask you about that, Mr. Allen. What's your view about the evidence before the inspector about the deliverability of this scheme if permission were indeed to be granted?
So as part of my Appendix 3 of my proof, I include correspondence from Carla Holmes, National House Builder, and Fairfax themselves, where Carla provide a clear timeline to expected delivery. As I understand, that's not disputed. Yep. So it's clearly is deliverable within the next 5 years of following any approval.
Okay, thank you.
I also just want to make a point in terms of the weighting highly substantial. Obviously, planning officers reached that view.
Should we just take that up? So, officers' report, core document 2.3.
Yeah.
And when you're there, just to orientate, it's PDF 69,
69.
paras 7.18.1 to 7.18.3. That's what the officers thought.
Yep. Yep.
And what was their conclusion about the weight to attach to market housing in this case?
It's very substantial.
Yeah. And just out of interest, 17.18, 7.18.3, did they make any reference to the previous inspector? Did they bear that in mind when they came to that judgment?
Yes, that's clear in the first sentence of that.
Okay.
Again, they do a similar exercise, when they track level supply.
Okay, thank you. And of course, you've heard Mr. Stroud give his evidence. He was cross-examined about the weight that he'd attached to market housing. Having heard his answers and what he had to say about that, does that cause you to change in any way your view that very substantial weight should be attached to the benefit of market housing?
No, and I'll just add that in terms of my weighting in my proof, that power 6.32, in addition to the London Road Shenley appeal decision, I refer to two other appeals whereby they're being determined post the previous appeal at the site, where very substantial weight are being attached, including a scheme of 70 homes, so less than the 98 or 97 market homes provided as part of this scheme.
Okay, so that's market housing. You're as one on affordable housing, so we don't need to look at that. Education, benefit for education. Quite a difference between you. So you say significant weight to the provision of the safeguarded land. Mr. Stroud says limited. Let's just take up his proof again and have a look at why he says that. So he's at 540.
Yep.
540, and he tells us it's at least in part a measure to address demand that the appeal development itself would generate, rather than the freestanding public benefit of substantial magnitude. And then we get this. In the previous appeal, the inspector accepted that any expansion requirement was uncertain and contingent on wider circumstances, including the delivery of other sites, parental choice, future reliance on faith provision, and that the benefit would only arise if the option were taken up within the relevant period. In those circumstances, is limited weight. Mr. Allen, what's your view about whether things are the same in factual terms or different as between this inspector and Inspector Fagan?
So yes, I think it's fair to say Mr. Stroud largely adopts Inspector Fagan's conclusion on that. What has changed, and there has been a material change in my mind, is in terms of the statement of common ground that was agreed with the County Council that formed Appendix 2 to our planning statements, which is CD 130. I won't go through it in detail, but what it does do is just a agreed statement with the County Council whereby they quantify the need for this expanded school at Newbury's primary school, which is one of the things is that this is the only show in town in terms of a school expansion, so not just need arising from the development itself, but other forecasted need, which at that time was based on the 2024 draft plan figures, which, as I said earlier, will no doubt increase. So the need for the facility will only increase. And so, yes, so there's that where I lead on in terms of that weighting attached to it is the statement of common ground, which I say quantifies that, and what the MPPF states at paragraph 100 and 101.
Yep. So,
which talks about schools and public service infrastructure, which schools are, where it talks at the last sentence of Power 101, where it says significant weight should be placed on the importance of new expanded or upgraded public service infrastructure when considering proposals for development. So this would facilitate that.
yeah. And so just to pick up on a point you made about the Education Authority have said this is the only show in town. What's your view about Mr. Stroud's evidence where he says he relies on what Inspector Fagan said about the potential for delivery of other sites to meet this particular need? What's your view about the accuracy or otherwise of that particular statement?
Well, as we sit here and now, there is no other site.
Okay, thank you. So that's education. And then just trying to look at the remaining benefits. So if we take up your proof and we go to your 6.53, we've got your summary table. And we can see market, affordable, safeguarded land we've dealt with, compliance with golden rules, nothing between you and Mr. Stroud on that. And then biodiversity net gain, economic and social benefits. He said limited, and you said moderate. And what I just wanted to ask you, Mr. Allen, was that let's suppose for a moment the inspector accepted that one were to attach limited instead of moderate weight to the BNG and economic social benefits. Would that, in your judgment, have a difference to the very special circumstances conclusion you've reached?
No.
Yeah. And just thinking about Inspector Fagan's decision and the inquiry and the evidence he had and the evidence this inspector has, economic and social benefits, is it the same economic evidence that's before this inspector as before Inspector Fagan, or is it different material that's before this inspector?
It's different material. The economic social assessment dated September 24, so which accompanied the application.
Yeah. And in terms of how that evidence compares to the evidence that was before Inspector Fagan?
Well, it quantifies the economic social benefits. I know, again, planning officers attach moderate weight to that, and other comparable appeal decisions in there also attach moderate weight to that benefit.
Yeah. Okay, thank you. And just on the biodiversity net gain, had your evidence that the provision of biodiversity and net gain in this instance would comply with 159 in that it would be on land identified for the creation or improvement of existing habitats in the LNRS? Was the LNRS, even in its draft or emerging form, something that was before Inspector Fagan?
No.
And does the adoption of the LNRS and your view that the provision of biodiversity net gain is promoting the realisation of its objectives, does that have anything to do or bear on the weight to attach to the provision of BNG in this case?
I think it just reaffirms my view that moderate weight is the appropriate weight to be attached.
Okay. Lovely, thank you. And then just finally, I wanted to just meet this point head on about Inspector Fagan's decision, January 2024, and the world we're now in. What, in your view, has changed, materially changed, between the considerations to which he was directing his mind and those which our inspector will in due course come to turn?
Yeah, I mean, I'd say there's probably three main changes that occurred since January 24. Obviously, changing government, new MPPF, new methodology behind standard method, a stock-based approach, and a more ambitious housing target. So the sort of the parameters of housing requirement needs has substantially shifted. As I say, touched upon the school position, more evidence, I would say, in terms of the quantified need for school expansion at Newbury School, and of course the golden rules, which in their own right attach significant weight, which again is something that's common agreement between us and Hartsmith.
And so just bearing what you've told us in mind and reviewing all of the material as a whole, what's your take on Mr. Stroud's evidence this morning, which is to say that if the inspector finds himself concluding that this is not grey belt, it's a green belt site, well, the inspector has a well-trodden blueprint rehearsing all of the same considerations which resolves in very special circumstances not being made out. What's your view about Mr. Stroud's advice, evidence to the inspector in that regard?
I don't agree, because there's clear differences that would warrant a different outcome, which is in fact what planning officers reached in their recommendation.
Yeah. Thank you, Mr. Allen.
Obviously notwithstanding the main point that the site is grey belt.
Of course, yeah. Thank you, Mr. Allen. Was there anything else you wanted to clarify in your evidence in chief?
No.
Okay, thank you very much. If you might wait there, please, there'll be some questions for you. Thank you, sir.
Good afternoon, Mr. Allen. Now, let's move with all due pace. I think we're all agreed on, as between you and I, on the decision-making structure so far as this case is concerned, of principal relevance for the inspector. In other words, I think from your perspective, to be fair, there are really two routes for you to gain permission. One would be that very special circumstances exist in accordance with the provisions in the NPPF and policy, and the other would be that the site is grey belt and the relevant provisions apply in the NPPF as well. Yeah? I probably put them in the wrong order because the grey belt should go first. Okay. Yeah. But those are the two bits and set out in the statement of common ground inspectors read. And I suppose the converse is true, simplistic but worth just repeating. I mean, if the site is not grey belt, in other words, it's green belt, and if the inspector comes to the view that very special circumstances don't exist in this case, then the development would be inappropriate, and in NPPF terms there would be a, quote, strong reason for refusing permission in para 11. So that's really the structure you and I are discussing our matters in. Is that fair? Yeah. Good. Now, and if it's not grey belt, in other words, if it's green belt, I was going to put to you, I'm still going to put to you that it's effectively a rerun of the last appeal, although in light of your answers, you're, as I understand it, saying, well, Inspector, there are actually some material changes in terms of the evidence, principally, in the weight you give to various factors, whether that be through housing need or the other factors you've just been through with my learned friend.
Yeah, the context as well.
All right, okay, that's fine. We'll come back to those in a moment. But just so I understand your position on the inspector's decision, which we can turn to if we need, but the inspector's been to it so many times, I think we can go quite quickly through some propositions. You agree it's a material planning consideration?
Yes.
Now, when I look at your statement of case, you indicate that it's an important material consideration and the inspector should take the conclusions into account and only depart from them having first had regard to the principle of consistency. That's your general position, yeah?
As a principle, yes.
Yeah, I understand that. And again, the inspector will be very familiar with the principle of consistency, and generally one looks at a number of factors when one's considering whether the position is the same. You look to see whether the policy is the same. You look and see whether the nature of the application is the same, and perhaps whether the on-the-ground situation, the physical things, or perhaps the need for education of those kind of matters are the same or similar, yeah?
There's similar, yes.
Yeah, because, I mean, nothing's in life is necessarily going to always be identical, but broadly, in terms of the nature of the application, and I know there are twists and little twists and turns, but the nature of the application is almost identical, isn't it, in terms of what's applied for?
Yeah, I mean, I think it's covered in the statement of common
Yes,
ground.
I know.
isn't it?
So I'm just,
Yeah.
is that a fair proposition? I know there are small differences here and there, but essentially it's the same application as
Yeah.
before, Inspector Fagan. Yeah. And on the ground situation, again, effectively the same outline, access not reserved, but there might be a little more space for some landscaping, but essentially, standing back from it, essentially the same application.
Yeah.
Yes. Now, the thing that we've agreed, and if we take up the planning statement of common ground, which is core document 6.4, which I suspect you have to hand, or will have to hand shortly. Thank you. The item that we've agreed between, it says 211, the particular item that we have flagged up, 211, we looked at this earlier in the inquiry, the decision constitutes a material consideration appeal. And parties agree it's important to note that since this appeal decision, there's been a material change in national planning policy through the introduction of the grey belt concept. That's the key policy change, isn't it, that's happened since the time of Inspector Fagan. Everything else in terms of policy is broadly the same. Yeah? Fair. Okay. Now, again, we can say in your statement of case, I took you to that quote, which was, for the inspector's note, we can go to it, it's statement of case at para 3.7 PDF 8. The quote, or the proposition you put forward that the inspector is, quote, required to take Inspector Fagan's conclusions into account is tailored and relates to the ARUP work, when it sort of picks out the ARUP work. You don't... and what I'm going to suggest to you, that's rather strange, isn't it? The only bit in your statement of case of this appeal that you say to the inspector is important for him to take into account and have regard to the principle of consistency relates to the conclusions on purposes A and B from ARUP, which is the only area where policy's changed. And that does seem a rather strange position for you to take in your statement of case, isn't it?
Well, I mean, the statement of case is an outline of our statement which we build on, so the single reference to me doesn't mean that alone is only where you apply that principle.
Oh, well, that's helpful. I mean, because I'd read that as being you quite specifically saying, is that bit, you say the principle will apply to other parts of Inspector Fagan's decision, not just the Greenbelt purposes part. I mean, I'm happy with that if that's your position.
Yeah, I mean, there's always, no doubt we may well get
I'm not going to hold you
to
to every single line of every paragraph, but
yeah.
broadly, yeah? But because you see, just to push you on this, the bit you did flag out in yours, you put your outline case inquiry, it's strange, isn't it? Because that's the one area where we've agreed in the statement of common ground, obviously after you wrote your statement of case, where there's been a material change. And that might be one area where the inspector therefore looks again to see what the latest policy position is in relation to the grey belt concept. Would that be fair?
Well, I mean, it's mentioned there, but yes, I mean...
Okay, all right, I'll take that. I'm not going to rehearse again. I've put propositions about, inspectors heard lots about what existed when in terms of the grey belt matters with others, so I won't repeat that view here again. But turning to the issue of grey belt and green belt and how one assesses whether a bit of land is grey belt, I think we're all pretty much as one, well, perhaps we're not, but I think you agree, don't you, that the amendments to the PPG in February 2025 that we have before us in the core documents at 3.9 are addressed specifically to the issue of how one might identify whether land is grey belt or not by reference to the purposes. Because that follows from the definition of grey belt in the NPPF, yes? Yeah? Sorry, I couldn't make
I wasn't sure whether that was a statement or a question.
No, well, it was a statement I'd hope you'd agree with. No. Little Australian question mark at the end with my voice. Okay. And we agreed, aren't we, that when one looks at 3.9, I think this is all traversed now, they're just illustrative features, they're not meant to be exhaustive. I think Ms Brockhurst has agreed that. I think it's been agreed in Mr. Digger that you could look at other, you're not limited to just looking at those.
It's not a closed list, no.
Not a closed list. And there's no indication in it of what weight you give to any particular illustrative feature, is there, by the government?
What weight to the physical?
Well, any of the features, there's no indication that one should give any of the indents particular weight or any weight. It's one of those areas, isn't it, where a decision maker, obviously there's a material, but the decision maker's got to form his or her own view as to what weight is given to them. Yeah.
Well, I think it's less a matter of weight and more seeing whether those circumstances exist.
Well, it's not just that. I mean, I was interested in that. Is that your approach? Because I was interested when you gave answers on purpose A. One of the points you said to the inspector in your brief was, well, there are, as a matter of fact, you say various physical features enclosing and existing which might enclose or encircle or whatever, restrict. And you said, well, they're there and there. That's one of the matters that of itself could mean it can't be a strong contribution. I think that's the way you approach it, isn't it, from a policy perspective?
Well, yeah, I mean, because effectively,
Yeah.
not less so in respect to strong, but moderate contribution. It talks
Yes.
about one or more features. So it is important. It's not a matter of weighting. It's effectively what is the position on the ground. Is there one or more features? You know, typically sites are 4 sides. So
Yes.
it's kind of...
But it is. I was trying. I mean, I understand how. Well, I've asked Ms. Brocker's question how she's approached it, but as you approach Purpose A, as I understood your evidence, you were essentially saying, on looking at Purpose A, you say, well, Inspector, there are some physical features in reasonable proximity that restrict and contain here, and therefore this is not going to be in the strong category because they exist. That's a sort of tick box. Now, we know, don't we, and Ms. Brockhurst has agreed with me, that the mere existence of physical features which might restrict or contain doesn't necessarily follow just because they exist. A site can't make a strong contribution. That's what she agreed with me. That's right.
Yeah, I mean, it's that. Yeah, that, you know, the fact that the wording is that doesn't preclude that out.
Yeah. Well, that's what she agreed with me.
Yeah.
Right? You heard that? Are you taking a slightly different view? Are you taking a more mechanistic?
No, I'm not taking a different
No.
view.
So, I mean, that's right, isn't it? We know that from the Marlowe decision, for example. There's an example, very recent one, about 10 weeks ago, where there clearly were restricting and enclosing features, and yet it was still a strong contribution to Purpose A. So the mere fact of them doesn't mean you can't be a strong contributor as a site, does it?
Just, as an approach, yeah.
It's a judgment. Okay, fine. And so it's not a tick box exercise, is it then? Inspector, when he reads your evidence, got to bear in mind it's not a tick box exercise. Yeah.
When you say, I'm not sure, in terms of the phrase tick box exercise, I think it's an assessment, you know, I'm obviously, as I said, looking at it from a greenbelt policy perspective as the planning witness.
Let me put it another way then. The weight to be given by, or the relevance or the weight to be afforded to any particular consideration when the inspector's considering matters in this area, it is a matter for the decision maker, what relevance, what weight is given to a particular feature, depending on the view he takes of this site and its context. That be fair?
Yeah.
Okay. So a judgment is required, and I won't go through some of the appeal decisions. I've been through them. Ms. Brockhurst. Ms. Brockhurst is the principal. I'm not wishing to overtly downgrade your evidence on this, but as I understood her position, she was principally doing the assessment. You're looking at it from a more policy point of view, but she's done the principal assessment work on behalf of the appellant on this issue. Is that right?
Yeah, that's what, yeah.
So I won't go through every point with you again. So far as the ARUP assessments are concerned, which we've looked at several times, you heard Mr. Stroud's view. You remember, I think Ms. Brockhurst or someone was taking to CD 4.5, which was the stage 2 assessment, and the particular criteria that it was said were used by ARUP. I mean, just as a matter of fact, when the inspector reads them and can compare them with the purposes illustrations, they're just not the same, are they? There's some similarities, but they're not the same.
So it just might be worth just going to that
If you,
4.5.
CD 4.5, yeah, I know the correct CD 4.5. I didn't the assessment one, whichever that is, and then it's page 15, and it was the sort of 3 criteria there. This is looked at with others, but I just wanted. I mean, the point that Mr. Stroud says is, that, well, they're not things you look at now. So you've got new policy, but they're not in any event the same.
So,
I mean, it's almost a question of just the inspector reading them and forming a view, but they're not the same, are they? Sorry, I'm going perhaps too fast.
Yeah, no. So I'm on page. Was it PDF page 19? So
Yeah,
it's
sorry, it may
halfway
be
down the page.
PDF 19 or PDF. Yeah. Yeah.
Yeah, I mean, the wording is not the same.
No. And I mean, I think we're looking at purpose A ones there, aren't we? We're not, I mean, it doesn't have reference to incongruity, for example, just to take one example.
Yeah, I mean,
And you know-
the wording's not the same.
No,
The
wording's not the
argument
same,
with the
that's fair.
principles might...
And you know, Ms Brockhurst fairly said to me, and of course there can be other matters beyond that are here, as Mr Stroud explained, because it's not meant to be an exhaustive. The policies, which can have as much importance as the MPPF, is quite clear. It's illustrative, isn't it? It's not meant to be
Sorry?
it's illustrative. It's not meant to be an exhaustive list of factors.
Well, like I say, it's not a closed list. I accept that.
So, in other words, there can be other factors that go even beyond what's written in ARUP, even were it the same. But it's
Well,
not.
I mean, it would, as the guidance, and it's been published for a reason, it's a clear starting point.
Yeah.
There would have to be very good justification, evidence to on that. But as a principle, as an approach, I don't disagree.
Yeah. Oh, right. Good. Excellent. Good. So we can. That deals with ARUP. That saved us a little bit of time. Good. Right. So it wouldn't be the. I mean, it's in fairness, in light of all that, in light of what you've said about ARUP, it's right, isn't it, that Inspector Fagan, whatever he said about purposes A and B, did not have the up-to-date MPBG factors, illustrative features before him, nor did he know of the existence of the concept of grey belt.
Oh, yeah. It's a fact that, grey belt
That's
didn't
where we
exist
are.
at that time.
Okay, thank you. Now, so far as purpose, I don't think I need to traverse matters with you again. I think I've got enough from Ms Brockhurst, and as I say, you're not purporting to do the principal assessment. Just help me with one point, I think. When we look at your proof, if we could just turn your proof up where you look at purpose A, it's 6.6 in your proof, which we've looked at on a number of occasions at the inquiry, and I think maybe I'm the only one that's confused still, but we'll see. You 6.6, and you see the sort of second half of it. You're describing this in the context of your analysis of purpose A. Yep. Do you have that? Sorry, am I racing ahead? Do you?
Yeah, no.
Page 21. And you're talking there, aren't you? You're describing elements of the site as part of your conclusion as to what contribution the site makes to purpose A. Yes? That's
I'd say, yes. I mean, it's not quite a conclusion, but in terms of other factors that... This is part of your logic and your reasoning that you're inviting the inspector to rely on in your conclusion of purpose A, and you're dealing expressly, whether you want to call them matters of character, let's see if we can agree this, you're dealing with matters relate to how the site is perceived, both visually and spatially, in terms of its look and feel, if I can use that language. Well, I'm assessing from a spatial perspective.
Yeah, well, you're looking at the urbanising influence because of the presence of the existing development on the western boundary in Primary and Newbury School, aren't you? You're taking a position, fair enough for you to form a view on this, but you're taking a position of how it looks and feels in terms of an urbanising influence as opposed to an open pastoral influence. That's the exercise you're doing.
Yeah, in accordance with the criteria in the PBG.
That is another way of saying you're looking at the particular character of that area to inform your judgment on purpose A. If you're unhappy with the word character, you're looking at the look and feel and visual and spatial terms, aren't you?
I'm looking at it from a Greenbelt policy spatial perspective.
Right. And the opposite of the proposition you put forward at the bottom of 6.6, that it's an urbanising influence, but would be that it's not an urbanising influence, that it's more of a pastoral and countryside influence. That would be the opposite of your argument, wouldn't it?
But I'm not looking at it from that perspective. I'm
not asking you that. I'm asking you what the opposite of your position would be, Mr. Allen.
Well, I'm looking at it from a Greenbelt policy spatial perspective.
No, Mr. Allen, sorry, forgive me, I'm not asking that. I'm saying when you say in your paragraph 6.6 that there would be an urbanising influence across the site because of the development, a counter position which I'm not saying you're going to agree with, would be that there's not an urbanising influence, it's more of a countryside or pastoral influence. That would be an opposite view, dealing with the same kind of factors from a different point of view, wouldn't it?
It would, but like I say, I mean, looking in the context of the PPG guidance,
right.
but I take your point.
And that's part of the argument that Ms Brockhurst, Mr Stroud have used in coming to a different conclusion from you, not the only thing, that informs their view on, for example, Purpose A, isn't it? That's what they've done.
Well, yeah, I mean, I think conflating two issues, but like I say, as part of the process, as a planning consultant, I'm looking from a policy perspective. Miss Brockhurst is looking from a landscape. Right,
all right. Well, I think the inspector probably gets the point. And while the Inspector Fagan didn't have the grey belt test before him, we know that on this issue of whether the site has an intrinsic pastoral and open character, as opposed to whether it has an urbanising character, he was squarely with the position taken by Miss Backer and Mr Stroud at this inquiry, wasn't he? And we can go to the reference, for example, at his 43 and elsewhere that we've looked at already. But that's right, isn't it? Inspector Fagan took that view.
What power?
Well, look, if you want, for an example, 43.
From the landscape.
The second half of 43, the settlement edge does not affect the intrinsic pastoral open character of this agricultural field. And elsewhere he expresses similar views that I looked at with Miss Brockhurst. So he's taking a different view than you are, at your 6.6, when you say, it's the urbanisation affects it. He's just taking a different view.
Yeah, I mean, I'd say this is from a landscape perspective, and I'll defer to Miss Brockhurst on that.
Yes, fair enough. But I'm only asking because you put that proposition in your proof, you see, that's where I'm... And the point's this, that you tell us, and you agree with me, that one, at this stage, has got to be careful before departing from findings in Inspector Fagan's decision, as to, and this is findings as to how he assesses the look and feel, the spatial, visual feel of the site. What's changed in that regard? Nothing. Has it?
Well, in terms of on the ground,
no.
No.
No. So there we are. Well, so applying your own principles that we agree, the inspector should think very carefully. Of course he's entitled. He's entitled to take a different view, of course he is. But applying the principle of consistency as a material consideration, he should think very carefully before he does so, shouldn't he?
Well, it's a factor to consider.
Well, that's right, isn't it, what I'm putting to you? Proposition? Applying the principle of consistency on this issue, the inspector should think very carefully before he decides to depart from that finding on the basis of the principle of consistency in planning decision making for members of the public, for planning authorities. That's a factor that weighs in this case, isn't it? We've agreed.
Well, I mean, it's a factor that weighs in most cases.
Am I right, Mr. Allen, the proposition I'm putting to you?
Well, in terms of, there's a, if there isn't...
So yes or no and then caveat, I think, to be fair. Yes or no, then caveat. Am I right in the proposition I put to you?
Yes.
Yes, and by all means caveat it now.
Well, yeah, so it's, in terms of it's a factor for consideration, but there are other factors that might warrant a different outcome.
All right, thank you very much. Now, again, I'm not going to traverse Purpose B with you, but you will have heard the evidence of Miss Brockhurst and Miss Backer and Mr. Stroud, and can we agree that when inspectors looking at, from a policy perspective, at the PPG guidance on Purpose B, in other words, the purpose to prevent neighbouring towns merging into one another, and one's looking, isn't one, the site in question and trying to identify in relation to that purpose what level of contribution the site makes? Yes?
Yes.
The test when you're looking at a particular site is not whether that site itself prevents the merging of towns, is it? It's whether and to what extent that site makes a contribution to that purpose. Yes?
Well, in terms of the PPG criteria?
Yeah.
Yeah, I mean, it's in the context of, yes.
Yes. Okay. Good. And that can be, as Ms Brockhurst fairly agreed, physically doing measurements, or it can be perceptually applying the Lancaster decision approach with which she agreed. Yes?
Yeah, it's not just one fact,
Oh.
it's not purely
Good, thank you.
distance.
Helpful. And now, Miss Brockhurst fairly accepted in relation to the approach taken by Miss Backer. She obviously gave evidence before she heard Mr Stroud, but she accepted, although she disagreed with her approach to the purposes, she accepted they were reasonable judgments taking into account factors that could properly be taken into account, but she disagreed with them. That was Miss Brockhurst's position, wasn't it, in relation to Miss Backer's evidence?
Well, in terms of the conclusions reached by Miss Backer, is
Yes,
what,
yes, that's right, isn't it?
in terms of the towns merging
In
into
relation
one
to the purposes generally, and both we put it to her, she accepted that the approach taken by Miss Backer was a reasonable one. She disagreed with it, but she accepted them as a reasonable approach to take. That was her evidence, wasn't it?
in terms of the visual
In relation to
perception.
purposes A and B.
Hmm.
Yes, that was her evidence.
Yeah,
Yes.
I'm not going to contradict.
Right, good. So is that a yes?
Yes.
You were here, thank you. Now, you, and that's the evidence of the witness for the appellant, who was put forward as the principal assessor of purposes A and B, all right? Which, you've said in evidence in chief in relation to these issues, you said there is no evidence you can see from the council to properly support an argument in relation to a strong contribution to those purposes. That is directly contrary to what Ms Brockhurst said, isn't it?
Well, I'm looking at it from, again, applying this threshold, the criteria in the PPG to that, in terms of is it forming a substantial part of a gap between towns?
Yes, so was
Is
she. So was she.
I-
I mean, Ms Brockhurst was applying the PPG criteria, wasn't she?
Yes, and I'm playing it from a policy perspective, giving my view on it.
Yes.
And that's the view I reach.
I know you are, but that's not what I'm putting to you. Your position, and you telling the inspector, you say there's no evidence, quotes, well, is directly contrary to the position that your colleague, Ms Brockhurst, took in her evidence, isn't it?
Well, it's Miss Baker provided that evidence.
No, it's Ms Brockhurst's evidence I'm asking you.
Oh, Miss Brockhurst.
I put you the proposition, you agreed she said it, you agreed with that proposition, and you say something different, and I'm just putting to you that your evidence is obviously contrary to that, therefore, of Ms Brockhurst in that regard. Because you say there's no evidence to support it, and she's accepted there's a reasonable judgments of form, she doesn't agree with them, but she accepts they're reasonable.
Yeah.
Okay, so your evidence is different, it can be noted.
Yeah.
Right, you disagree with your witness, and you know, in the context of what we're told and promised each day as a cost application, that's pretty important, isn't it? Because one of your witnesses, the principal witness dealing with this assessment, has accepted in terms that there's a reasonable level of evidence to support the position of the council. You fairly accepted that to me, and yet your client is apparently considering pursuing an application saying there's no evidence. That's the position, isn't it?
Well, I wouldn't necessarily put it like that.
Well, that is the position, in light of the answers you've given to me, Mr. Allen, isn't it?
Like I say, I don't necessarily put it like that.
Well, why not? I mean, I think I've been fair. I've taken you through the questions. You've accepted your evidence is directly contrary to Ms Brockhurst. And why am I wrong? I mean, that is the position, isn't it?
No, that's reasonable.
Thank you. That's reasonable. Thank you. What isn't reasonable in those circumstances is for you or your client to seek to pursue a cost application, is it? That would be, frankly, with great respect to you, unreasonable in light of your answers. Is that fair?
No,
Why not?
I just don't agree with that position.
Why not? Given your answers, why on earth not?
Well, I have nothing further to say.
You have nothing further to say. Right. In relation to the CSA study, which is at core document 1.25, and that's the study looking at the issue of what contribution those authors think this site makes to the purposes, yes?
Sorry, pardon?
Are you familiar with that study?
Yes.
It's a study that seeks to assess what contribution the appeal site makes to the purposes A and B, and perhaps others, but for my purposes A and B, yes? Yeah. It's dated July 2024, yes?
Yes.
It doesn't apply the grey belt purposes and the illustrative features that we have before us in the NPPG, because the NPPG didn't exist.
Yes, it didn't exist at that point.
It didn't even apply the criteria that we looked at earlier in relation to ARUP, which you've now fairly accepted are not the same in any event, but it didn't even apply those, did it?
No, well, it took a view in terms of...
It took a view. What was that view it took in relation to the contribution the site makes?
So I'm just going to go there.
Yeah.
What document reference?
CD 1.25.
Yep. Okay.
So I was asking you what they assess doing on the basis they do. What do they assess about the contribution the site makes in relation to purposes A and B?
So they reach a conclusion it's a weak contribution.
Yes. So different from your conclusion.
Oh, reach a conclusion that makes no more than moderate.
Yeah. So different from your conclusion. So you've upped the level.
Yes, well, I take the view that's no more than moderate.
Yeah. And I mean, the reason I take you to this, because again, to support your position, you tell us at this inquiry in your statement of case that you're going to rely on this. This is for the inspector's note, your statement of case, para 3.8. And that's put forward. Now, where we're at, we know, don't we, that in relation to that document, it's not even applying, frankly, the same definition of grey belt that we now have, because it was looking at a draft version which was different. Yes?
Yes.
It's certainly not applying the criteria we now have by way of illustrative features, because they didn't exist either. Yes. No. And so far as it does take an approach, as you put it, they took a view. It's a view that is entirely, well, it's materially different from the view you take in terms of the level of contribution that they identify.
Yeah, well, I take a view that's no more than moderate. That's a view.
So you don't rely on that as a bit of evidence anymore, do you, just in light of the change of policy and the way they've approached it, or do you?
Well, it's an assessment against the purposes that comes to view on those purposes.
Not based on current policy.
No, well, it was at the time of that assessment.
Yes, but the inspector's got to deal with policy as it is now, hasn't he?
Yes.
Mr. Allen, so you're not relying on it anymore, are you, as a relevant bit of evidence to assist this inspector?
Well, it's part of the body of evidence that supports the application.
Yes,
so in that context.
But are you still relying on it in light of what we've agreed? I mean, if you are fine, you were in your statement of case, but I want to really understand, and I suspect the inspector might want to know whether you're saying to him he should place any reliance on that in light of the questions and answers we've just had.
Well, in terms of how I've assessed the relevance of the other evidence that out there to support the conclusions on the contributions, it's part of that body of work.
Okay, all right. Thank you. Good. Now, in terms of the various KC advices that are before the inquiry, we've looked in particular at Mr. Cannon's, which is core document 2.1, which is the most recent in terms of chronology. And again, by all means we can look at it, but can I just try and deal with this quickly? Neither he nor any of the other earlier authors, eminent as they are, of advices and opinions had the evidence that exists before this inquiry before them, did they?
In terms of the...
In terms of an assessment of the contribution the site makes to the purposes. It just didn't...
Yeah, the date it's clear that, it was based on the evidence at the time of the application was determined.
Absolutely, and what absolutely fair. And what I'm putting to you that the 4 independent assessments before this inquiry that conclude there's a strong contribution to A and B were not before the authors of those opinions, were they?
Well, that's a point of fact, isn't it?
Well, I hope we'll get an easy one, an easy yes, and move on. Yeah, and all of them, quite properly as lawyers rather than planners, make the point that they're providing their opinions and advices on the state of the evidence that existed when they wrote their opinions, didn't they?
Well, yes.
Yeah. Okay. Good. Thank you. Now, I'm going to move off grey belt and green belt in the interest of time in the last sort of 15 minutes, I hope. Just so far as landscape evidence is concerned, I've had the debate principally obviously with Miss Brockhurst. You are told, what's reported to you from Miss Brockhurst is that there are no significant effects that you should, that's how she reports to you, that's her judgment, isn't it? That's the conclusion you've taken on board from her evidence. Let me put it this way, sorry, I've slightly mangled my wording, as I'm often prone to do. She reports in her proof that the effects are not significant, using the language as she explained. And you remember I had a debate with her about how she'd got to that conclusion. I won't trouble you with that. But is that the finding that you've taken on to weigh in your planning balance from her?
I mean, in terms of that way I attach, if I can explain my approach, that would probably be helpful.
Well, could I just, by all means, Stephen, could you just answer that question first? Is that the finding you've taken from her evidence, or have you taken other points of evidence?
Yeah, that's
the finding you've, right, by all means carry on.
So in terms of the landscape effects, and Inspector Fagan refers to 44 and 101, 103, he obviously doesn't reach a conclusion in terms of the weighting, in the sense that he accepts that, or he makes the reference there's substantial adverse landscape effects, but at the end he obviously doesn't attach a weight to that. Just looking at Miss Brockhurst's landscape rebuttal, where it's at table R.11, where she refers, there's the land use grassland, both her and...
I don't want to interrupt you, but can I, and tell me if it's an unfair interruption. When I'm looking at your proof at 627, and where you come to the conclusion, you say I attach limited weight to the landscape harm, and I reading 627, you form that view. I think that's what I'm putting to you in light of the conclusions that Miss Brockhurst reported to you that the effects were not significant, as she put it.
I defer to her for landscape
Yes.
matters, but there's other contextual matters which I've had bearing to, and I was getting to.
Fine, sorry, then it was perhaps an unfair interruption. Sorry.
So, in terms, my understanding on 44 is Inspector Fagan is looking at the land use receptor, where he comes to that view, looking at the overall character of the site in that table. Both Miss Brockhurst and the council's witness come to a moderate adverse, which is obviously, from a character perspective, lesser than the substantial adverse landscape. So, in that sense, along with Miss Brockhurst's conclusions, I'm factoring that into it, and the fact that Inspector Fagan doesn't reach a conclusion on landscape weight in the decision.
Well, I think he does actually. If we look into his proof, if you look at paragraph 100 of this proof, when he deals with planning balance, he refers, doesn't he, at paragraph 101, there would be beyond the green belt. He says there would be substantial adverse landscape effects on the character and appearance of the area as a result of the permanent residential development on approximately 8 hectares. And then he goes on at 102. He refers to his scale of harm, and then he draws it together at 103, and he says, having regard to these benefits, they do not clearly outweigh the overall significant harm to Greenbelt and the substantial adverse landscape effects on the character and appearance of the area. So he's clearly not giving them limited weight, is he? Because he then goes on to weigh them against all the benefits and finds they outweigh them.
Yeah, but in terms of the effects, it's the terminology he uses.
He doesn't use significant effects. I mean, I think Ms. Brockers is the only one that does. Yeah. So, I mean, let me put this to you. I'm going to suggest you tell me if I'm wrong. I'm going to submit, and I think I'm right in doing so, that the planning inspector Fagan gave a degree of weight well beyond limited to the landscape character effects, as did the planning officers and their committee reports. Okay, as far as I can see, you're the only planner involved in this case the last 2 or 3 years that's taken the landscape character and visual harm, however it's characterised, and given it limited weight. You're the only person that's ever done that, and I think it's because Ms. Broadbent's reported to you no significant effects. She's the only person to ever have done that as well. Is that fair?
Well, like I say, she's informed from a landscape perspective my rating on it, and the terms of the fact that it's my take on that in the sense that the impacts on landscape character is confined to the site alone.
But in put it this way, in the balance you then undertake, there's other harm as well. But when you come to the benefits, you're weighing that in your evidence, aren't you? So far as the landscape matters are concerned, they're just limited weight you're giving them in the balance, on that side of the equation. Yeah?
Yeah.
Okay. Now, just in terms of other harms beyond the landscape and visual, there's obviously the openness issue. There wasn't any dispute in the evidence, the landscape and character and openness evidence, as to the nature of the harm to the openness. And as a matter of national policy, you're required, really, it's one of those instances where you're required to give it substantial weight, and that's been your approach. And both for the definitional harm, as it were, and also the on-the-ground harm caused to openness.
Yeah, it's bundled up in terms of the substantial weight.
So on the harm side, perhaps the difference for the inspector, if this assists, there's not a lot between us on the harm one gives to impacts on openness, but the difference lies, you give very limited weight to landscape harm. Others, Mr. Stroud gives more weight, considerably more weight to that in the balance. That's the difference.
That's the difference.
Yeah, all right.
The only observation I would make is, even with planning officers reaching that conclusion in the context of a VSE case,
yes,
they concluded that VSE existed.
They did, but they're absolutely right. But they didn't give limited weight to landscape.
No, so
you're absolutely right. But I'm just taking it as part of the process. I think you're the only one that's ever done that, as far as I can see. Okay, now so far as the very special circumstances balance is required, one's obviously got to look at the benefits, and it's again applying the principle of consistency. This is bar some slight, if I can put it this way, on your evidence, changes to some matters of weight in the assessment of various benefits. It's broadly a rerun of the position before Inspector Fagan, isn't it? In terms of policy context, nature of the application, and matters that are considered as benefits.
There's differences, as I set out in chief.
Yes, you did, but as I understand it, there's no new categories of benefits. The difference is, so far as you identify them, are into the weighting of the particular subheadings of benefits.
And you've got the compliance of the golden rules, which is
yes, all right, okay, fair enough. Take that on board. But apart from that, the policy is the same, the application is the same, the headings of the benefits, education, medical, are the same. Yes, fair point about the golden rules. That's right. That even if it's Greenbelt, there's a carried forward and weighed. Absolutely fair. Yeah? Okay. But apart from that, it's broadly the same. Fine. So again, the inspector will want to consider again, won't he, the principle of consistency, whatever his own views are, before departing from the position Inspector Fagan takes, with the caveats you give about differences as to weight and the golden rules.
Yeah, and obviously the points I make in terms of the context.
Yes. Now, just one point then, again, I think this is relevant to the principle of consistency, because Inspector Fagan made it quite clear, and this is a point the inspector will see that's touched on by the High Court in the Vistry case in the court documents, and the challenges were made since Fagan's view. The High Court made the point that Inspector Fagan, let's just have a look at this at paragraph 103 of his decision at court document 5.1, he felt pretty clearly, didn't he, that the benefits he'd had regard to in his previous parts of his decision did not clearly outweigh the overall significant harm to the green belt and the substantial adverse landscape effects. Okay, that he'd set out above. While he says, whilst these are of course a matter of judgment, I would add that even if greater weight were to be attributed to some of these benefits, for instance, if I had given significant weight to the new health facility and to the economic benefits, the totality of these other considerations would still not clearly outweigh the overall harm that development would cause. So there was a degree, if I can put it this way, of leeway in his judgment in terms of even if more weight was given to some elements, it wouldn't have made any difference. That was his position.
Yeah, I mean, obviously makes that qualifications. I mean, I think it's the changes in my mind outweigh that tolerance that he has. So, you know, in terms of he refers to, for instance, gave significant weight to the new health facility, which he attached moderate weight to in that context of the appeal, and the economic benefits, which he attached limited. I think the change in circumstances that I set out and the additional benefits, golden rules compliance,
Yes.
is not comparable to what he was saying there.
Right, I see. But I mean, I wasn't necessarily asking about that. That's a fair enough point for you to make. But the point I was putting to you was that I'm just going to get the table of benefits up. I've lost my hard copy. If we look at core document 6.9, which is that rather useful agreed table you produced together with the Rule 6 party, which sets out the differences, doesn't it? And really the point I'm making, if you look, for example, in light of that paragraph of the inspector, if you look at for example, the health issues, medical centre issue, so you give it limited, LPA gives it limited, yes? Mm-hmm. That's one of the examples the inspector said he might have given, even if he'd given it significant weight. So a notch, in fact 2 notches up on his scale, which is the same scale you use, even if he'd given it 2 notches up, it wouldn't have made any difference. And equally, if we look at the economic one, where you give that moderate, Mr. Stroud gives it limited, inspector says, well, even if I'd given significant weight, so again, higher than you give it even now to those factors, it wouldn't have made any difference to his overall assessment. And that's what I mean by built into that decision, material planning consideration, principles of consistency, is a fair degree of leeway, isn't there?
Well, I mean, I'd point firstly to the council officers, planning officers, and their recommendation. Clearly, they had Inspector Fagan's assessment, and they reached a different conclusion.
Yes.
The housing benefits for the market housing is at the very top end, and I consider very so it's not I don't think it's just a straight line. It is when it's the top end benefit that has the top weight. That
all right. Yeah.
That's a
I suppose
proposition.
You make the point about the officers, of course you do, but they don't quite have. I mean, that's not the council's position. That's officers reporting to members who disagreed. Council take a different view in line with Inspector Fagan's conclusions, and Inspector Fagan's decision on behalf of the Secretary of State is a material planning consideration that we've agreed the inspector should study carefully before he departs from. Yeah, so it's a little bit more important than what officers thought in the report, isn't it?
Well,
yes, is that fair?
It's a material consideration in terms of Inspector Fagan's decision, and for the reasons I've just set out. Yeah, there's clear differences that would justify a different decision.
That's your position. Okay. Now, the inspector's got the arguments on the various matters. I'll try and take them quickly. There's a difference between you in relation to the provision of market housing. Mr. Stroud set out his position, you set out yours. Now, it's fair, isn't it, that there are, in terms of market housing, there was slightly less than there would have been by virtue of you providing more affordable housing. It's 97, as I think, as opposed to 107 before. Yeah, I mean, so that's, that cuts both ways, of course, and there's more affordable housing but less market housing if one's dividing it up this way. The other point I just want to put to you, when one looks at Inspector Fagan's decision, we've taken this inspector to before, in particular paras 55 through to 60, where he's dealing with housing supply as was before him when it was 2.25, and you fairly make the point that it's materially less now than it was before him, which is a fair point. But it's right, isn't it, also, that when the inspector reads Inspector Fagan's reasoning underlying the weight he arrives at, which is substantial rather than very substantial, he is quite clear in his own mind, isn't he, when you read that, of the importance that one should afford to the delivery of housing in this particular area, and indeed looking forward in terms of what he thinks likely to happen or not happen moving forward.
Yeah, I mean, I'm just, having been at that last appeal, I'm looking at Power 58, where there was a whole discussion in terms of the number of new homes and that informing the weighting attached to that benefit. And there's references to other appeal decisions.
Right.
I say that it's moved on since then, and the appeal decisions that I referred to in my proof all determined post the previous appeal, where it had different housing numbers, all attached to the highest tier of benefit.
Sure. You'll see, but even at that stage, there were appeal decisions, as the inspector noted at paragraph 58. He referred to them. He accepted that there were other appeal inspectors giving very substantial weight to housing. His judgment, for all the reasons he set out, despite acknowledging the dire state of housing, was that it should be substantial rather than very substantial. And my point, I suppose, is this: he was fully aware, albeit the housing supply was different. When you look at his reasoning, he was fully aware of what he considered to be a very dire situation and a national policy imperative to significantly boost housing. He was aware of all those factors, wasn't he?
Well, yeah, but since then, though, it's not comparing the same situation to as it was then. It's not just got slightly worse; it's got a lot worse. And like I say, the at 58 talks about that he's applied a sliding scale based on numbers delivered. Whereas no, because of the situation it is now, i.e. got markedly worse, the inspectors recently, irrespective of numbers, have attached a top weight.
Okay, fine. Well, look, in the interest of time, there are other differences between you. Mr. Stroud set out his position, for example, on education that's slightly different from you, and on BNG. For example, on BNG, again, Mr. Stroud's taking the same position that the inspector took, Inspector Fagan. There's been no real change on that front, as they all still proposing to provide, I think, is it 20% BNG?
Yes, it's a minimum 20%, but yes.
So you're taking a different view for Inspector Fagan. I think Mr. Stroud's in line with Inspector Fagan, who considered 20%.
Again, I'd point to other appeal decisions I think I referred to in my proof. So just because Inspector Fagan reached a view then doesn't make it so now.
No, of course it doesn't. But it's a material consideration, isn't it?
Yeah.
That one should only depart through having regard to the principle of consistency, as we've agreed.
Unless other things have changed.
Yes, well, what's changed in the BNG world? I mean, you're not providing any more BNG. What's the difference? That's what I'm getting at.
Well, there's obviously the benefit that the local nature recovery...
It's still 20%, isn't it?
So, yeah, still 20%, but it achieves wider aims.
Right. I see. Okay. All right. And then economic matters, again, the difference between you, that's one of the ones when, we know from Inspector Fagan, even if he went higher than you, as I've said before, it would make no difference in his view. It's a matter for the inspector to grapple with. Okay, and overall, I suppose one point I put to Mr. Stroud, that I don't think either of you in your proofs, but at some stage, one's got to presumably weigh Inspector Fagan's decision, or constituent parts of it, in the balance as well. And it's right, isn't it, in light of our discussion, there are parts, at least, of his decision which would, as material considerations, weigh against the grant of planning permission in this case. Is that fair?
Sorry, say that again?
Sorry, I'm putting to you that parts, at least, of Inspector Fagan's decision that we've traversed together as material considerations would weigh against the grant of planning permission in this case.
What, is there any specific parts, you say?
Yes. But I don't see what parts of his decision would weigh in favour as a material consideration. The parts that we've looked at, I'm putting to you, would weigh as a material consideration against the grant of planning permission in this case, wouldn't they?
In what sense? You know, there's obviously conclusions is reached in terms of contribution to Greenbelt purposes, which is relevant, appreciating it's pre-PPG, but you know, he's reached a view on strong, moderate, weak.
Good. Well, thank you, Mr. Allen. I can't resist just pointing out that you're using the appeal reference number from the previous Inspector Fagan inquiry on your proof. It's a cheap advocate's point. I could have done at the beginning.
Yeah,
I leave it to the end just as a matter of detail.
I picked up on a rebuttal. But
Thank you. Thank you very much for answering my question.
Mr. Beglin.
Yes, sir, we're at 5:15.
We are.
I think I'm owed some conditions on felling licences that I'd quite like to look at before I cross-examine this witness. Okay. And I'm conscious that I referred to some PPG guidance that, in fairness, this witness also ought to see before I start to ask him questions about it.
Okay. So essentially, we're to leave that till tomorrow then? Is that what you're telling me?
So yes, that was my long-winded way of suggesting that. I think that would also give me the opportunity to see where I still need to go in light of the time that Mr. Cosgrove has spent, and hopefully I can narrow things down.
Yep. Of course, now I'm quite happy with that. I think that's not unreasonable. I did have an expectation I would get through all of you, so that's fine. I'm happy to adjourn there. Get 9:30 tomorrow morning. Any particular housekeeping points for me then before we leave? I've got to go through, and it has now arrived in my inbox, the SIL statements and the like.
We've been trying to assemble people. From various messages, I think people are attending. Some people may be attending by Teams tomorrow to help you. Okay. I don't quite know which screen they're. I'm rather hoping it's not that screen, but I don't know quite know how. But we'll find out how that works overnight.
A big brother looming behind. That would be interesting. Okay, we'll work at the technicalities.
I don't know. Someone. Thank you, sir.
Okay, we'll adjourn then until 9:30 tomorrow morning. Thank you for your contribution. Thank you.